Good morning. It's the Fit Lawyer ATL, and we are live. Yes. Thank you for tuning in this morning for an episode of Legally Speaking with Fit. And we are here to go over the Karmelo Anthony motion for new trial. Okay. So we're going to get into this document. It was filed, I believe, July 7th, and it's 193 pages. While I posted that I was starting to read it on Wednesday, it took me a little while because I had court every day this week. So it was a lot to get into. The motion itself was only 63 pages, but the exhibits that attached to it ended up making it 193. So very long document, very interesting. So we're going to get into it. I made a Facebook post earlier this week about it. If you're new to the channel, hello, Lisa. Lisa J. Snipe. She says, "Good morning, everyone." Thank you, Lisa, first in the chat. So I'm a 20-year criminal defense attorney and personal injury attorney here in Atlanta, Georgia. I have my own practice, the Adams firm. And I was in court this week and just made a post on my Facebook that I was reviewing the new motion. And in that post, I'm going to pull it up so you all can see it. It ended up, I guess, getting into the Karmelo Anthony algorithm, and it ended up with like 4,500 comments. Oh my God. Like, I'm not sure what from the post made people feel like I was wanting Karmelo Anthony out of jail or that I was just a Karmelo Anthony supporter, but it brought out an entire group of people, some making intelligent comments back and some people making racist comments back. When I simply said that I was reviewing the motion, it was crazy. Welcome in Michelle Sizemore. Hey, friend, that's an old childhood friend from Birmingham. Shout out. Got Operations No Vote 4049. Good morning. The variant says the whole situation breaks my heart for both boys. Exactly right, right? That's been my kind of thing the whole time, that there were lessons that we could take away from this on both sides, right? Austin's side could take away that, you don't have to approach people in an aggressive manner, right? You don't put your hands on people, especially when they've done nothing physical to you, because you never know what their reaction would be, whether it's lawful or not. If it causes your death, it kind of doesn't matter, right? You're no longer here. Well, on Carmelo's side, like, I can't find anyone that's okay with you stabbing someone for simply being pushed, as that's what the evidence was presented at trial. So you have to respond to things accordingly, right? So there are lessons on both sides of this case, and the situation does break my heart as well for both boys and their families, because just because this motion for new trial has been filed, it doesn't mean that Karmelo Anthony automatically gets out of jail. Like, for some reason, that has been people's strong reaction to it, and that's just not how that works. Corporate America says, "Hey, Sora, it's been a minute." It has, because see, remember, I did a live the day the verdict came out, and we did verdict watch. And then I came back the next day after I had a chance to review the law of Texas on murder and self-defense, and did a whole live about the jury got it right. Because based on the evidence and the law, I think they did. Because one, Texas murder law doesn't require premeditation. And so it just required intent. And intent could be established by the fact that you intend to cause serious bodily injury, which is pretty much the only thing that you can do when you stab someone, right? And that you do something to someone's body that could cause the death, right? Which was be the stabbing. So under that law, whether I like it or not, I feel like the evidence presented at trial did. But we're going to find out today why the evidence presented at trial was what it was. Because a lot of us were like, why didn't the defense attorney do more? Why didn't he cross-examine the witnesses on the statements that we heard existed in the police report? We're going to find that out. And that's what I was so shocked about when I read this motion. Mr. Big Play Bray, good morning, everyone. Thank you for being here. Mindy Ann, one of my moderators, 44, says, "Hello, all. Thank you for being here, Mindy." No LA Girl for Life said, "It breaks my heart for Carmelo Anthony and his family." I think mine too, because it was just so many mistakes. They got bad advice from the beginning. Dominique Alexander, the convicted felon that was the family representative, I feel kind of led them astray. Some things early on that could have changed how this case went. So definitely for those reasons, I do, right? And their son took someone's life. Like, you never want that to be what occurs, right? But we never really saw that remorse from them. They've been kind of playing the victim role the whole time. And I think that's kind of what led to him ending up with the 35 years as well. No LA Girl for Life says stand your ground works for everyone, not just certain people. Free Karmelo. Well, was it a stand your ground situation? That wasn't presented in the evidence before, and we'll find out why we didn't hear from Karmelo, right? Because a lot of people were like, how is this a self-defense case and the defendant didn't testify? And a lot of times you don't want the defendant to testify. They're not attorneys. And no matter how much you prep some people, they're just not ready, right? Because you don't get to just get on the stand and tell your story. You have to be cross-examined. So we were all like, why didn't he testify? It must have been something they didn't want to come out. Well, they had a gentleman's agreement that they were going to try this case clean and that they were not going to bring in, bad fact evidence on either side against Austin and Hunter or Karmelo. And that agreement kind of is what made the case feel so dry from the defense. And then they get ready to have Karmelo testify and the state reneges on the deal, in my opinion. And so that's why Karmelo didn't testify, which is why we didn't get this whole self-defense in there. So the jury can only decide the verdict on what they hear. And it was very limited in this case. And you're going to find out why as we go through this motion. The variant, I know K.A. killed him, but I don't believe for a second he intended to kill him. I know he needs to be punished, but details matter, including his age. I don't believe anyone under 18 should be charged, probably is what they're trying to say. Thank you at the variance. And the right. So I agree. I don't believe that he intended to kill him, but the law says that's one way to prove intent. And then there's actually 3 ways in Texas. And so the second way is what I spoke of earlier, is that you don't have to intend to kill, but if you intend to cause serious bodily injury and you do an act that can cause the death, which stabbing can cause death, right? It did in this case. And if you stab someone, you have to know that it's going to cause serious bodily injury, right? That's kind of your intent in doing it. Like you felt justified in doing it, but that is kind of what the intent is. And that's what the jury found and how he was convicted. So I agree. I understand why people are upset on both sides. I get the emotion in the case, but it really comes down to the law. And that's what we do here. We just base it on the law, which is why you haven't seen me in a while, because I didn't want to get into the whole conspiracy theory. The video shows this is blurry, is grainy, is no, because guess what? All of that didn't matter at that point because the jury issued their verdict, right? It matters now with this motion for new trial because Karmelo's team is able to bring in evidence that was left out of the trial and that's not in the record. And that was really surprising to me as well, is why we don't have a record in this case. Shout out to Jay Witt Podcast in the building, listening in fit. If you all do not know who Jay Witt is, he has a podcast on YouTube and he talks about all kinds of things on his channel. He goes over legal things as well, as such as politics. And so go check him out. So if any of the moderators in the channel can drop Jay Witt's channel, I greatly appreciate it. Thank you. All right, so let me get started. So this motion for new trial was filed July 7th, 2026. And you all have been following this case. Karmelo Anthony was convicted of murder for the stabbing death of Austin Metcalf at a track meet that occurred April 2nd, 2025. The conviction was this year, I believe it was June 9th, and that gave the defense 30 days to file a motion for new trial. So a lot of people are really confused, like, oh, this is the appeal. The appeal courts get to decide. Why is there a motion to recuse? And it can be confusing because anything that occurs in a case after conviction is an appeal issue, correct? Right? Because it's post-conviction work. And so it's the appellate team. It's never going to be the actual trial team doing anything on the case post-conviction. Most times, I say about 90% of the time, unless it's a motion for reconsideration, just because you want to raise issues that things that happened at the trial were wrong. So in this case, we were all like, where's Mike Howard? Where's Mike Howard? Why haven't we heard from him? Well, he speaks in this motion. He has filed, I think it's like a 10-page affidavit, and we're going to go through it line by line because it really it answers all the questions that we've been asking. Like, why didn't Karmelo testify? Why wasn't this evidence that we have found out about the Metcalf twins introduced? Why weren't things that we heard about Karmelo? Was it true? Like, did it really exist? You're going to hear that the state served the defense with a 75-page notice of bad character evidence that they were going to enter against Karmelo at trial had there not been this gentleman's agreement. Like, what was in there? I can tell you one thing that I know is in there without even seeing it because it's in every criminal defense case: social media posts with a gun. Like, I don't know why these kids these days feel the need to post social media post with a gun. I'm not sure what it does. I mean, kids that don't even have, they are not about that life. You will still get a case and you'll get a secret Instagram account that nobody knew about, but it's connected to you because you got to log in with your phone number or your email address, right? So they can find it even if your parents don't know about it, even if you think it's private, even if you deleted it before you got arrested. They can do a deep dive on your phone and find it. There are always pictures, even from the girls. Like, it's amazing, but that's the thing. So I can guarantee you, at least on one of those 75 pages, that's what it was, right? But we have never heard any allegations of Karmelo using a gun to do anything, right? So was that so bad that they needed to make this gentleman's agreement to keep it out? The lead attorney is in the building. Shout out, lead. He says, a gentleman's agreement in a murder trial? Right. I was just so surprised. So, like, let me pull up my Facebook post because I want you all to see kind of what it sparked and the comments from there. Are actually already have it here. Okay, so I simply said, and where is, okay, hold on. I have a lot of things open here. I'm like, where is the Facebook posts? Oh, here we go. All right. So I said, in court reviewing this Karmelo Anthony motion for new trial while I wait. I am a 20-year criminal defense attorney. I had a case of my own in Henry County, Georgia, and this is where I was sitting as I was reading this document. This is the picture that accompanied it because as I read it, I was utterly shocked by some of the things that I read. And so I said, oh my God, oh, they did some dirty, dirty stuff. And I guess the dirty, dirty stuff is what brought out all the Austin supporters. I have no clue. It's over 4,500 comments on this post. I said, I don't have a crystal ball. Well, let me back up. So I said, oh, they did some dirty, dirty stuff. So what I was referring to was learning that, for one, this entire case file is sealed by the judge's own oral order and is still in his chambers today. Like, what? None of the case file has been filed into the public docket. So you can't just go to the courthouse and ask the clerk to give you the motion to suppress or this motion in limine or this. No, it's under judge's seal in his chambers. He did not release this document to the appeals attorneys when they requested it because he says he would only give it to them if they agreed not to disclose what was in the file. So because they couldn't, because they don't know what's in it yet, like I can't agree to something until I see it, he wouldn't give them the file. They could only view it in his office. I don't know about y'all. And if you don't know and you don't practice, I mean, I got a court reporter that I'm going to bring up in a second to just kind of speak to this issue, but that's not normal, okay? And then also I learned that there was this gentleman's agreement, as the lead just spoke about, that kept out bad facts about the twins. They agreed to keep it out about Karmelo as well. But when they get to the point of Karmelo testifying, the state says, oh no, we never anticipated the defendant testifying. Like, it's a self-defense case. How was the defendant not included in this agreement? Okay, so when they realized that was BS, they then moved to the argument that, the defense opened the door to carry to evidence when they said that Karmelo played chess. So deal's off the table. Like, what? Even the judge said that was not the case. He did not feel like that opened the door, but the state still said, Karmelo, you testify. We're going to bring in this evidence. They literally, so y'all remember that Monday when it was like this 2.5 hour break in the trial? This is what was going on during this time. Like, you'll read in the motion and in Mike Howard's affidavit how this actually led to a 10-minute shouting match in the judge's office, and the judge saying, okay, y'all just walk it off, cool down, we'll come back. Like, this was a very big deal because the entire defense was built on this gentleman's agreement. So when they're at voir dire, when they're questioning the prospective jurors and they're choosing a jury, they're operating under this agreement. When the state presents their witnesses, because they go first, and they're testifying to things that happened at the trial, and they're changing their testimony to what was actually in the police report and leaving things out, they're not cross-examining them on that because of this agreement. And then when Karmelo gets ready to testify, now the agreement no longer exists. So if he does, you got to hear about it. So that was jaw-dropping to me because that's not normal. And I feel like that is dirty, dirty stuff. Okay. And just the fact that the judge issued this order, kind of the gag order, sua sponte, like nobody, meaning on his own free will, not either side asked for a gag order to be put in place. There was no hearing to decide why a gag order needed to be issued. And this was done July 28th, 2025. And then come to the trial getting ready to start, and we have this this order saying the media can only be limited to 9. Legacy media, they're going to give the family. No, actually, it didn't even prescribe all of that, but it put in restrictions about what couldn't be allowed into the trial. So it set up a scene where only 27 to 32 members for the public were allowed into the trial. 9 legacy media members that they chose out of a group. When they offered everyone to apply, they ended up only choosing the media, the kind of in Texas that had already been covering cases from Collin counties. Those are the media that got the 9 passes. And then it was supposed to be 15 seats for the defense family and 15 seats for the state family. Room for a sketch artist, the court staff, and then 27 to 32 left for the public. The rule was that the public could enter 10 minutes before court started. But you're going to hear in the defense's motion that actually you had to get there like 4 a.m. to get in line. And I mean, it happens like that sometimes because I had to do that for the Diddy trial. When I went to the Diddy sentencing in New York, I had to hire a line sitter because I wasn't spending the night outside to get a seat, but I needed a seat. So it can be like that. But also in the Diddy trial, they had an overflow room, right? And this judge, while he had an overflow room for the first 2 days, which were jury selection, he closed the room with no hearing, no order being issued, no explanation why once testimony started. And the defense is raising issues with that. And whether you like it or not, the Sixth Amendment says that the defendant is due a public trial. And if there are restrictions put in place, there has to be rules that are followed. Okay. So all of that is in this order. But like, those are the things to me that I felt were like dirty things. So let me go back to the post. So, all right. So I say I don't have a crystal ball. And I also know motions for new trials almost never get granted because they don't. A lot of times the motion for new trial goes right back to the judge who just tried the case. And a lot of times they're not going to overrule themselves. But in this case, Karmelo had an extra argument. He filed a motion to recuse this judge because he went and did a news conference on the case after the verdict. Like he did a whole 18-minute, it's on YouTube, I have it pulled up. He did a whole interview speaking about the trial, saying that he agreed with the verdict, that the jury got it right, that he spoke about Karmelo's character. So the person who put a gag order in place July 28th, 2025, and said no one else with personal knowledge could speak to the public about any facts of this case, takes his butt onto the news and does a whole interview and writes a thank you letter, a 4-page thank you letter, like a love letter to Collin County and everyone who participated in making this trial, that he took 8 months to prepare, come off as a success. Like it was, you definitely are getting recused. Like you should, because you've issued an opinion about the case, right? You're no longer unbiased. You've said that you agree with the defense. I mean, the state. You say that the defense was wrong, that Karmelo's guilty. So how can you now, in an unbiased nature, review the motion for new trial? You can't. So that is why the defense has filed a motion to recuse. Okay. So we're going to go back to the post. And then I say secret hearings in chambers, because not only was this gentleman's agreement done in secret in chambers, but also motions for to suppress and motions to in limine were argued in chambers without a court reporter. So, I mean, if you don't know, but I guess really more, it kind of started before COVID, but more so now after COVID, every county pretty much in the United States does e-filing. It's electronic filing of motions, documents. You don't have to go down to the courthouse and stand in line anymore to file your documents. And in some courts, when you do, they make you sit at a computer and e-file it in person because that's the new system. Well, in this case, nothing was e-filed. As far as any motions in limine, motion to suppress, none of that. It was hand delivered and argued in judges' chambers without a court reporter. Like, what? So there's no record of what was done, which is why the defense's motion has so many affidavits attached to it, because there's no record. And if there is a record, we don't have it because the court reporters say they haven't started transcribing it yet. Like, what? Okay, so without further ado, I am going to bring up a court reporter that we're going to chat with briefly, just to kind of talk about the issues with this record and why the court reporter was left. Like, is that normal? Does that normally happen? And after that, we're going to go through this motion for new trial. All right, so let me bring up Quinicia Hill, who is a court reporter that I know from Fulton County Superior Court here in Atlanta, Georgia, which happens to be Georgia is the jurisdiction where the Supreme Court cases that they're arguing in this motion come from. So we are connected. So without further ado, Quinicia Hill, please introduce yourself to the channel.
Hi, Tiffany.
Hello, how you doing?
Hi, I'm wonderful. Thank you. Thank you for having me. Thank you for inviting me.
Thank you for agreeing last minute, because I'm literally, as I'm prepping the show yesterday, I'm sitting there and as I'm thinking about all this court reporter stuff and I'm arguing with people on Facebook under my post, I'm like, wait a minute, I know a court reporter. Let me see if she can come up. And you happen to be on Facebook when I inbox. And she's like, let me see if I can fit it in my schedule. And here you are. So you fit it in. So thank you so much for being here.
As a court reporter, I'm here to serve the public. So that includes you and your wonderful followers.
Thank you so much. So introduce yourself to the channel.
Okay, so my name is Quinicia Hill. I'm a nationally certified official court reporter. I was formerly a court reporter in Fulton County, but I'm now a federal official for the Southern District of Florida, aka Miami. I have been a court reporter for over 20 years. Same as Tiffany. Actually, I met her in the beginning stages of her career. So we're kind of like, starting out around the same time. Basically, my job in the courtroom is to be seen but not heard. And I make the official record of everything that goes on in the courtroom, from the speakers to the hums, the ha's, the ahs, the and everything else you can think of. I work with the attorneys, I work closely with the judges, and as a public servant for the courts, I'm here for the people.
Yes, thank you so much for your service and
Yes,
your
thank
continued
you.
service, because you're still working, as you stated. But like you said, yes, I was a public defender when I first started, and in Fulton County, and that was 2006 to 2014, and that's where I know Ms. Hill from. So that's our connection there. All right. So as I stated in my opening, kind of just going through the things that were jaw dropping to me. Have you ever seen a case where, I mean, we're over a month now after the trial the verdict has been rendered, and the file is still under seal in the judge's chambers, and nothing's on the public docket?
Yes. So the short answer, which we as court reporters really like, is no. There has never been a case that I have personally been a part of that the entire record is sealed from the public, from even the attorneys. That is totally unheard of. As a court reporter, we create the record. Now, there are some things that are done in camera, even ex parte, but even those are reported by the court reporter because it is a part of the record. It may be sealed, that portion, but when you say an entire trial, no.
You also heard me mention that in this case, there were documents that were hand delivered. They were not e-filed, so they weren't made part of the public docket. And the hearings for those motions were actually in the judge's chambers. Now, have you ever been a part of those before as a court reporter? Have you been in chambers when there have been secret hearings?
So, yes. Now, secret hearings, it's not secret type thing.
So
but now there have been situations where I have been a part of an in-camera hearing, produced a transcript from it, hand delivered it to the clerk's office because it is sealed and it has to be open under the order of the court. But again, for an entire trial, no. An entire trial is a public record. The public is entitled to attend a trial, be, able to view all proceedings. So for a trial transcript to be sealed totally is very unusual, very out of the norm. When I was in Fulton County, I worked for a judge in Superior Court. That judge had a saying: out loud on the record, meaning that she would never conduct a hearing outside of the presence of the defendant, outside of the presence of the prosecutor or the plaintiff, outside of the presence of the defense attorney.
Yes. Because
So,
you're creating a record, because if
yes.
something's done in your, like, say, superior court, and I want to appeal it, in order to take it up to the appeals court, I need to produce the transcripts and the record. And I wanted to go back and clarify. You said the transcripts are under seal, but get this, the transcripts haven't even been started. The court reporters have not started transcribing this case. So it's just the docket in the sense of whatever motions the parties filed, whatever
Right.
the judge's rulings were. Those are the things that are sitting in his chambers, because the transcript has not a day of this trial, not jury selection, not any of the motion hearings, anything has been transcribed to date. Is that
Okay.
normal? Have you ever seen that?
Okay. So let me just touch on that. I saw a comment on social media, so I do want to address that part. Transcript production is not free. Okay. There's a cost associated with producing a transcript. As a court reporter, we are there at the behest of the court, at the pleasure of the court. We are there when the court says, I need a record. So my position, I show up to make that record. However, that record has to be produced. That record is produced on my personal time. So therefore, I have to be paid for my services. I am bound to the court during court hours, Monday through Friday, 9 to 5. Transcripts are produced by a court reporter outside of those times, and therefore that court reporter has to be paid for his or her time. So to come back to your question about the transcript being produced, and that post that I saw, oh, the transcript costs tens of thousands of dollars, whatever the dollar amount is. That has to be taken care of before that court reporter begins production on it, because the court reporter is not just a person, but we are also a business. So therefore, we employ people. Those people have to be paid. So that's the answer to your question. So
Okay.
if the transcript has not been produced, either they have not officially ordered and paid the court reporter to do it, or because of the circumstances going on, the judge has probably ordered the court reporter, don't produce that transcript.
Yeah. That's
So
what I
it could be one of those two things.
Mhm. Because the case file is still under seal, and he wouldn't
Yes.
release it to the actual appeal attorneys. The attorneys that have filed an entry of appearance and are representing Karmelo could not get the file or the transcripts. They couldn't. They wanted the transcript, because of course you want to go to the transcript in the motion for new trial, because that's how you can find each and every error. They weren't able to do that because the judge is not allowing it to be produced. He is keeping this file under seal. So that's just not normal. And so you spoke about in camera, and I want to explain to the channel what that is. So in camera, usually, what is that? I know what it means. Just tell the
So
channel what it means.
in camera means outside of the public hearing. So an in camera hearing is only done when it's the judge, the parties to the case. Now that judge may close off the courtroom and not allow anyone outside of the parties to the case in the courtroom to hear it, or he or she may hold that hearing in their chambers, in their office, hence making it in camera.
Okay.
A Latin word, you have to look it up.
I know a lot of Latin in legalese. Now, in camera, a lot of times when I deal with those, it's in like child molestation cases or something like that, a victim, like 6 years old, 7-year-old, that they want to have testified or interviewed by the judge. And so, of course, you don't want that done in public, right? So that'll be done
Right.
in camera. Or I know sometimes the judge will review defects records, or about a child school or something like that in camera first before they decide to release them to either party. And sometimes we'll have to sign a production, not a production order, protective order before we can
Right.
get documents saying that we won't disclose them to anyone but experts or something like that to help the trial, which is something the judge could have done in this case, right? He could have issued a protective order if he wanted the case file not to be leaked to the public. He could have asked the attorneys to sign that. But tell me what other type of in-camera hearings that you've been a part of that you see in this trial.
Oh, yeah, in-camera hearings can run the gamut. Literally, like you said, in family cases, child custody cases. The reason I got into this field is mainly because I used to watch this show called Divorce Court. It was a full-on case, and when they had children involved, the judge will always speak with the children in camera. And no one was allowed to go into that in-camera hearing but the judge, the children, and the court reporter, who is the keeper of the record. And everybody always wants to know, well, what did the kid actually say? Well, I have full insight. I get to sit in and find out. So that's just part of it. I have sat through many in-camera hearings. A lot of my hearings, though, are held in the open court, but with only the parties to the case involved. That ranges from snitch testimony, you know.
Okay.
That ranges from I have a patent on a pharmaceutical company. And they don't want it public, but they are making a record because perhaps they're being sued for taking somebody's idea, or they have to put that on the record, or they want to make a record of it so that they can have it for down the road litigation that may or may not come. It's just so many reasons for hearings to be held in camera. Those are sealed. If the transcript is requested, it's produced and produced under seal, only to be opened by a court order. Now, in this case, and I'm just jumping ahead, thinking ahead out the box. In this case, with the transcript, it's gonna have to eventually be produced because Mr. Anthony is part of his appellate rights. The transcript has to go up. Right. My thinking is this judge is probably gonna be recused, and then the next judge sitting on the case will then open the record.
Yeah, I agree. And we're going to talk about that in this live about the motion to recuse and kind of why it's really favorable in this case to be heard. So before I let you go, because I know you got to go.
Yes.
One more question. Talk about, like, there has been cases, I know, like the Diddy case, right? A transcript produced of whatever hearings or whatever was happening daily. And so do you see that in trials? And what's the typical time frame after, I know you said first y'all got to get paid, but let's say I ordered the transcript the day the trial ended. What's the typical timeline that I could expect that trial transcript to be ready?
Oh, okay. So it just depends really on what court you're dealing with. Court reporters are employed in lower courts all the way to federal court to the congressional floor. Right now, for us in the federal judiciary, transcript production can be anywhere from immediate to 30 days. So sitting here in the federal judiciary, I do daily copy, high profile trials almost every month or so.
And daily copy is meaning that you're producing the transcript every day.
Yes. So I offer real time. So what I do is I connect the attorneys to my iPad, and they can be in the room in any part of the world. I offer them a real time production, and they get the proceedings as they're happening in a rough format. And then after that, I go home, produce this transcript with the help of what I call my steno L's. That's another conversation for another day. But my steno L's sit in the background somewhere in the world, and they work on this transcript with me so that I can have it ready by the next morning before court starts. That is what is called a daily copy transcript.
Okay, so y'all heard it here. So you either trials that have daily copies, meaning the transcripts are produced daily, or like you said, in federal court, it's a 30-day deadline. So this is a federal case, we're past that deadline. Like, this is not normal procedure to have this high profile case with because a notice of appeal to the appeal court was filed literally the day the verdict came in, because so that lets the court reporter know this case is going up on appeal.
Right.
So when you get that kind of notice, do you go ahead and start on your transcript?
No, you once you get notice, even if the verdict is guilty or whatever. Now, I don't think this was a federal. Was
No,
it?
it's not
No,
federal.
okay.
No,
This
it's
wasn't federal.
Texas.
Even still, once we get notification that the transcript is requested, we go through a whole process of getting that set up. We give our time constraints and everything. In the lower courts, that time can be 6 months.
Okay.
It just depends on which court.
Okay.
Yeah.
Okay.
But in federal court, when we do high profile cases, we know in advance that it's going to be a daily copy trial, and we set up and get prepared for that.
Okay. Well, thank you so much for providing your insight. Is
Oh,
there
you're
a way that
welcome.
any information you can provide if people in Florida, Miami area need to hire you personally, or like, can you do something
So,
offer?
because I am a federal judiciary court reporter, I do not do independent work.
Okay.
However, they can reach out to the National Court Reporter Association, which keeps a listing of nationally certified court reporters to hire. And as well, most states have an association of court reporters. Georgia, which is where I'm from, born and raised, Italian. Georgia has a Georgia Board of Court Reporters.
Okay.
And if you are looking for a court reporter, please feel free to go to the boards, the state boards, and we are all listed there.
Okay, thank you for that.
Yes.
Well, thank you so much for joining us. I really appreciate your insight. So people know, like, I'm not just saying something, making it up. Like, you really hear from people who've been in the industry for over 20 years. They work as a court reporter every day in federal court, started out in Fulton County, Georgia, and as a court reporter. So you've seen all types of cases, and this just some stuff in this case that's just not normal. Like, you don't have a court reporter. You have one all the time, if it's in chambers or in camera, because you're so thank
Absolutely.
you.
Oh, thank you for having me. So
Yes.
So everybody know we are here. Again,
Yes.
we here to serve the public. And yes, make sure you hug a court reporter.
Yes, because they got all the tea now. Okay, so anything we're
All the
speaking
tea.
about, they got all the tea. Thank you so much.
Have a good one.
Thank you. So yeah, y'all heard here. So my mouth is jaw dropping because this is not normal things. Like, this case is still under seal in the judge's office. So without further ado, we're going to get into this motion for new trial, because I really want you all to see what the defense's arguments are, right? So as I stated in my Facebook post, and let me just, before I leave it, bring this back up, is that, this is not about guilt or innocence, right? So this is about fairness and justice. That is all that a motion for new trial about. It's about, was something legally fair? This is not about Karmelo being under the tent, if there were other people, if it was his knife, or was it Hunter's knife? Was it this? Like, y'all see the comments are still coming on this post. They were so mad. So let's look at a few comments, and then we'll get into the motion, but this kind of gets you knowing like what's going on in this motion. So, okay, we're getting past the supportive posts. My people were coming in here like, wait a minute. You must be reading super secret papers that didn't get released by the people that I have heard it and come to a completely different understanding. Nothing in there is grounds for a new trial. We have been getting a laugh about it at work. This person says they work at a law office. And what's funny about it is the very first argument that the defense raises is literally about the trial not being public. And so, no, it's not about whether the door was open, did some of the public come in? No, it's saying that, and we'll get into the law, that if there are any restrictions that are put in place, they have to follow standards that come from the U.S. Supreme Court in Waller versus Georgia and Presley versus Georgia, which are Georgia cases. And we're going to pull those up because show you kind of what lawyers do. Because we go to law school, all we're doing is reading and briefing cases, because that is what determines how the law that is written by the legislature is actually applied in real life. Okay, so without further ado, let me pull up the motion and we're going to get into it. So, sorry, let me stop sharing. Okay, share screen. All right, here we go. All right. Come on. Okay, so I'm going to make it bigger. Give me 2 seconds. And then we will get. Now, this motion is, as I stated, 193 pages. We're not going to do that. Fit doesn't have that, okay? I think Nika at night was covering this and she read like every line, and it was like she was on live for like 8 hours. I was like, oh yeah, I don't have that. So we are going to read, though, line by line, the introduction and the factual background on it, because the facts matter, right? So what the defense is basing their motion on, we're going to get into that. But then I'm going to kind of summarize for you what their legal arguments are, and we'll discuss them. And this motion was prepared very well. He has an amazing legal team. I can just tell by the detail that they put into this motion that they are very thorough. They actually pull up cases that the state possibly could argue, and they show how those don't apply. They actually do graphs within the motion and kind of break down what was in this case, what's not in this case. I mean, it was very, very well written. Seen a lot of motions, and this was a very good one. And so we're going to get into that, and we're going to talk about there are 4 grounds that they are raising in this motion that they believe will allow Karmelo Anthony to get a new trial. One is that the trial was not public. They say that the restrictions that the judge issued weren't following the Waller and Presley standards. They also say that the gentleman's agreement that the parties reached, the state reneged on it before Karmelo got ready to testify, and that coerced his testimony. They also raised the issue of that all of these errors were a collective that damaged the fairness of the case. And let me go back up. The first grounds, saying that the trial wasn't public, if they're right on that argument, the law has already said that the only thing that they can do is redo the trial. So this is not an issue of like, was Karmelo really guilty? Does the court have to look at that? Not when it comes to the public trial argument. Their harmless error standard doesn't apply. And Karmelo doesn't have to prove that he was prejudiced by these restrictions that were placed on the court. Although he does show that grandparents and aunts didn't have room, could not get admitted, because instead of the 15 seats they said the family was going to get, they actually only got 8. So he talks about that, but he doesn't have to prove that. We're going to get into what he does have to prove, and there's some argument or not of whether this is timely, whether his defense attorney made objection to it at the right time. Is the issue preserved? But if was the 5th week, but if all things line up and his defense attorneys are right in their argument, what the judge has to do is overturn the conviction and you get a new trial. And people are like, he's going to get a new trial, he gets more time. The new trial will look very different than the trial that we've seen. There will be no gentleman's agreement. Okay? If the new trial happens, if it actually goes to a new trial, meaning, the new trial is granted, the conviction's overturned, it doesn't mean that there has to be a new trial. Sometimes you end up just getting a plea because either side is like, look, we don't feel like doing that again. The judge talks about in his interview on TV, it took him 8 months to get this case, the county, the security ready for this trial. You better believe it's going to take 12 months to get this case ready the next time, because it has even more national attention. And so it's going to be more, does somebody want to go through that, right? And so sometimes that can work out a plea deal and there might not even be another trial. I will tell you what happened if the conviction is overturned. Karmelo goes home for a minute because he was out on bond prior to being taken into custody after the verdict. So he would go back on his bond prior to, while what they're deciding whatever's going to happen with the case. But the issue is, was it timely? If this motion goes forward on that issue, it's automatically overturned. Ground 3 was the provocation issue. So in the jury charges, and we'll go over that, the judge gave this provocation argument, stating that basically if you feel like Karmelo was the aggressor because he, and I mean, what could they infer from the evidence caused him to be the aggressor? Because he wasn't the physical aggressor. They're saying like sitting there when you're asked to leave and not leaving, or, remaining in the tent and saying, hit me, touch me and see what happens. If you find that made him the initial aggressor, then he can't argue self-defense anyway. So you don't even get to consider the self-defense argument if the state proved beyond a reasonable doubt it didn't exist, because if you find he's the primary aggressor, you don't get to argue. So they're saying that was wrong, that there wasn't evidence there that allowed the judge to give this charge. And then ground 4 is just saying the cumulative effect of all of these errors is enough that this isn't fair. So it needs to be granted a motion for new trial. And in accompanying this motion for new trial, they filed a motion to recuse Judge Roach, which honestly, y'all, I've been practicing 20 years, and everybody knows a case isn't final until it's final, right? And so a judge really shouldn't speak on anything until something is out of their jurisdiction, right? And when you appeal something, it could be overturned or remanded back to you. So you don't go on TV giving a interview about a case. I don't know if I was in high school when OJ went to trial, so don't hold me to any of this. But I don't recall if the judge gave an interview. I remember interviews happening on that case, but by that time they did, I was an adult. Like, I'm grown, I'm paying attention. So it was years after the case that the judge, I don't even know if a judge ever gave an interview, but it would need to be well after you would ever do anything on the case, right? You can't speak about this case publicly, give your opinion on the verdict, and then think you get to rule on something that's coming back before you. So I think the motion for motion for him to be recused should be granted. What's happened so far is, and it's the same practice here in Georgia, because we just filed one in the YSL case that we're working on. And so you file it, the judge who receives it or who's it's against reviews it and determines whether or not it's timely, whether or not an affidavit that was attached to it makes an argument that if somebody read it, they could deem it as biased, possibly. So it may give an appearance. So you need to, a hearing needs to occur, and you can't rule that type of hearing on yourself. So you always have to then refer it over to another judge. So that's what's happened in this case. Judge Roach could have recused himself once the motion was filed, and it wouldn't have meant anything. The law says that the judge that is filed against can simply sign an order recusing themselves, and they're not admitting that they are biased or that they aren't speaking to the facts of it. You're just simply removing yourself from the case. You're just, you're saying that the motion was timely, that someone could read this and could see that you are biased or could have that feeling. It gives this appearance possibly. So I'm just going to take myself out of it. But me taking myself out doesn't mean I necessarily agree the motion would be granted or not. I'm just going to remove myself. He could have simply done that. He is going to retire. He's already announced his retirement. He's leaving the end of December. So he could have simply recused himself, or you refer it to another judge, and that's what he's done. So that another judge will decide this motion to recuse Judge Roach. But what is a bigger issue and what is pending is the motion for new trial. In Texas appeal law, which I have pulled up and reviewed, and we can look at it later, states that this motion for new trial has to be decided within 75 days or is denied. So while it's a bombshell motion, the defense raises amazing arguments. We could get to a point where this is never heard in court. They have asked for a hearing on this to be granted by, I think, the end of August, and the 75 days is September 21st. So the state they don't have to respond, but I would think with the allegations that are in this motion and the affidavits from Mike Howard that they probably want to respond because they want to put their side of it on the record, because this is going to become a part of the official record and go up for appeal. So I would think as the state, they're forming their motion to respond, and usually those responses are due within 30 days after the motion itself is filed. And then that, we'll be back, right? Because we'll review their argument. I could read their argument and say, oh my God, I can't believe that the defense did this. It could be something in their motion. They're going to have case law that they're going to cite as well. So after that is done, so stuff is going on, right? Because you got the motion to recuse. So that is going to be decided by a judge, and they're asking an interim judge to be appointed to decide this motion for new trial so that the time doesn't run out while they're doing this motion for recuse. So it's a lot going on. And this is what you do when you're a criminal defense attorney. At all times in a case, you're looking for a needle in a haystack, okay? So you're digging for whatever you can find. So you're going to throw everything you can at the kitchen sink. You're going to put it all in a motion. You start with your best argument. The public trial argument is pretty strong. Is 48 pages of the 63 that consist of the motion. And then you drift in your second best argument, your third best argument. And so we're going to pull that up and get started going through that motion so we can see what the defense is arguing. Let me hit the chat. Y'all still with me? All right, we got 82 in here. Make sure you're liking the live. If you can bag out of the big screen or so and hit the like button to come back. into the chat. You can share the live so that we get into the algorithm. I have no clue how I ended up in the Facebook algorithm on this case, but it did. So get us into the YouTube algorithm on this so people can see, because it's all about the legalese. This is all that a motion for new trial is about. Okay, it's not about anything about the videos or anybody's opinion about that. So let me pull that back up so I can read along with you all. These different screens. Oh, it's actually over here. Sorry, let me pull this over. See? Oh, okay, hold on. I didn't share what I'm looking at. Let me see. Okay, there we go. All right, let me make this bigger and we'll get started. All these spam calls come through all day long. All right. So clear up confusion of where this document has been filed. Okay, you all can see this, right? So this was filed July 7, 2026, 11:41 a.m. Michael Good is the district court clerk of Collin County, Texas. And this is the deputy that stamped this in. So for all people confused, this was not filed in the Texas Court of Appeals. This was filed in the District Court of Collin County, which is the same court that decided the trial. That is where you start when you are doing post-conviction work on a case. Every case that is a verdict comes down in that's guilty, the defendant has 30 days to file a motion for new trial. That is always filed back before the same judge that hears the case in the trial. Not often, but sometimes you accompany that with a motion to recuse if that judge has done something to show himself biased. None of the defense's arguments for bias has anything to do with the jury's verdict. It is only the fact that Judge Roach took himself on TV and gave an interview and issued statements in that interview that shows that he has a bias to this case now. Not saying that he had one at the time the trial existed. The defense is arguing he has a bias now. So because of that, they don't want him deciding the motion for new trial, which speaks to how he behaved in the underlying case because they feel he has a bias. All right. So that is what this document is. It is Karmelo, once he was convicted, did file a notice of appeal with the Texas Appeal Court, and they will file an appeal, but that brief is not due yet. They have kept asking for extensions. First, they need a transcript and a complete record to send that up. So that's why you have this motion for new trial pending in the same court. That's how it is in Georgia. That's how it is in every court. Okay, so have that understanding. It's done by his appeal team, but it's filed in Collin County District Court. All right, so this is the motion for new trial. They cite the Texas Rule of Appellate Procedure that allows for this motion to be filed. That document is here. I pulled that up as well. And let me close this. This outlines the rules that have to occur when you do a motion for new trial, okay? And so it talks about a motion for new trial. The grounds that it can be filed on is when the court has misdirected the jury about the law or has committed some other material error likely to injure the defendant's rights. What else is important for this? The defendant may file a motion for new trial before, but not later than 30 days after the date when the trial court imposes or suspends sentence. So he got sentenced June 9th. This was due by July 9th. It was filed July 7th. The state may oppose in writing the defendant's motion. That's what this says. The defendant must present the motion to the trial court within 10 days unless the court grants discretion for later, but that doesn't matter. They did it before 10 days. They have already submitted it to Judge Roach. The time to rule. The court must rule on this motion within 75 days after imposing a sentence in open court. So that date would be September 21st, which is 75 days from July 7th when this motion was filed. In ruling on a motion for new trial, the court may make oral or written findings. So the decision could be made orally or written down, either one. The granting of a motion for new trial must be accomplished by written order. However, it says granted for a new trial, must be accomplished by written order. So if the judge grants a new trial, he's going to have to write an order, put a finding of facts why he's granting that motion for new trial. A docket entry does not constitute a written order. So it actually has to be a document that has finding of facts, okay? Because the appeal court, when they review the record, they have to know why this judge made this decision in order for them to rule on whether the decision was right or not. That's what we're experiencing in the YSL appeal that we filed for Antonio Sledge. We got the response from the court on June 18th. They remanded the case back to the trial court because they said the judge did not put a finding of facts in her order as to why she agreed that his sentence was void. So because there are no findings there, the court can't make a ruling on whether the findings were correct. So the judge has to do that. So that is why if you don't have a finding of facts, the case comes back down. All right. A court must grant a new trial when it has found a meritorious ground for new trial, but a court must grant only a new trial on punishment when the issue affected only punishment. Okay. What Carmelo's argument is affecting the entire trial. Granting a new trial restores the case to its position before the formal trial, including at any party's option, all the way back to arraignment. So this case could start all the way over back at arraignment, but the defendant will return to where he was at the time the conviction was overturned, which would be on bond. Let's see. A finding or a verdict of guilt in the formal trial must not be regarded as a presumption of guilt, nor may it be alluded to in the presence of the jury that hears the case on retrial. So a lot of people have been online like, oh, Karmelo could come back and get 99 years this time. And it's like, okay, the jury that is going to be new and sitting down will never know that a prior trial existed. How will they find a jury in Collin County that won't know that this trial existed? Probably won't. So if he gets a new trial, it's going to have to change venues. But where will it go? I don't know. That is how you get to he could get a new trial and this could end in a plea deal, because who wants to go through all of that? So, this is going to be a fight, which I think is why the state will respond to this motion, because as you see, if this goes for a motion for new trial, you don't get to get up before the new jury and say, hey, we're here to redo this. He was already found guilty. No, you start from scratch and the jury gets to know nothing about that. So you got to find people that don't know about this case. And while everyone feels like everyone in the world knows about this case, no, there are people that don't. So you sit those people and they hear it like it's for the first time. It's fresh. So it's a whole new case and there will be no gentleman's agreement, right? So all the facts get to come in. So that is what they're fighting to have happen in this case. All right. So when I tell you we're legally speaking over here, we're going through, this is from the Texas Rules of Appellate Procedure. We're pulling it up. We're going through the law. We're not, it's no hypotheticals, no games. All right. So back to the motion. So that's the law that they are allowing them to file this motion. So here's the introduction here. I just talk about, the case. It says this case presents a structural public trial violation. The court had authority to manage courtroom security, decorum, and capacity. But once it adopted and administered restrictions that foreseeably excluded members of the public from a high-profile criminal trial, it was required to make record-supported findings and to consider reasonable alternatives to closure. This requirement, y'all, that they just spoke about comes from case law from the Supreme Court we're going to get into, but this is what the court was required. So this isn't how the defense feels. This is what the law says was required. What the argument is did the judge, did these things exist in this case or did they not? That's what the fight is about. But the law is the law. This is what's required. So it's required to make record-supported findings and to consider reasonable alternatives to the closure. The court did neither. That's the defense argument. They say the access regime limited public attendance to a narrow daily admission period, a small number of seats, and no continuing overflow or audio or video access after jury selection, because that closure affected the trial proceedings themselves. And for the 3 additional grounds set out in this motion, defendant asks the court to set aside the judgment and grant a new trial. All right, so we about to get into it. All right, so we got 188 in the chat. 100 people just popped in on us. Make sure you all continue to share the live. We are getting into the facts factual background of this motion for new trial. If you're just tuning in, you got to go back and start over because you got to hear we had a great court reporter talking about all the anomalies that exist in this trial with the file is still in the judge's chambers, has not been admitted to the court docket. Luckily, we got this, right? Luckily, we were able to see this motion for new trial because his defense team released it, but it definitely, the file is still under seal. All right, so the factual background. The case and the verdict. This case arises from an altercation at a high school track meet. The defendant, Karmelo Anthony, was charged by indictment with the murder of Austin Metcalf, alleged to have been committed on or about April 2nd, 2025 in Collin County, Texas. The defendant pleaded not guilty. His defense at trial was self-defense, that he used force he reasonably believed immediately necessary to protect himself. The court's charge, which is the jury charge, submitted the offense of murder, the lesser included offense of manslaughter, and the law of self-defense, including the justified use of deadly force. The defendant did not testify. On June 9, 2026, the jury found the defendant guilty of murder, and the court imposed a sentence of 35 years confinement. These matters appear from the indictment, the court's written charge, and the judgment. The case drew national attention from the outset, and the court appointed a public information officer to assist with media credentialing, communications, and access logistics. In practice, public and media access were administered through that process. What follows is how that access was in fact administered before trial, at the perimeter of the courthouse campus, at the courtroom door, and after the verdict. Secrecy before trial, the gag order, chambers conferences, and no public pretrial hearing. Sorry, just keeping up with y'all in the chat. All right, so shout out YSL Kel says only 50% of y'all have hit the like button. Let's get it up there, gang. I don't want to have to be like lead and shut down the chat. No, I'm just playing. All right, so actually, let me go to this screen, right? All right, so the closing of this prosecution to public view began more than 10 months before trial. On July 28, 2025, acting sui sponte, meaning on his own free will, and on no party's motion, the court, which is the judge, entered an order prohibiting extrajudicial statements, a gag order binding the parties, their attorneys, witnesses, law enforcement personnel, courthouse and court staff, and court-appointed officials, which by its terms remained in force through trial. That's on Exhibit 1 attachment. Exhibit 2, we're going to look at that. Covered persons with firsthand knowledge were restricted from speaking publicly about the facts, evidence, witnesses, and expected testimony absent written approval from the court. So once this gag order was put into place, nobody was speaking. So, this happened April 2nd, May, June, July, 3.5 months later, this gag order is put in. So we're not able to hear from anybody. So that's why we haven't heard, the attorneys going on TV, doing interviews or any of that. The judge says he didn't want, any of the potential jurors or anything to be swayed by public opinion. So he wanted everybody to stay quiet on this case. What is, I guess, funny about that is that the fact that he went and did a whole interview about this trial after, but there was a gag order that he issued. Number 5 says the gag order's terms were sweeping. Unless first approved in writing by the court, no covered person could make any extrajudicial statement that addresses the character, credibility, expected testimony, guilt or innocence of any party or witness that discusses evidence anticipated to be introduced at trial, or that intends or is likely to influence public opinion or potential jurors. Restrictions expressly applicable to any public medium, including traditional news outlets and social media, and enforceable by contempt, fines, attorney discipline, and other remedies. So that is what would happen if anyone violated this order. And this goes on to talk that nobody violated the order. So that's not an issue. Its findings were 3 sentences. These are the findings that are part of this attached order is Exhibit 1. This is what they say in the order. that media coverage has the potential to cause imminent and irreparable harm to the defendant's right to a fair trial, that alternative measures such as venue change, juror screening, sequestration would be inadequate alone, and that narrowly applied speech restrictions are necessary to protect juror impartiality. No evidence is recited. What they're saying is that in this order, because there was no hearing, okay? The judge issued this order on his own. So there's no evidence listed, like what evidence was presented by the parties that led you to come to this conclusion. The defense is saying there is no evidence recited because there was no hearing. The order permitted only procedural announcements like hearing schedules, court filings, and statements required by legal or ethical duty, a safe harbor that presupposed filings the public could see. So basically the judge, yes, you all can get the court notices, know when the court dates are, know when the hearings are, but everything else, you can't know about. By its terms, it would yield only to further written order of this court, and the amended order later reaffirmed it until the completion of the trial. So basically they're saying the first order said this is in place until my further order, and the amended order said this is in place until completion of the trial. Well, the trial's over now, so why does a judge still feel the need to seal the entire case file in his office? I don't know. It goes on to say in the 10 months it operated, and it is the first order that was put in place, Exhibit 1. No person was ever alleged to have violated it so far as the public record reflects. Number 6, the substantive pretrial work of the case was then conducted out of public view. The parties' pretrial conferences with the court, including a May 21st, 2026 conference in chambers at which the parties' evidentiary understanding was described to the court, and a May 29, 2026 meeting addressing trial security and scheduling occurred in chambers outside of open court. No reporter's record of them exists. A matter the hearing will confirm. The hearing they're requesting a hearing with this motion. So they're saying when they have this hearing, you can confirm that there's no reporter's record that exists, no court reporter's transcript of these hearings. No pretrial hearing was ever held on the access restrictions, and the register of action reflects no such setting. The public docket discloses no motions in limine and none of the substantive pretrial litigation that in fact occurred. Filings that were hand-delivered rather than filed in the district clerk's public record. A member of the public who examined the docket before trial would have found no hearing to attend and nothing to read. Now, this is important because when I did my live on the trial and how the jury got it right, part of that was going through the court docket. And I was like, well, it doesn't say that the defense attorney filed any motions. Like, how could he not file any motions? There's no motion to suppress, no motions in limine. Like, there's nothing on the docket. Was there a hearing? Nothing. You could only see subpoenas being issued and the court dates. And Dennis Byron came up on the show that day and he said, I've spoken to people in the clerk's office and they've informed me that there are motions, but the judge is keeping it all secret. And now we know what he was talking about. These hearings that are always public, y'all. I was in a pretrial hearing Wednesday when I was reading this motion. I had a pretrial hearing Thursday in Gwinnett County. I have a pretrial hearing on Monday in Fulton County on a case. Like, there are public hearings. Everybody who's on the calendar is in the hearing, and all the attorneys, the courtrooms are open to the public. And we discuss matters about the case. Judge, are there any outstanding motions that we need to have a hearing on? Yes, Judge. And then we get a date for those motions, and they're done in court. Now, you heard from the court reporter earlier that there are some times when stuff is done in camera, not in public record. However, there's always a court reporter, right? So there's always somebody to take everything down. Hell, sometimes I'm asking so many questions, I don't remember what the last question was, right? Someone objects, the judge says, overruled or sustained. Ms. Adams, rephrase your question. Judge, what was the question? Right? Because we went back and forth on the objection. I forgot what I asked. Madam Court Reporter, what was the last question? The court reporter is there for a reason, to keep a record. So the fact that these hearings happened in chambers outside of open court where no court reporter record exists, it's a problem. It's a problem. All right. So the amended order, the written term of access. So the court, this is still the defense motion. This is number 7 in the factual background. On May 18, 2026, the court signed the amended order regulating trial proceedings, media access, security, and courtroom decorum, entered to govern all aspects of the trial proceedings. The order recited the directives of Waller versus Georgia and Shepard v. Maxwell, found that unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial, and it promised reasonable access, public access, consistent with constitutional requirements. So the defense is right. This is still the defense's motion here. And they're referencing the judge's order to keep, only 9 media in, 15 defendant seats, 15 state seats, sketch artists, court staff, and then 27 to 32 seats open for the public. But you'll hear that those constraints of how it was ran, that wasn't in the order. That is what the public information officer came up with, is how they were going to administer the judge's order. And so that is also going to be raised as an issue in this case. Number 8, its operative terms were these, and this is the order keeping everybody out, or not everybody out. Let me rephrase that. Strike that from the record. It's just the order that limited public access. Let me say that. Its operative terms were these. The courtroom would open at 8:30 a.m. for the media, at 8:40 a.m. for designated family members, and at 8:50 a.m. for the general public. No more than 9 members of the media would be admitted. Seating would be on a space available basis. The doors would close promptly at 9 a.m. Individuals arriving after that time would not be admitted until a recess, and no person who left court could re-enter except at a recess. All persons attending were required to dress in appropriate business attire. Hats and caps were prohibited, and clothing or items displaying messages, logos, symbols, or images related to the case or otherwise distracting or potentially prejudicial were banned. The order appointed Steve Stoller, identified in the order only by a personal email address and cell phone number, as the court-appointed public information officer, committed media credentialing to that office, and announced that the court will not intervene in or resolve disputes among members of the media regarding access or seating. The order contains no provision for an overflow room, an audio feed, a video feed, or any other means of observation for members of the public turned away, and no mechanism by which a member of the public could be heard to object to any of it. Now, the mechanism to object is not what is required by the law, and we'll get into Waller and Presley that goes over what is required, but they are saying that these are the restrictions that were in place. So the judge gave times that people could enter, and you couldn't leave out once you came in, and how you had to dress. And you can hear that and you can say, well, that sounds pretty reasonable to me. Like what's wrong with this? And we're going to get into that. But I can say I attended the Diddy trial for sentencing, and there were restrictions there as well. However, in that case, they had a hearing, and there were alternatives that were considered by the court and put in place in that case. I mean, Diddy's trial was way bigger than Karmelo Anthony's. Let's just be clear, right? Diddy's known worldwide. And so in that case, the judge recognized, one, you couldn't bring in cameras and all that because it was federal court. But thank you, Kia Elders. She is showing you all how you can support the channel. Shout out Maude in the house. I appreciate that. But in Diddy's case, so it's public, right? So there's a lot of people that want to come in. They had a public information officer just like they had in this case. And so that courtroom was much bigger than this Collin County's courtroom because Judge Roach said he only had 70 seats. But I would say it was probably, I don't know, maybe 100 seats. Let's say it's 100 seats in the Diddy hearing. Or maybe 150. I can't look, I'm not good at like looking and guesstimating numbers, but the entire right side of the courtroom for sentencing day was given to the media. The other side, the left side, the first 3 rows were family, and then the rest of it was open for public. But in order to get into the public seat for inside the courtroom, you had to be in line by 7 a.m. to get your name on the public information officer's list. And then you were told to show back up and be inside the courtroom before court started, which I believe for this hearing for sentencing was 10 a.m. And so you had to come early and then come back at 10. Like I say, I hired a line sitter to sit in my seat overnight to keep my space in line because there was a lot of people out there. And, you know, I had to show up at 7 to take over so I could get on the list. Like, so nothing's wrong with putting parameters in place. What they're arguing in this case is that unlike in the Diddy case, there was overflow room. So let's say you were a part of the public and you were in this line to get in at 7 and you didn't make the list. You weren't turned away. You were just sent down the hall to an overflow room. So you couldn't be in the courtroom, but you were in a room outside and they had a live feed to that room. And you'll hear how the judge provided that for the first 2 days in this case. But then for some reason he stopped it and never had a hearing on it and didn't follow any of the Waller factors or Presley factors that the law requires. This is the defense argument, okay? And that because he didn't, then the restrictions were not done fairly and Karmelo didn't get a public trial as prescribed by the law. And so the verdict needs to be overturned. So that's the, you know, the gist of the argument. But what we just went over are what the restrictions were in the judge's order. And you're going to see a problem is that they weren't even, I'm going to go through it, but the order says this, but how it was actually put in practice was even more restrictive, okay? And that's what we're going to get into next. So number 9, the order also closed the courthouse grounds themselves. It placed the entire courthouse campus, including parking lots, sidewalks, green space, or any other designated area under a nightly curfew from 11 p.m. to 6 a.m., beginning May 31st, 2026. It designated restricted zones on an attached exterior map, and it ordered the Collin County Sheriff's Office and other law enforcement personnel to ensure compliance with this order at all times during the trial. Judge Roach spoke on this in his interview and said he brought in like 3 different counties. It was Collins County, Frisco, and another county's police that helped with enforcement of this order. Under the order's enforcement clause, any violation including a citizen's presence in a courthouse parking lot or on the green space beside the courthouse before 6 a.m., expose the violator to immediate removal from the courtroom, courthouse, or courthouse grounds, and the imposition of sanctions, including contempt of court, and no warning is required prior to enforcement. No findings of any kind accompany the curfew. So remember, we spoke earlier about the findings of facts that the judge has to put on the record. They're saying that the order didn't speak to any findings of fact as to why this curfew had to be over the parking lot, which is a restriction, right? Because you'll see further why this mattered, but this affected who entered the courthouse. Access in operation, the curfew, the parking lot, and the pre-dawn line. In operation, admission had almost nothing to do with the order stated 8:50 a.m. public entry time. Because the public seats were few, members of the public began arriving in the pre-dawn hours, often between 4 and 5 a.m. Okay, so the order said public is to come in at 8:50, but if people are lining up at 4, you got to be out there at 4, right? You can't just be sitting at home saying, well, the judge said 8:50. If people are in line, now what is in practice is even more restrictive than what is actually happening. But how are people getting in line at 4 and 5 when the order just said the parking lot was closed until 6 a.m.? I don't know. So it says, because the public seats were few, Members of the public began arriving in the pre-dawn hours, often between 4 and 5 a.m., before court was in session and while the campus curfew was still in force. And sheriff's deputies enforcing the order stopped arrivals at the parking lot and restricted entry onto the campus until the curfew lifted at 6. The queue that actually determined who would see this trial thus formed at the perimeter of the courthouse campus hours before any proceeding convened. A member of the public who appeared at the order's appointed hour of 8:50 had, as a practical matter, no prospect of a seat. Okay, so do you see, like, they're saying the order says, oh, show up at 8:50 for the public. But in actuality, what happened is you weren't there at 4, gathering on the outside of this perimeter in a line to where when they raise the arm at 6, you're running to the courthouse doors. You're not getting into the hearing, even if you follow the judge's orders. So that makes it even more restrictive, right? 11 says the line itself was administered without published standards. And if you'll remember, the judge said in his order, he wasn't getting into that. He wasn't going to get into how this order he wrote was administered. He was leaving that up to the public information officers and the sheriffs, right? So you couldn't say, Judge, we need a hearing because, they're letting people in line. I mean, there was no mechanism to object or argue about how the restrictions were actually being applied. So it says the line itself was administered without published standards and not even handily. Individuals were permitted to move ahead of members of the public who had already waited for hours. Thelma Anderson, who arrived early on June 6 and initially held approximately the 7th position, was displaced to approximately 35th, beyond the number of available seats, and was excluded from that morning's proceedings. Tamara Carter, identified as number 7 on an early arrival list, was removed from the line on June 5th and lost the morning session. Admission was run through 2 lines, one for a media list, one for everyone else. And media outlets denied credentials, meaning they couldn't come through the media line, were directed by the public information officers to seek entry through the public line, thus lessening even more seats for the public, right? Whereas the Collin County Sheriff's deputy administering the line acknowledged on video, persons who print out whatever and make themselves like they are the media consume the public's few seats, a practice the officer conceded they could not police. So what they're saying was happening, like there's a media line, there was only 9 legacy media. So you get there that morning, you show, and they actually, as you'll read later, allowed the media to get in the parking lot at 4:30 a.m. so they could start setting up and going live for the morning news. All right, so what people were doing was making fake media credentials. But these police officers out there aren't aware, they don't know that it's fake. They don't have a way to check that. So as people are flashing badges, they're letting them into the parking lot. Also, what was happening was that media that got approved and you got 9 seats, say this media, they wanted to get 2 seats for this media outlet. They would give their second person media credentials to get into the parking lot at 4:30, but that person would jump in the public line, being earlier than the other public that's allowed in at 6 to get into this public line. So the public's coming in at 6, and it's a line of 27 to 32 they're letting in, and already 20 people are in line because they're media credential people, but coming through the public line. So you see how this was causing a lot of friction outside. Now, you're just tuning in, you're hearing this part about the motion, you're like, what in the hell does the media people, the line being closed, all of that have to do with Karmelo's rights? Well, the 6th Amendment of the Constitution says that the trial has to be public, and if the judge places any restrictions on those of the public openness of the trial, he has to follow Waller versus Georgia and Presley versus Georgia. We're going to get to those cases shortly, and you're going to see what the defense is arguing that the judge didn't follow from those cases. Those cases also say that if the judge doesn't follow these pre-prescribed rules to make this decision, it is a structural error, meaning it doesn't matter what the verdict is, the case will be overturned and sent back for a new trial, period. Okay, so this is not about something didn't happen under the 10, it's self-defense, Karmelo's innocent. It's not any of that. This is about the judge has to follow the law in order to put restrictions on his courtroom. And if it's not done correctly, then the case can be overturned. Okay, so I'm going to pull out of this interview, of reading the motion, and just see if there's any questions or comments that I need to address. All right. YSL Kale says, I'm thrashing around like a toddler, screaming rights violation, kicking and screaming. Like, yeah, sometimes people can win on technicalities. It happens every day. I get that to happen on cases. It doesn't ever mean that the person isn't guilty. It just means that the law wasn't followed. And if that is what the court decides, because I'm not the decision maker, the defense, this is just their argument. This is a one-sided bias live because it's the defense's argument. I don't know what the state is going to argue. I can pull little things out as we go along that I think I would argue if I was on the state, but I'm not spending time to research their position. They will file a motion. We'll come back and review it. Okay. So this is the defense's argument as to what the judge violated. And I'm saying if it's true and the court finds that, they can overturn the conviction based on those things if they find they're missing and the objection was raised timely and that everything is correct, else with the motion. YSL Kale says, hand delivered, stop the madness. I agree. So we don't even know what the motion looked like. We don't even know. Well, we know one wasn't filed in the whole restriction. The judge didn't even have a hearing. He just woke up one morning, July 28th, 2025, issues a gag order. He wakes up another morning and issues this order restricting the public and the media and stuff from coming in. So, and I'm looking at that order. The amended order was May 18, 2026. That amended the, who all could come in and what was done. And the gag order was done July 28, 2025. All right. So see if there are any other questions before I go back. YSL Kales also says no record to such extent must mean it didn't happen. There's no way to look past it. Well, doesn't mean it didn't happen. It just means that a court reporter didn't take it down. So that's why they're attaching all of these affidavits to the motion to get inserted into the record what happens, right? But affidavits are one-sided. And so they are sworn testimony, but that's why they are asking for evidentiary hearings so that they can decide what's credible, what actually happened in this case. We got to create a record after the fact because judge, did a lot of things in secret. I saw Kat Nat Williams in here. Shout out Kat Nat Williams. She has an amazing channel on YouTube. If any of the mods in the chat can share Kat's channel, I greatly appreciate it. She says, sorry I'm late. Got caught yapping. Great job on everything you're doing for Mootoon, Mrs. Sledge. Thank you so much, Kat. And I know I just got a text from Jim. He told me he found the motion. So, we did get an order back from the Court of Appeals on YSL case. They said the court there didn't place a finding of facts on the record. So they got to go back and do that. And so we're still fighting, but we got all day to fight because the Department of Corrections of Georgia is maxing out on Samuel Sledge for his entire 5-year probation revocation. So we got 5 years to fight. So we're still at it on that case. Love Forever 44444 says courts are private businesses. They are not. They are open to the public. Your tax dollars support the court system. And so it's not a private business. It's publicly owned. You have a constitutional right to the trials that occur in your county. And so does the defendant. And so does the media under the First Amendment. So that would be wrong. But yeah, Moontuki's still keeping his head up. So y'all keep him in prayer. We're still fighting on that case. All right. So I'm going to get back to the motion. All right. So now we're in section E, and this is still the factual background that opens the defense's motion for new trial. It says the courtroom held approximately 70 seats by the court-appointed public information officer's own written account. 15 were allotted. And now let me tell you, this wasn't in the judge's order. Remember, he assigned this public information officer to facilitate his order. And his order spoke on the times people could enter, what they couldn't wear, all the 9 media legacy people that he would allow in. That's the judge's order. What we're getting into now is the public information officer's enforcement of the judge's order. Okay. So the courtroom held approximately 70 seats by the court-appointed public information officer's own written account. 15 were allotted to the prosecution's family, 15 to the defense's family, and 9 to the media, including a courtroom sketch artist, with additional seats for court staff, leaving about 24 or so seats for the general public. The trial judge later confirmed the arithmetic on television during his interview, and he says they had some 200 requests by the media and 27 to 37 public seats that we rotated every day. That's the judge's words from the interview. None of these allocations appear in any order, however. And the 15-seat family allotment was not honored in practice. The defendant's own family was limited to 8 seats in total, so that his grandfather and his aunts were excluded from his trial, while those admitted were required to register a day in advance and were warned, can't talk, and they were warned that a visible facial expression could result in removal. I think that's a little extreme. I mean, I could see an outburst, but to make a face? Which is funny because, I mean, I heard other court reporters and people that were not court reporters, but people who were inside the trial that were legacy media reporting that they saw Austin's dad do visible, head movements, shaking and nodding during testimony. So I wonder, was that considered a facial expression? I don't know. Hey. That's what the public information officer said, was that visible facial expressions could result in removal. Now, the whole not being let in unless, you're having a recess, that's normal. That's how it was in Diddy case, which is why I didn't drink any water the day I woke up, because they said if you leave out, you can't come back in until the court is on a break. And because it's distracting, if you allow people to go in and out, you got these big doors closing, somebody's testifying. I mean, when people in the courtroom in a high profile case, it's so quiet, you can hear a rat peeing on cotton. Like, it's really quiet. So when you go in and out, you're going to be disruptive. So I totally understand that. So they're not arguing that any of this was too much or not enough or whatever. Their point is that people were excluded. And if that is the case, the law requires you to follow these steps. And we're about to get to those, okay? Section 13. It says, for jury selection, the court furnished what its order had never promised. So in the order, when we went through the restrictions about who can come in, who can come out, the courtroom has this many seats, it never spoke to any alternatives or extra viewing areas they were providing. However, when everyone showed up on day one, there was an auxiliary viewing room. All right. So for jury selection, the court furnished what its order had never promised: an auxiliary viewing location outside the courtroom, a functioning overflow room where members of the public who could not be seated inside observed the proceedings on June 1st and 3rd. Great, right? That sounds good, right? That means that people outside of the 2732 were able to watch the jury selection go on. People could report back how many minorities they saw on the trial, like what questions were asked. That's how we know that Black jurors were taken off and not chosen, because they were being unbiased. They were saying, I can't give a brother time, or, I could never give the death penalty. Those are things that get you off a jury. That's how we know that the last 3 Black jurors that were struck were the teachers. And they were taken off of the trial because the state argued that they didn't feel like they could be unbiased because they were high school teachers, and this was about students at a high school case, and maybe they'd be sympathetic. So we know those things because people were allowed to sit in auxiliary viewing room and see it. But why did that stop? Questions never answered on the record. So the defense says on June 4th, 2026, the first day of testimony, the court eliminated it. No announcement was made in open court, no order was entered or modified, and no findings were made. Public access was thereafter confined to the seats inside. Nor was the elimination a reaction to anything that occurred at trial. As early as May 25th, 2026, The public information officer had advised an inquiring journalist in writing that there will be no overflow room during the trial. This, although the county's own media request intake form listed the overflow room access on the form as an option you could choose. When Thelma Anderson asked the court for an alternative viewing location, there was no way even to file the request. The county's electronic filing system had no category for a courtroom access request in a criminal case. So the request was routed by email to the court coordinator and on to the public information officer, and it was denied outside any judicial proceeding. On June 5th, the public information officer confirmed in writing there is no overflow room. What they're referencing is that the Thelma Anderson, she's nobody important, right? She's nobody like particularly related to the case. She is just a viewing member from the public that traveled to watch the trial. And they're including her affidavit attached to this motion because she had communication with the public information officer where he communicated, things like there's no overflow room when there was one for the jury selection, or he communicated things about the whole 15 seats for the defense and 15, their state is, the defense got that information from emails and writings from this public information officer to other members of the public. So when they are referencing these exhibits, that's what they're talking about and how they are submitting this information to the court for it to be considered. And remember, this motion for new trial only has 75 days to be ruled on. If it's not stayed, meaning the judge considering the recusal doesn't issue a stay on that time, come September 21st, if either whoever is the judge on the case, right now it's Judge Roach, but if he's recused, then let's say it's Judge Johnson, right? I don't even know if that person exists there, but Judge Johnson, and he doesn't rule within 75 days by September 21st because there's been no stay, then this motion is automatically denied as a matter of law. But then it'll be appealed to the Court of Appeals, right? So they need to create a record of the things that they're arguing about. And so that's why they have all of these exhibits, because these issues weren't things that were argued in court. They're outside of the court. So that's how you create the record. So I know y'all like, who is Thelma Anderson? And there are people from the public that have reached out to the appeals team and that they have tracked down to assist building this record of what occurred outside of the courthouse and in how the judge's order was put in place. So just to clear that up. So the defense then says, day by day, the accommodation existed only while no witness testified. So the pattern is visible day by day. During jury questions and voir dire, June 1st and June 3rd, an auxiliary viewing room accommodated the members of the public who could not be seated inside. On June 4th, the first day of testimony, that room was eliminated, and on every documented day of testimony thereafter, members of the public were excluded. The accommodation existed precisely when no witness was testifying and vanished precisely when the evidence began. And they have this diagram here to show, like, we had an auxiliary viewing room doing voir dire, jury questionnaires, but not when testimony began. There was no way. And now what you'll see, and what is also one of their arguments, during the judge's interview on TV, he says to the reporter, in hindsight, I kind of think maybe I should have had a video, audio feed, not video, but audio feed of the trial. But then he says, but people are going to make up and hear what they want to hear. So that thought is what should have been on the record, right? There should have been an evidentiary hearing where those alternatives were discussed. And if they weren't discussed, then they had to be considered by him and had to be listed in the order as to why they weren't being put in place. So if you did consider an audio feed, why wasn't it granted? If you did an overflow room for jury selection, why didn't you continue it? If your concern was the young witnesses that were testifying, and you recognize, because he talked about this in the interview, that when cameras in the room, he notices that sometimes people change up how they act, that sometimes the judges act different, the attorneys act different, the witnesses get shy, right? Because if you're testifying against somebody, the street's going to call you a snitch and everybody's looking, you're going to testify differently, right? Or maybe as a child, in this case, you go to school with Austin and Hunter, right? So Austin's no longer here. You got to go back and return for your next year with Hunter. He's going to be there, but he just graduated. But you're still in the community with these people. So do you want to get up there and testify? Are you going to be okay to be on TV speaking against these people during your testimony, or are you going to kind of switch it up? So that's what the judge's concern were. But like he said in his interview, audio feed sounds like something that we could have done that would have avoided the minors being on TV, right? Some people got doxxed as a part of this case. Doxing is when people from the public, get a hold of your cell phone number, your home address, and they just put it out for the public to see, and you didn't get permission for that to happen. Some people are getting swatted. That's when they call 911 and make up fake bomb threats or something like that serious so that a SWAT team shows up at your house. So the judge is concerned that is that concern valid? Maybe so. That could be a valid concern. But what's the alternatives that we could do to override that? Because this is not the first case where kids are witnesses. This isn't even a sex case where there's sensitive testimony from the kids. This is about a fight outside. Kids talk about this every day, right? They had no problem going to the police and talking to the police and making statements right after, right? So you're concerned if you don't want them to be seen on camera, you put an audio feed. And you let that audio feed be broadcasted to the world through the media that you've allowed in, or you allow it to be broadcast to overflow room, but you can make sure that people can hear, right? And so you considered it on the interview, so it should have been considered in your reasoning, in your order for the appeals court to see. And that's what another argument they're making. Presley requires that reasonable alternatives be considered on the record, and that means in the document that is restricting the courtroom. We didn't see anything in there that said, I'm not doing audio because da-da-da-da-da. So because of those reasons, the defense is arguing he didn't follow Waller and Presley, and so therefore he didn't allow a public trial, and therefore the conviction should be overturned. So that's what the defense is arguing. All right, so we're still on number 15. The exclusions that followed were repeated and concrete, and they're going to list other people that submitted affidavits. Jacqueline Yon traveled from North Carolina, and on the first day of testimony found a line roughly 80 to 100 people, from which only about 27 were admitted. Tierra Allen flew in from Arizona, observed jury selection from the auxiliary viewing room, was told on June 4 that the room had been eliminated, and was excluded from the courtroom on June 4 and June 5. Bridget Smith attended on June 1st, 4, 5, and 6, and confirms both the roughly 27-seat public cap and the elimination of the outside viewing location once testimony began. And they're using all these people because they need to be able to prove that this actually did occur, and they're not just making it up, right? Because this is outside the presence of the court, so it's not on the record, okay? So this is their way of perfecting the record. Kiera West was turned away on June 1st on a purported juror members only rule and was physically removed from the courthouse on June 6th because of the expressive content of her clothing. Remember, that was something in the judge's order, was that certain clothing could get you banned. Thelma Anderson was excluded on June 4th, June 5th, and on June 6th, was seated only in mid-afternoon after substantial portions of that day's proceedings had passed. Throughout, no declarant observed any disturbance, security incident, or disruptive conduct by any member of the public that would explain the restrictions. This unrecorded agreement. All right, so now we get into this gentleman's agreement that led this case to be shaped the way that we all know it played out in court. It says the same off-the-record method that hid the pretrial proceedings from the public also produced the understanding. Oh, I'm not sharing my screen. Sorry. It's like, why do I just see myself? All right, sorry. Okay, so number 16. The same off-the-record method that hid the pretrial proceedings from the public also produced the understanding on which the entire defense was built. Beginning in early May 2026, the lead prosecutor proposed that the parties tried the case clean, based only on what happened under the tent that day, with neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. The terms were negotiated in meetings and calls on May 5th, May 8th, May 11th, and on May 21st, 2026. The parties presented the understanding to the court itself in chambers off the record. Let me go without that court reporter again. To avoid media reporting on bad act evidence, the understanding was memorialized only as a deliberately generic motion in limine, hand-delivered to the court on the first day of trial. It does not appear on the public docket. I have to stop and give a shout out to Louise Levi. She sends, her name on, I'm sorry if I messed that up, was Aries One. She says, thank you so much, Aries One. She sends a $5 Cash App. I greatly appreciate that. So I wanted to pause and give a shout out to Aries One. Thank you so much for your support. All right, let me go back. So this is a gentleman's agreement, right? So you all hear this, right? So this is the off the record method that they talked about trying this case clean. They had conversations May 5th, 8th, 11th, and on the 21st. And in order to memorialize this off the record gentleman's agreement is a deliberately generic motion in limine, meaning the motion doesn't say anything about the agreement. It's just a motion in limine that the defendant said basically want to keep out character evidence. And they just filed it and hand delivered it to the court on the first day of trial. That's it. So no in writing the actual words of this gentleman's understanding. They just met about it, talked about it, worked it out that way. And we're going to go through Mike Howard, the defense attorney's affidavit, to where he talks about what his understanding was and how everything blew up at trial, and how that is the reason that Karmelo did not end up testifying in his own defense. All right, so number 17, it says, from that point forward, meaning once they worked out this gentleman's agreement, the defense tried his case under that limitation at every stage in reliance on the bargain. In voir dire on June 3rd, the defense did not explore with the panel the themes of the decedent's character and aggression it otherwise would have developed. In its opening on June 4th, it introduced none of them. Through the state's case on June 4th, 5th, and 6th, the defense let the state's student witnesses leave the stand without confronting them with their own recorded statements to the police. That in statements such as that Austin Metcalf was kind of like the aggressive guy on the team, that he got triggered, that Austin and Hunter, they're not going to let you disrespect them, that if Austin is about to get into a fight, you can tell, and that he could be a bit aggressive at times. These were statements that the kids that witnessed this incident and testified on behalf of the state made to the police on the day that this incident occurred. But because of the gentleman's agreements, they agreed not to cross-examine the kids about their statements, even though the in-court statements differed, because they were going to keep out extraneous offense information on both sides. Extraneous offense is stuff like bad character stuff. You're going to hear stuff that, and I didn't make this up, I'm not pulling this from a YouTube conspiracy. We're going to see this in this actual motion, that they had evidence that Hunter and Austin had participated in racist graffiti in the past, that they had participated in bullying the cheerleaders in the past, that they had been, we're going to get into other things that were said about them, but just as they had bad things about Austin and Hunter, the state also served a 75-page notice of extraneous evidence against Karmelo Anthony. We don't know what that evidence is because, of course, Mike Howard's not going to tell us that. Right? So that's not in the motion. But as a 20-year criminal defense attorney, I would bet $100 that at least a few social media posts of Karmelo with a gun is in there. Because that's what all of you all have when you have criminal charges. Every case I get with a young person, I don't care if it's a female or a male, if they're charged with some type of violent offense, there lies on social media a picture of them with some type of weapon. There's no evidence that the weapon was used, right? That doesn't always exist. But I don't know what it is about social media that, this generation of kids love to post pictures of themselves with weapons and all that kind of stuff, okay? There could have been other stuff about Karmelo. So this gentleman's agreement wasn't entered like Mike Howard was just being, just not a good attorney. He was doing this agreement because there were things in it that he believed were harmful to Karmelo to come out at trial in his self-defense argument, just as the state entered this agreement because they knew that there were things that would hurt their case that could come out against Hunter and Austin, right? If this is a self-defense case and I'm able to present evidence that the decedent, the person who died, that Austin was a bully, that he was aggressive, that he was racist, that will color the jury's thoughts about this case in a certain way. I don't know which way, but I'm just saying it would be different. And the same with Karmelo. If there are negative things placed against him, the jury may not believe this self-defense argument, right? So both parties, and you'll hear in Mike Howard's affidavit that the state initiated this agreement, but once it was presented as a defense attorney, you need your client to testify, but you got to deal with all of this bad facts, and someone offers you a way to keep it out. He decided that the right move in this case was to take the state up on their offer, and so they entered this agreement. And so that is going to be a crux of the issue in their motion for new trial, because they say that after operating on this agreement through jury selection, through not cross-examining the state's witness, we get to Karmelo testifying, and then the state wants to not participate in the agreement. But during the sentencing phase, they want to come back and participate in the agreement when their argument before Karmelo was trying to testify was that the defense opened the door, and so the agreement was off the table. But then they put it back on the table when it got to the punishment phase. So kind of funky. So we're going to get into that, but let me go back to the motion. Oh, let me come back. I saw a couple of comments. Shout out to CDB, says, I love the way you're explaining this to us piece by piece. Yes, that's what legally speaking with FIT is all about, okay? So we're getting into just the legal documents. We're not getting into the conspiracy theories, the hypotheticals. We're just dealing with the law, and the facts, okay? So thank you so much for tuning in. Tracy Perkins 7651 says, is this gentleman's agreement even legal, or is it common practice that lawyers kind of do this behind the scenes? I will not say it's common practice. I have not ever made that agreement, but we have made other kind of agreements like, hey, we're going to stipulate that this is what this is, and not go through the whole rigmarole of bringing in somebody to testify that, this picture is a picture of the scene, or that this text message really, say the text message, experts. We're just going to stipulate to agree that this is the text from his phone that he sent. We will make those type of agreements to make the trial go faster and smoother, because the jury, you're lay people. You don't want to hear a whole bunch of mess from a whole bunch of experts. You want to get to the meat and the crux of the case. So yes, there are times when you will enter agreements to not argue over certain things. I cannot say that I personally have ever heard of this type of agreement being a handshake agreement. I was talking with someone earlier, and I think back to the YSL case and Brian Steele and Keith Adams and their representation of Young Thug. And I just can't see Brian Steele entering into a handshake agreement with DA Love, who they will be shouting matches every day in the courtroom. He couldn't trust her. He said he didn't want to ever meet with her alone anymore. Why would you make a handshake agreement, right? If we do make this agreement, let's reduce it to writing. Let's put it on the record so that if there are any issues and we fight about this, we can make an objection to it. We can actually argue. We have put in writing what all the details are, and you'll see that this handshake is part of the issue, because when it gets to Karmelo testifying, the state says, wait a minute. We never anticipated Karmelo in this agreement. We were just talking about the witnesses under the tent. Well, isn't Karmelo a witness under the tent? He's going to be testifying just about what's under the tent. How else would the state get in all the extraneous offense information against Karmelo but through Karmelo testifying and being cross-examined? You can't bring in everything about the defendant bad. You can't, talk about his social media posts through. How do you get that stuff in if you didn't do a search warrant for his cell phone? Like how do you get all of this other bad act stuff about Karmelo but through his testimony and cross-examining him? So you had to consider that he was going to testify. That doesn't make any sense. And then the defense is like, yeah, that's how we based the argument. We did this whole case. You knew self-defense was part of our case. And as any good attorney would know, if you're watching a case and it's unfolding and the defense doesn't have a witness that can testify about the defendant's fear and why they acted in self-defense and why they stabbed somebody because they felt threatened, the only person that can answer that would be the defendant. So when the state started saying, no, we didn't anticipate Karmelo testifying, and that sounds crazy, they then say that the defense opened the door to this stuff coming in because the agreement's out of the window, because during opening, Mike Howard said that Karmelo played chess. The judge actually says, I don't agree with that. That door wasn't opened. But hey, buddies, this is an off-the-record agreement, and so I don't have any way to enforce it. So if Karmelo gets up there and testifies and the state raises an objection or tries to bring in some extraneous information, I'm going to follow the rules of evidence. So it's coming in. And then Karmelo has to make a decision if he's going to testify. Y'all see how this is like leading down a slippery slope and it doesn't feel good? So let me go back to the motion, but I just want to break that down. So answering that question, no. Hell no. In a murder case, if I'm making a gentleman's agreement, it's going to be in writing. I literally just had a case at the top of the year, client in Atlanta. She young, 18, 17, graduated early for school and had gotten herself into some trouble. She had participated in an act that was basically party to a crime to felony murder. And the police were reaching out to get a statement. I was not taking her down to make a statement. We don't talk to the police, but she was in a position where she was the least culpable person in this act. And so I felt like, hey, well, they'll give us immunity, meaning your statements can't be used against you in trial. This may be your way out, right, to save yourself. And so we began a 4 or 5 day back and forth to work out an immunity agreement. And we could never get the language of the document that we were putting in writing of this agreement to what we wanted. So we didn't talk. Like, you get it in writing. I'm not trusting the state on a handshake. Okay. I want it in writing so that if something like what happens, is clear on the record as to what the agreement was. And so while you may have, Queen Brielle says, hi, Fit Lori, this sounds a mess. It does. And this is why I had that jaw dropping when I was reading the motion. Like, what? Because as we were first going through this trial, it was like, why didn't the defense object? Why didn't they bring up this about Austin? Why? Because his own mom in her interview stated how Austin was aggressive and could be aggressive. And she even talked about the whole bullying with the cheerleaders and how they had to meet at the school and there was this email. She confirmed that. That is true. And so we all wondered, why didn't it come up? This is why. All right. So I'm going to go back to this motion and continue on the defense's arguments. And this is just the factual background. So we haven't gotten into the legal arguments. I am injecting some of that as we're going through because we're not going to read all 63 pages of this motion. But I want to go through the factual background so you can get what the defense's argument is based on. And it's these facts. All right. 17. Okay, I was talking about the things that the defense left out, the statements like, that Austin kind of like the aggressive guy on the team, that he got triggered, that Austin and Hunter, they're not going to let you disrespect them. These are things that the gentleman's agreement kept out. The defense designated no experts, foregoing a neuropsychologist prepared to explain how the defendant's, Karmelo Anthony's, epilepsy affected his perception of threat, and a forensic psychologist prepared to address adolescent brain development and the fight or flight response. Because the state took the position that such testimony would breach the understanding, the defense didn't bring it up. So you see, like, if this motion for new trial is granted, it's going to be a totally different trial. They're going to be experts that testify. We're going to hear all the dirt from both sides. Like, it will be a different trial. So who knows if the verdict will change or not, or even if they will want to go through another trial if this motion is granted, okay? I don't know if it'll be or not. 18, the forbearance had a purpose. The payoff was to come in the defense case under the understanding, as the prosecution itself repeatedly described it, covering all witnesses to what happened under the tent. The defendant would testify to the altercation like any other tent witness, free of character impeachment, and the defense would present its self-defense case through him. Every pretrial discussion presupposed it. The prosecution repeatedly raised the ambiguous aggressor doctrine that matters only in a self-defense case built on such evidence. And as trial counsel has sworn through Mike Howard's affidavit, in this case, the defense would ordinarily depend on the defendant's own account of his perception of the threat. On Monday, June 8th, the final day of evidence, after the defense has spent voir dire, is opening the entire cross-examination of the state's case and the first day of its own case honoring the bargain, the lead prosecutor announced that the agreement had never contemplated a testifying defendant and asserted that defense counsel had already opened the door by mentioning in opening that the defendant played chess, a position the court itself rejected. So Judge Roach even told them the defense mentioning the chess did not open the door to this agreement, but the state stood on that position. The court then advised the parties that it knew of no mechanism at its disposal to enforce their gentleman's agreement. And understanding that throughout the months, the defense relied upon it, existed on no record because it had been reached and presented to the court off the record. And that if the defendant testified, the door to character and extraneous offense evidence would almost certainly open. So this is Judge Roach here. Judge Roach advised the parties that it had no mechanism to enforce their out of public, but presented to the court off the record gentleman's agreement. And Judge Roach said that if the defendant testified, the door to character and extraneous offense evidence would almost certainly open. And I will tell you, that's the case in every case. That's why sometimes the defendant can't testify. We had a defense case, a murder trial. Couldn't put up our defendant because he had a previous conviction of aggravated assault, of shooting up a place. So it's like we're in a defense case now, self-defense case where a gun is used, somebody dies, you can't testify because if the jury hears about your past conviction, they're most certainly probably going to convict you of this. And so we had to use other witnesses to bring in that self-defense claim, right? And so here the judge is saying, if a defendant testifies, pretty much you're putting your character in the evidence because you're going to talk about your character in this situation. So then your other character evidence could possibly come in. It does require hearing, but I'm just saying if you open the door and the defense is cross-examining you, the state is cross-examining you on it, the judge is saying, I don't have a mechanism to enforce that agreement. I got to follow the rules of evidence. And so I think it's going to, open the door. The judge then allotted 10 minutes. The defendant elected not to testify. Judge Roach gave Karmelo 10 minutes, a 19-year-old charged with murder, to decide whether or not he was going to testify after this 2.5-hour break. So this 2.5-hour break wasn't 2.5 hours of Karmelo deciding whether he was going to testify or even being presented with that option. It was the attorneys arguing over whether or not this agreement had been breached and what could happen. I mean, you'll hear in Mike Howard's affidavit that they had a shouting match and the judge told him, walk it off, cool down. So that's not Karmelo thinking about whether or not he's going to testify. That's them arguing on whether or not the state was going to enforce their agreement. You're going to also hear from Mike Howard's affidavit that they actually went down and Mike Howard went through his entire direct testimony that he would have done with Karmelo on the stand with the state over his back. And they went through each sentence, each question. Would this open the door? Would this open the door? Would this open the door? And if it's so, he took it out. They went through all of that. And then the judge has this discussion and says, yeah, I hear y'all went through all of that, but I don't care. I mean, I can't. And you'll hear about, because this is just a brief introduction of it, but I've read all the pages. And the judge says, you know, hey, I understand y'all went through all of that, but Karmelo, I don't think you should testify, because if you do, it's going to open the door. And I understand that y'all just went through line by line, but if the state does something and the defense objects, I'm following the rules of evidence, not what y'all just went by line and did. Although he allowed the entire trial to be tried on this gentleman's agreement. He knew, watching the state's case during cross-examination, every time the defense got up and didn't go too far, they were operating on this agreement. So to then get to this point and say, oh, you got 10 minutes to decide whether or not you're going to testify, but if you do, everything's coming in, doesn't feel good. I don't know if they're going to rule that this is something that's enough. Is this going to be considered a coercion so that Karmelo doesn't testify? But it definitely doesn't feel good, okay? But feelings don't matter. It's about what the law says. But this is what the defense is laying out the facts to be for their argument. And I see y'all in the chat, and it's like, this is crazy, you know. Someone says, where's Toby Shook's affidavit? Isn't that interesting? No, Toby Shook and Bill Worski work together. So it's kind of like, you read his and it speaks like this, you're going to be like, oh, y'all used to work together. Y'all ain't friends no more. Y'all, you know, you're being biased. But this is Mike Howard. He doesn't have a connection to Bill Worski. He's just stating what the facts are. So no, I don't think that it's strange that we don't have an affidavit from Toby Shook at all. I mean, he used to be a DA in Collins County. He used to work in the DA's office. So I think Mike Howard is the most unbiased attorney out of the team of three. It was three. Why did the female not write an affidavit? She doesn't have a working relationship with the DA. So I just think Mike Howard was the lead counsel. So that's why he's writing this affidavit. Certainly if for some reason Toby Shook is not in support of this, and if some reason someone's lying or whatever, he definitely can write an affidavit stating that case and file it with the state's motion. But no, I think we're looking into things on that. I think Mike Howard was the lead. Everyone's been questioning why he didn't do certain things. He was first chair, so that's usually who we get the affidavit from. Okay, so back to the defense's motion. The judge allotted 10 minutes. The defendant elected not to testify. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witnesses. And at punishment, the defense case was reduced to 3 pre-approved questions of the defendant's mother. The state, for its part, called no punishment witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice, resting its punishment case immediately, exactly as the lead prosecutor had described on May 11th that the agreement will operate. Exhibit 10, we're going to go through that because that's Mike Howard's affidavit. The state thus performed the bargain at punishment the day after denying that the same bargain covered the defendant's testimony. In the end, neither side put on the character evidence the understanding covered. The bargain was performed on both sides through the last day of trial. The only term repudiated was the most one vital to the defense, the defendant's own testimony. Karmelo Anthony was necessarily a witness to what happened under the tent, under the understanding as the state itself had repeatedly described it. He would testify like any other tent witness, and his elimination as a witness was devastating to a defense that turned on his perception of the threat he faced. By then, the defense had already paid the price of reliance and could not undo the voir dire, opening, cross-examination, expert designations, or decision framework that had followed from the understanding. The expedited schedule, Saturday court in 10 minutes to decide. Number 20, the trial itself was run at speed. At the May 29th conference, the court announced its intention that the defense began calling witnesses immediately upon the state's resting, so that no trial day would go unfilled, including Saturday, June 6, 2026, a day on which several defense witnesses were unavailable. Like, I've never seen a case tried on Saturday, but this judge didn't want any breaks and wanted to get this done as soon as possible, so they came in on Saturday for this case. And so anyone can imagine why defense witnesses wouldn't be available on a Saturday. I mean, trials is the one during business hours, which are Monday through Friday. So people had plans, other pre-scheduled things. And so this is what the defense was telling the court. Trial counsel told the court that the schedule could force the defense to call the defendant out of order. The state rested midday Saturday, and the defense began its case that afternoon. The repudiation of the parties' understanding, described above and set out fully in Part 4 below, erupted on Monday, June 8th, the final day of evidence. When the moment came for the defendant to make the most consequential decision of the trial, whether to waive his Fifth Amendment privilege and testify, the court allotted the defense 10 minutes to counsel a 19-year-old through it and denied counsel's request for additional time. The defense rested that day after the shortened session, and the jurors were sequestered overnight in a hotel, informed that if they did not reach a verdict on Tuesday, they would remain sequestered. On Tuesday, June 9th, the court delivered its charge, the jury charge. The parties presented closing arguments, and the jury deliberated approximately 3 hours before finding the defendant guilty of murder. The punishment phase, evidence argument, deliberation, and the rejection of sudden passion was then completed, and the 35-year sentence imposed before the day ended. The sequestration and deliberation chronology, widely and publicly reported, will be established at the hearing and confirmed by the reporter's record. They're just speaking to how fast everything went because it's not normal. Like, right? Even in the Diddy's case, they didn't have trial on Saturday. Like, and the fact that they deliberated, convicted, deliberated, because the jury sentenced Karmelo in this case. In state of Texas, you can decide whether or not you want the judge or the jury to decide. Now, I will say in Georgia, you don't get that option. The judge sentences you. So you're convicted on murder in Georgia. If it's 4:30 p.m., you're getting sentenced that day because all the judge has to decide on whether it's not going to be life without or life with parole. And so it's because it's going to be life. And so we don't have that whole 5 to 99 where it's all these years to decide. It's a very quick and easy decision for the judge to make on a murder case. Like I say, she's just deciding whether or not you're going to be eligible for parole or not. And so unless it's a death penalty case. So unless you say, Judge, we got a lot of witnesses that we want to bring in to make a presentation to the court before a sentencing, usually it'd be done that day. If the trial ends later, because sometimes verdicts don't come back to like 6:37, then you'll return the next morning for sentencing. But the sentencing will usually take about 10 minutes. It's quick. But in this case, they had an opportunity to have a sentencing hearing because the jury was the one making the decision on the time, and it was very quick. And we know why, because of this gentleman's agreement, there actually was a prearranged 3 sentences or like a couple of sentences that Karmelo's mother could make. And then the defense decided not to present any of that was part of the agreement, any of their bad act stuff or anything like that. They would allow the mom to speak, but they would not allow a false impression to be presented. So they weren't going to let her get up there and talk about, oh, he's a manager at Foot Locker and he's a captain of the football team. And they weren't going to allow that because that was outside of the agreement. However, the day before, they had said the state violated that agreement. So how do we go back to we didn't violate it and now we're operating under it? It's just a little shady. All right. So J21 says this one. Yeah. Okay. So we ended with the sequestration of they're saying that all of that to be proven at a hearing. So number 21, the secrecy outlasted the verdict. Trial counsel withdrew on June 10th. Appointed appellate counsel was then replaced, and present counsel were substituted in on June 23rd, 2026. All while the 30-day deadline for this motion ran, the reporter's record remained wholly untranscribed, and the pleadings and case file sat in the court's chambers rather than in the district clerk's public record, sealed by an oral order. At a conference on June 29, 2026, the court advised that the entire court file had been sealed by oral order and conditioned appeal counsel's inspection of it on an agreement not to disclose what he observed. A condition counsel could not give, leaving the file available only in chambers. So even Karmelo's team that's filing this motion for new trial have not been given the court's file because the judge has sealed it in his office. And because they won't agree not to share what's in it, they can't get it. Never seen that before. I don't even know why. And if it was sealed by oral order, that means that there is no written order, which means there's no finding of facts as to why this case docket is still sealed. So, but while it's sealed in his office, this same judge went on TV and did an interview talking about the case. So, kind of weird. Number 22, 2 days after imposing sentence, the trial judge, 2 days. I didn't realize it was 2 days, y'all. God, I mean, literally, Karmelo had just been in prison 24 hours. 2 days. Wow. So 2 days after imposing sentence, and while the jury decided the sentence and said what they were doing, the judge still imposes the sentence, right? He still has to say this is what the sentence is, this is what the jury decided, and do all his, official duties. And then the defendant was taken into custody. 2 days after imposing sentence, the trial judge gave a televised interview defending the restrictions, describing the decision to bar cameras and streaming as an easy decision, acknowledging that he sometimes thinks maybe he should have at least audio streamed or something so people could hear it, and explaining that he declined to do so because people are going to distort whatever happens. So what's the point? In a written statement to Fox News, the judge added, "Now that the trial is over, it is important to me to provide transparency." And in a public letter on June 17th, 2026, he thanked the other judges of the county for adjusting their own dockets to accommodate this trial. At minimum, raising a fact issue about available courthouse space, available staffing, and available alternatives that should have been considered before the overflow accommodation was withdrawn. So if you caught that, the judge is thanking the other judges because what he asked them to do is, could you not hold court in person while we're having this trial? Could you stagger your court dates? Could you do court on Zoom, which is what the country did during COVID when the courthouses were shut down, but business still had to go on. So they're saying, well, the other judges, abided by your request. That means their courtrooms were empty. So there was plenty of space that could have been utilized as overflow rooms for this case so that more from the public could have heard the case if not through a video feed, at least an audio feed. Like he's saying on TV that one, he thinks maybe I should have at least audio. And guess what? If he had a hearing, maybe he could have heard from the defense to say, hey, maybe you could do this, judge, or he could have heard from the state and he could have considered alternatives. But because he issued the order sua sponte, meaning of his own volition, own free will, no one asked for it. He just issued this order and didn't consider alternatives. And that is what Karmelo is saying he did not do correctly. Will the court agree or not? They don't even have to rule on this motion. The law says they could just let this motion sit here for 75 days and it'll be automatically denied. But this is the defense's argument. 23, because, and this is the last point of the factual background, because the reporter's record of the trial has not been prepared, the official court reporter has advised counsel that no portion of the trial has been transcribed. And because the case file has been held in chambers rather than in the district court's public record, which is normal, you can go right now to the Fulton County Superior Court docket. You can log in online. If you don't already have a login, it's a free application. You fill it out. They allow you to log in and you can pull up the YSL case and you can download every motion that every attorney filed in the YSL case, and you can download every order. That is called the public docket. And that is the case in every case. It's the public's case. It's supposed to be public record. Unless for some reason there's a hearing and there's an order to seal. In this case, we've talked repeatedly how the judge just issued things on his own and without hearings to decide them. And that is a big part of the defense's argument. So 23 says, because the reporter's record of the trial has not been prepared, the official court reporter has advised counsel that no portion of the trial has been transcribed. Not one day, not voir dire, not jury selection, or that's the same, not openings, not anything. Nothing has been transcribed. And because the case file has been held in chambers rather than in the district clerk's public record, the recitation above is drawn from the indictment, the court's charge, the public docket, what little of it exists, the court's own orders and public statements, the attached affidavits and declarations, and counsel's knowledge, Mike Howard's affidavit. Defendant will offer evidence at the hearing in support of the grounds timely raised herein. So 11 pages, and we have just finished the defendant's factual background for his motion for new trial. As I told you all before, we're reading this, but we're 2 hours in, and we are not going to read all 63 pages. But next, they're going to get into the legal arguments, and I have summarized those. I got some little spreadsheets. We got some cases that we're going to look at, case law, and we're going to just see, what the law says, what the defendant is arguing, because we've heard like what the judge's order said, what the restrictions were. We have a copy of the order. We can see it ourselves. And so what this first ground argument is about is that Karmelo's trial wasn't public. They're saying, and now you're like, oh, it was open to the public. People were there. Pause. Okay. With the law, every term is defined. So while, yes, some of the public was allowed to come into the trial, several people were kept out because there were restrictions that the judge put in place. The judge put in place certain restrictions that limited I'm going to go to that order so we can just review it. And it's an exhibit attached to this motion for new trial. And this order placed restrictions on who could attend the trial. And what the defense is arguing is that the law says in order to issue these restrictions, you have to follow Waller versus Georgia, case out of Fulton County, and Presley versus Georgia, which is a case out of DeKalb County, both two courts that I practice majority of my cases in. Now, these cases were before I was a lawyer. I think Waller is like 1984. But that is how attorneys know what's required, right? It's not just a book of laws. Like, you got OCGA in Georgia, and that lists out that this is a crime, or that this is a rule when court happens, when you have a criminal trial. But how are the rules applied, right? Because the rule may be 2 sentences, right? But there's exceptions to the rule. Does it apply here? Does it apply at jury selection? Does it apply during the trial? Does it have to be public during motion hearings? Those things are decided by the Supreme Court, if it makes it that far, or Court of Appeals in case law. And that's what we go back and review and put that with the facts as attorneys when we file motions for new trials. And that's what the court is going to be deciding. In this case, they're not deciding the facts of the case. This is no longer an argument of did Karmelo stab Austin? Was it self-defense? That's not the argument here. It's just about did the court proceedings follow the law? Want to take a second. We have some super chats I want to review. Anthony Peterson 5618 sends a $2 super chat. No comment, no question, just for the pure love of the game. Thank you so much, Anthony. Greatly appreciate that. @4Dread sends a $5 super chat. He says, I'm just a criminal justice fan, not a lawyer, but as a lay person, Exhibit 10 is very alarming. Yes, we are going to I have that pulled to the side, okay? Yes, very alarming, right? Very, very alarming. And so we're going to go through that because that's Mike Howard's affidavit. And that's how we get into like the juiciness. And like what I just read was a summary. His affidavit is about just as many pages as what I just went through. And it just lays out everything about this case, how the hearings were held in chambers with no record. Like it goes into a lot more detail about what was in this gentleman's agreement and what happened in court and how they were shouting in the judge's chamber. It goes through all of that. So @4Dread says, I'm just a criminal justice fan, not a lawyer, but as a lay person, Exhibit 10 is very alarming. The backroom deals on what to not get into. My God. Yes. Do you see? As a fan of criminal justice, that means you watch a lot of these cases, a lot of these trials, and it's just not things that you see. These are not issues that I've ever read about in an appeals case of being an issue. Like, this is wild. Like, not only was there this gentleman's agreement, but it wasn't placed in writing. So when you get to fighting about whether or not the defendant is covered, it's kind of like, he say, she say, right? This is my understanding. Well, I thought this, but it's nothing to go back to because it wasn't reduced to writing. This is just really amazing. Like, you see, how things that happen prior to a case even starting shape what could be the verdict. You know what I'm saying? Because would we be in the same place if the jury was able to hear all the bad stuff that they had against Austin and Hunter, and being bullies and racist graffiti, and the email that the cheerleaders sent about them bullying them because the football team sucked. They were 1-9 and the cheerleaders were joning and making jokes about it. And then Austin, calls one of them a bitch, and then they write an email saying they're never punished for their behavior. Like, would the jury felt different if they heard that? But then again, Karmelo had things that were kept out by this gentleman's agreement, right? Would you have heard about his social media posts that possibly exist, or a fight he had, or school disciplinary records? Would have changed your opinion if you heard that Karmelo had gotten into a fight before, or even that he had a weapon before at school? Like, would that have changed your mind about the case? Like, those are the type of things that were kept out by this gentleman's agreement. I mean, Karmelo wasn't able to testify. That is the most, I guess, like the thing I heard the most after the trial ended was, why we didn't hear from Karmelo? Why didn't we hear from Karmelo? It's so crazy. Denise Walker 9298 says, if Karmelo had fired them during the trial, what would have happened? It just never has happened. I mean, you're in the middle of trial, so why would you fire your attorney, right? You're already, a new attorney would have to come in and operate under the same agreement, but that would be even harder because they were never a part of the negotiations. It doesn't undo what you've already agreed to, right? So we'll see. Silver Sergeant says, oh, please, none of that is even relevant to what happened under that tent. Silver Sergeant must just be joining us because he's making a comment about the facts under the tent, and we've already known, as we reviewed Texas Appellate Court, that this motion for new trial doesn't deal with the facts under the tent. It deals with the legal proceedings and was the trial fair or not. That's it. He feels he murdered the kid. Karmelo could have testified. Well, you're just in time, as we're discussing again, as to why he didn't testify. You're right. He could have, but they enter into an agreement that they keep out both things, and then they get to it and the state changes. So as you all know, along with this motion for new trial was a motion to recuse Judge Roach, because when this motion is filed, Judge Roach is who this is heard before. So before we get into the arguments, and because I need to take a break for the calls right quick, it's been on 2.5 hours that we're up here. I'm going to play you Judge Roach's interview with the court, and you can hear some of the statements that he's making about this trial. I've sped it up now, so it's not going to be the full 18 minutes that it is. We're going to listen to it on a faster speed, but I do want you to hear and listen to that. And you tell me, right, when we come back and listen, do you feel like the judge that makes these type of statements is an impartial judge on this case? Do you feel like he can now hear the motion for new trial and not, be biased towards Karmelo Anthony after this interview? Let me know your thoughts. All right.
My name is John Roach.
I hear that.
JOHNROACH.
No, I know the answers to that. I know the answer to that question, but I got to ask it for the record.
100%.
You've been on the bench for some time.
Yep, I've been on the bench for about 20 years.
20 years, and this is the end.
And then 6 months will be in the end.
Did you want to take?
Can y'all hear that? I need a 1 in the chat. Somebody put a 1 in the chat. Can I get a 1 in the chat if you can hear the interview? I want to make sure yes, you can hear it. Thank you, Latria Watley, so much. All right, I'm so going to go back to play this.
On this trial.
All right.
I wanted the Collin County Judiciary to take on this trial. It was important to me to have somebody from Collin County preside over this Collin County case. So I didn't ask for it. No one, that's not how it works anyway.
Yeah.
I didn't ask for it, but I was certainly willing to do it because that was my duty.
In your conversations with, I guess it's an administrative judge who goes, I know they go down the list and they say, all right, it's your turn, it's your turn. As they go through all the conflicts of judges potential conflicts, when they come and say, John, this may be yours, your first reaction is?
I'll take it every time. I think it's my job. It's my duty. That's what I was elected to do.
Yeah.
That's the oath that I took, and I'm going to do my job.
No consultation with your family or?
No.
Nope. And where does that come from?
I don't know. I think it's just duty. I think duty, whether that's duty in the Marine Corps or just duty to my family and stuff, I take duty really seriously. And I took this job to perform that duty. And if that's what I had to do, that's what I have to do.
Did you fully at the time grasp the enormity of that decision and the outside stuff?
I don't know. I think in some ways I did. I think in other ways I didn't. I certainly knew it was very, very important case within our community. I didn't think I realized the enormity of the social media and the media during the trial.
How long have you been prepping for this trial?
I've been prepping for this trial with the department, with the Collin County system, with the sheriff's office and everybody for about 8 months.
Is that the longest you've ever had to prep?
100%.
Why?
Logistics. One of the critical pieces of this case where we had minors who were testifying. Prior to me getting the case, we had some of those witnesses doxxed and swatted and revealed on social media. I didn't want that to add to the already traumatic event they've been through. And I didn't want them to change their testimony or be uncooperative with people trying to call them as witness out of fear. And so my number one duty at that point in time getting the case was to how do we protect those minors who are critical to this case to come and testify.
I'm sure you've already read and know that one of your fellow judges has already been doxxed and swatted and all the things.
I did know that.
And still no reluctance from wanting to take it on.
None.
Yeah. The decision to not have cameras or any kind of streaming, was that an easy one?
Yes, it was an easy decision. And I'll tell you why. My primary goal in any case is to make sure that the defendant and the prosecution gets a fair trial, period. I have seen from other cases around the country where cameras in the courtroom changed the way that the judge acted, the lawyers acted, some of the witnesses acted, and we were not going to have that here. We were going to really isolate the purpose for which we were here for, which is to have that fair trial, and cameras in the courtroom did not enter into that equation at all.
How much grief did you get from people around you about that decision?
I don't know. I don't listen to it. I just flat don't listen to what's going on the outside. I do what I think is right, no matter what decision that is. And I sleep well at night knowing if I follow the law, then everything works out like it's supposed to. And so these outside influences, all the noise from the outside, I really isolated myself from that in this case and in all cases, and just do my job the best I can following the law.
How do you think we're talking with the attorneys, other attorneys outside of this. How do you think they describe you?
Strict, no nonsense, fair. And that to me is the most important part. I know for a fact when I make a decision here, people are unhappy. What I hope is when they walk out the door that they think they got a fair trial. or a fair hearing or fair something. And if they do that, no matter what they think about me personally, then I've succeeded.
And you're okay with any of those characterizations?
I think they're fair.
Yeah.
All right. So that is a little bit of the judge's interview. And I think enough for us to show, like, is he speaking about the alternatives he could have issued and how he feels about the trial? Like, kind of makes you feel like, okay, you may have been impartial as the trial occurred, but now that you're speaking after it's over and there's still motions and stuff to be heard, maybe you're appearing a little biased, you know? You're making a public interview. You placed a gag order on this case and said no one with knowledge of any of the facts in the case can speak on it. But here you are doing an interview 2 days, 2 days after this public, the attorneys haven't spoken on it. The state hasn't spoken on it, but 2 days after. And then what I also found telling was a few days after this, he then says, oh, well, now the trial's over. You know, I feel like it's important for me to be transparent. Like, no, transparency was important the entire time, sir, which is why the defense is arguing you should have put these findings on the record as to why you didn't consider alternatives and to why you felt like the courtroom needed to be so limited, right? Because he says he had other judges in the courtroom that abided by his request to shut out the, to not do their hearings, right? So he could have worked around this seat issue, right? He could have used other courtrooms to have the hearings in. All right, let me go catch a super chat I missed, come back in. All News 110 sends a $5 super chat. Thank you so much for that super chat. He says Karmelo had something in his phone. I'm thinking maybe a picture like most young boys. Yeah, I agree. Most kids have pictures of, you know, with weapons or something like that in their cell phone. Doesn't mean that they're, you know, using those weapons for anything illegal, but they'll just pose with them, right? So that could have been it. We won't know because the defense did not list what that 75-page notice was, but the state filed 75 pages worth of extraneous offense information that they were going to try to keep out. So thank you so much, All News 10, for your $5 super chat. And Ayana I5W sends a $20 super chat. Thank you so much, Ayana. She says, hi, FitLawyerATL. I need your thoughts on IAC for Mr. Howard. Yes, I am going to go over his affidavit. Why do you think it wasn't included? Some others think not including IAC has crippled his chance and his motion. Would be denied, causing Melo to wait 3+ years for direct appeal. Okay, so you're talking about ineffective assistance of counsel. Well, I guess that, you know, in Georgia, it is required that you raise ineffective assistance counsel at your first time that you could raise it, which would be in this motion for new trial. In this case, though, Mike Howard is speaking about this gentleman's agreement. And so the issue that they're going with is not that this was ineffective assistance of counsel, but that counsel's effectiveness was halted by the state reneging on the gentleman's agreement. So the ineffective part would entering this gentleman's agreement be ineffective. And I don't know if they had 75 pages of extraneous information that he was able to keep out. Is that really ineffective? Or that's kind of what you want to happen, correct? But the ineffective part may have been in not getting the agreement written down, but you have a judge that is making everything off the record. And he was aware of the agreement. So, you know, ineffective assistance, a lot of times we raise those claims and it's a hindsight is 2020 thing, right? Because now that we see the state didn't follow the agreement, maybe it was better to get it in writing, but that's not necessarily saying at the time that decision was made, I'm ineffective. I'm thinking also they don't even have the entire record in this case. So there's no way for them to review objections in this case and whether or not something shouldn't have been allowed in, and you can't review that until you get a record, which is a transcript of, you know, what happened at the trial, right? You can't go into the judge's case file and look at it and determine whether or not certain objections could have been raised. So has he truly waived his ineffective assistance counsel claim? Maybe not, because then my argument would be I couldn't raise this argument until I had a record that showed me how counsel was ineffective so I could even make the argument. And they talk about that in this motion towards the end that, hey, look, we're writing this motion and we've raised 4 grounds, but there could be more that we don't even know about because the court reporters haven't transcribed the transcript from the trial or voir dire. So it's like, we don't know what the arguments are. So as a defense attorney, although you're right, the law usually requires you to raise this ineffective assistance of counsel claim at the first time that you're able to, but can you if you don't have a record? So if I have a record for appeal and I raise it there, maybe I haven't waived it because this is the first time that I can raise it. So it is like a technical legal thing. And this is what lawyers do. We're not arguing about what happened under the tent anymore. We're arguing about legal procedure. And that is why this is just about the law at this point. So that's a great question, Ayana. Thank you so much for your $20 super chat. And I guess we will just have to see how this plays out because not sure if you know, but we talked about it earlier and showed in the Texas Appeals Court in their rules, this motion doesn't even have to be ruled on, right? You would think any motion filed must be decided on, but no, the court says that they don't even have to rule on this motion. They could just wait it out with 75 days of basically ignoring it, and then the motion would just be denied as a matter of law. So great question, Ayana. I5W, thank you so much for the $20 super chat. I greatly appreciate that. And thank you for your input. And we'll just have to wait and see kind of how this plays out. But thank you so much for the super chat. All right, All News I-110 is back with a $2 super chat and says, I think Howard got backdoored. Yeah, he believed in what they were, this gentleman's agreement, and it backfired on him. And it happens sometimes. I've been in cases where I've given opposing counsel a reset, thinking I get the same in not reset, but an extension on maybe filing discovery, thinking I get the same thing. But I learned when it came time for me asking for an extension, I wasn't given that same grace. He bagged me up to a deadline that I couldn't then make something because I gave this, and you learn a lesson. You learn next time, don't get easy in the next. You don't make an agreement like that. So you live and learn. Doesn't mean I was ineffective at the time that I made the agreement. No, there was no reason not to allow extension of the time, but you learn hard lessons sometimes. So you just never know how that's going to go. Johnny Paul 685 sends a $10 super chat. Shout out Johnny Paul. He says, great commentary, sis. Thank you so much. I'm glad y'all are enjoying the show. We're legally speaking here with Fit today, and we're going through this motion. So if you're just tuning in, we have gone through the factual background. Now we're going to get into the legal argument. And when I mean that, I mean the case law that is going to rule the court's decision if they decide to even rule on this motion. So thank you so much, Johnny Paul 685 for that $10 super chat. Greatly appreciate it. Thank you so much. Let's see what else you all are saying in the chat. Yep, smash that like button for what? Mark Oliver. That's the setup. Need to read the whole motion before you pull up for your question. Smash the like button for Karmelo to stay in prison. I don't agree that he should stay in prison if the trial wasn't fair, but if it was, yeah, because I did a whole live saying the jury got it right based on the evidence that was presented. So Mindy Ann is a moderator here at the channel. Shout out, Mindy. Thank you so much for moderating. Thank you for your support. She says, smash the like button, subscribe, and share the live. After the live, hit the hype button. Yes, YouTube has this new hype button. So after this live, make sure you all hit that. All News 110 sends another $5 super chat. Shout out All News. Says, how often have you seen the DA edit a video before court? Every case. Every case. Because it's my presentation of evidence, right? So when I am presenting my side of the case, I'm going to show the clips that I need are pertinent, right? Like we got the full video there. The defense is welcome to when they get up, they can show you whatever clips from the video they want to see. But yeah, all the time. And the video that was used and released, you got to remember, like these are stationary cameras. They pan. So when the video starts and it's panning and you see the 10 across and you see the open, then it skips to you see Austin and then walking in. Obviously, that's a different camera. I am putting it together so that I can show you the story that I am laying out as what my theory of the case is. So all the time, just like when the defense gets up, they can then play the video from their perspective and they can focus and pan and zoom in and zoom out or whatever they want to, as long as the full video has been turned over to the defense and everyone has it, then we can put up. So edit means, I don't know what you presume by edit. Are you trying to say fake? I added something in. No, but if I'm cutting to the angles that I feel is pertinent, if you feel like there's another part of the case that is, then you play it on your turn. That's how that works. That's so every day. Yep. That's not something that wasn't normal. At For Dread sends a $10 super chat. I'm loving the questions, so y'all keep bringing them in. And as you're asking these questions, I am going to cut back to the legal argument of this motion, but I want to get the super chats in, show appreciation for people who are supporting the channel. We've been on now for 2 hours and 44 minutes, getting into a lot. We had a court reporter that came up live at the beginning of the live that talked about how some of this stuff in this case is unusual. So I definitely want to spend some time here on the super chats, and we're going to get back to the motion. So at For Dread sends a $10 super chat, says, one last question. With the Bill Werski and defendant second chair Toby Shook were allegedly firm partners previously. That's who made this agreement. Is that conflict of interest? Is backdoor for real? Thank you so much for the $10 super chat. So as we'll read in Mike Howard's affidavit, Toby Shook may have taken the first phone call to start making this agreement, but Mike Howard participated in those meetings as well. And it's not uncommon. They are from Dallas County. So it's not uncommon that the DA and the defense attorney used to work together, right? I started in the public defender's office, so there are going to be plenty of DAs that are now in private practice that I've worked with in the past. So that's not unusual. Judge Whitaker sat on the YSL trial. She used to be in the DA's office of Fulton County, which is the actual DA's office that prosecuted the case, right? There's not a conflict. She's no longer in the DA's office, and she wasn't in the DA's office when the case was being prosecuted. So, people were really looking for, and that's what you do, you're looking for a needle in a haystack, but those connections are not conflicts because it happens. I go to dinner with judges, lunch with judges all the time, and I show up in a courtroom. That doesn't mean we have an automatic bias because we're friendly outside of this court setting. So unless you have proof of something occurring, no, that's pretty typical because people move around in the legal sector, and it's a small community. So nope, great question. Thank you for that super chat. But no, that wasn't a conflict of interest or, any reasoning about why this deal fell through. Aries 1-1878 says, when I heard about the gentleman's agreement in chambers, what popped into my head was, is this a collaboration of the judge, prosecutor, and defense in an attempt to tamper with evidence? Shout out. Thank you so much for your question. You also sent a Cash App earlier, so thank you again for that. So I don't think so. If you hear in what you take away from the interview of Judge Roach, and we looked at a little bit of that, is that he really feels, and he was ex-military. He is serving as a judge. He's been on the bench for almost 20 years. He has never been appealed or overturned on a case. And he prides himself on looking at what the law is and applying it. So even if this motion is successful, I definitely don't think there's any kind of working together with everyone where the judge is purposely not doing something fair. No, I think he looked at the law in his interpretation. He feels like he handled things correctly, right? But sometimes you don't, and the arguments can be made. And if it's later found that's the case, I don't think that that's going to be what is going to, that there was any, we're all colluding together to kind of tamper with evidence. No, I think he thought this was his duty. And I think he thought he was making every decision he made rightfully so, and to protect the minors testifying and all of that. I believe all of that. You can listen to how he speaks about his duty to, handle these cases and how he was, grateful to get the case. And this is my duty. And even reading his letter, you don't get a sense of that he's underhanded or doing things, trying to tailor what happens in this case. He doesn't know the Metcalfs before this case happened, but I think he just may have made a mistake, and it just depends on if that's what the law says. If the law says you were supposed to do 4 things and you only did 3 and not the 4th, I don't think he intentionally didn't do the 4th. I just think that his decision was what it was, and just happens to be a good argument that it doesn't fit the law. So I definitely don't think that in the defense didn't raise that in their motion to recuse. It's not anything like that. It's just you went on the news after and you wrote this letter. And so you're showing a bias about the conviction of this case after the fact. And so we don't think that you should stay in making future rulings. They don't speak on anything that he did biased during the trial. So I definitely do not believe that he cooperated with them to make this. Is just how this shook out. Let's see. Well, Reese's Cup 444 says, so they edit the video to where we don't know what's true. Correct, because we weren't in the courtroom and we didn't get to go to ISD and see their video there. But they had hearings, you know, public wasn't allowed, and there's no court reporter, but there was some discussion on the, you know, about what was going to be showed with the videos, what's the best evidence rule, what can be presented. We just weren't a party to that. And that's some of Karmelo's argument as to why this wasn't a fair trial. Ayana I5W, shout out again. Thank you so much for another $10 super chat. Says, thanks for your answers. So you're saying even if an ineffective assistance of counsel was raised now, Texas law allows courts to not rule at all, denying it even if there's a claim. So it wasn't raised in this motion for new trial. What I was saying that if they don't have a record yet, so a record isn't created. So let's say that they do raise it in the appeals court, they would have to show how it's timely. And I believe their argument would be, we could not raise that issue because we did not see that issue because we didn't have a record to see it in. So you don't know that that is an issue until you get the record, which is the transcript, which hasn't been made yet. So that's what I'm saying. And I hope that further answers that question. All right. So we're going to get back into the motion, going over this motion for new trial. And right before I do, let me drop this last super chat. Shout out to All News 110, sends a $2 super chat, says, when you rush things, it normally backfires. And that could be no truer, because that's what happened in the YSL case with Antonio Sledge. You know, we filed a motion to argue that his the new sentence was still void because it wasn't done in open court. He wasn't there when he was resentenced. It was something that was rushed, and the court agreed and said, you're right. You know, his constitutional rights were violated. Send it back. It has to be done in open court. So you're right. When you move fast on things, a lot of times you allow errors to occur. All right, so we're going to go back to the motion, and now we're getting into the legal arguments that the defense raised. Did I pull up a different window? I think I did, but you know what? We're going to make this work because I can go back and forth to the exhibits. I don't really like the way that looks. Okay, hold on, y'all. Let me pull up the right one. Okay, so before we go to we're in the legal argument, but I want to go over the amended order regulating. This is the first exhibit that's added. So this is the order that lends to the defense's first argument. So this amended order was filed May 18, 2026, and it says amended order regulating trial proceedings, media access, security, and courtroom decorum. On this day, the court enters this order to govern all aspects of the trial proceedings in this matter. Due to the significant public and media interest in this case, the court finds that specific procedures are necessary to ensure the defendant's right to a fair and impartial trial, the orderly administration of justice, the safety and security of all participants, and reasonable public access consistent with constitutional requirements. The court has considered the directives set forth in Waller versus Georgia and Shepard versus Maxwell, as well as all applicable constitutional provisions, statutes, and case law. The court finds that this case has generated substantial public and media attention, and that unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial. The court further finds that reasonable time, place, and manner restrictions are necessary and appropriate, and that while the media and public retain the right to attend proceedings, such access is subject to the limitations set forth in this order. The courtroom shall open each day of trial at 8:30. Each entry shall be permitted beginning at 8:30 a.m. for members of the media, 8:40 a.m. for designated family members, and 8:50 a.m. for members of the general public. No more than 9 members of the media shall be permitted in the courtroom at any one time. Seating shall be on a space available basis. The courtroom doors shall close promptly at 9 a.m., and individuals arriving after that time shall not be admitted until a recess. Once admitted into the courtroom, no person shall leave and re-enter during proceedings except during a recess. The determination of who qualifies as a member of the media, which media representatives will be permitted access to the courtroom, and the allocation of media seating shall be made with the assistance of the court-appointed public information officer for the court. Media representatives must comply with all credentialing requirements established by that officer. The court will not intervene in or resolve disputes among members of the media regarding access or seating. The court has appointed Steve Stoller as the appointed public information officer. No person, including members of the media, shall photograph, record, or otherwise visually capture the images of any witness, prospective witness, juror, or prospective juror, nor shall any person publish or disclose the name, identity, or personal information of any witness who is a minor, juror, or prospective juror. No person shall communicate or attempt to communicate with any witness, prospective witness, juror, or prospective juror prior to the return of a final verdict. No interviews of witnesses, jurors, or prospective jurors shall occur until after the conclusion of the trial and only if voluntarily agreed to by the person. Photography, video recording, audio recording, live streaming, or any other form of recording or transmission of courtroom proceedings is strictly prohibited. No cell phones or other electronic devices will be permitted into the courtroom. Electronic devices may be permitted in the courtroom by the media for note-taking purposes only, subject to approval by the court, and must remain silent at all times. No media interviews shall be conducted in the courtroom or hallways or in any security-restricted areas of the courthouse. All interviews must take place only in designated areas approved by the court and coordinated with the assistance of the court-appointed public information office. Media activity must not interfere with courthouse operations, security measures, or the orderly conduct of proceedings. All persons present in the courtroom shall remain silent and respectful at all times. No talking, gestures, facial expressions, emotional outbursts, or other reactions to testimony, rulings, or proceedings shall be permitted. No reading of newspapers, books, or other materials unrelated to the proceedings is allowed. No food, drink, or chewing gum shall be permitted except as authorized by the court. All persons attending the proceedings must be dressed in appropriate business attire. Clothing or items displaying messages, logos, symbols, or images related to the case or that otherwise distract or potentially prejudicial are prohibited. Hats, caps are prohibited. No signs, banners, or demonstrative materials may be brought into or displayed within the courtroom or courthouse. No member of the public or the media shall be permitted beyond the bar, separating the gallery from the intersection of the courtroom. That area is limited to counsel parties, court personnel, law enforcement officers involved in the case, witnesses when called, jurors, and other individuals authorized in the court. The trial should be conducted in a secured environment. All persons entering the courthouse should be subject to security screening. Additional security measures may be implemented as deemed necessary by the Collin County Sheriff's Office. No weapons of any kind shall be permitted. How much longer is this? Because this is long. All right, members of the public and media shall not congregate in the hallways. All persons must comply with the directions of court staff. The order prohibiting extrajudicial statements or gag orders signed July 28th will remain in force until the completion of the trial. As stated in the order, any violation can result in contempt, fines, attorney discipline, or other remedies. Any exhibits submitted during trial should not be released to the public or media until the conclusion of the trial. Finally, as reflected on the attached map, the court has designated certain areas around the exterior of the courthouse as restricted access. Those areas colored in red will be secured for courthouse operations and security and will not be open for use by the general public or media. Furthermore, an individual or group should not assemble or congregate in areas that block ingress, egress of vehicular movement or pedestrian traffic. Any individual or group engaging in speech activities such as protests, demonstrations on Collin County premises shall at all times comply with applicable federal, state, county, city, or other local laws. Collin County Courthouse and the listed address shall be under a temporary curfew beginning May 31st. The curfew will be from 11 to 6 a.m. every day. Curfew means the designated time after which access to or movement within the entire Collin County Courthouse campus includes parking lots, sidewalks, green space, etc. Any violation of this order may result in immediate removal from the courtroom, courthouse, or courthouse grounds, revocation of media credentials or access, imposition of sanctions, including contempt of court. No warning is required prior to enforcement of this order. And the Collin County Sheriff's Office and other designated law enforcement personnel are ordered to ensure compliance. And it says that this order may be modified at any time. Now, I'm going back up to the top. So the order states that it considered the directives set forth in Waller versus Georgia and Shepard. And it finds that the case, so this is the reasons that they are closing the court, is that because of the media attention, this unrestricted access may compromise courtroom security, juror privacy, and the defendant's right to a fair trial. And so what the defense is arguing is that Waller versus Georgia requires that certain findings be put on the record. Okay, so welcome to Law School 101. All right, so many people think we go to law school to learn how to argue in court and file motions and hearings, and it's simply not. It's not. This is what we do in law school. The law is set out through cases that are filed in Supreme Court, if it goes up that far. But something happens on the lower court, they appeal it to the Court of Appeals, they issue a ruling. Then if you don't agree with that ruling, you can take it up to the states, like Georgia Supreme Court of Appeals, which is what happened in this case. They didn't like that ruling, and then they issued cert from the Supreme Court of the United States, and they issued a ruling in this case. That's why this says Supreme Court of the United States, even though this is a Waller versus Georgia out of Fulton County, Georgia case. Okay, so we go to law school, we learn how to read these cases, and we look for the holdings of these cases. The holdings tell us what the court decides after they listen to the arguments of the state and the defense in the case, and they issue a rule that has to be applied to every case that follows this case. Okay, so I have gone through and kind of acted like I was in law school and highlighted the important parts of this. If I wanted to go back and review it, these were some highlight moments. And then at the end, I put in green here what the court rules has to occur because of this case. Law School 101, okay? So that is what the defense is doing in their motion. So they have said that this order that I just went through and read that the judge issued did not follow what Waller versus Georgia requires when you're placing restrictions on the courtroom. So this is it wasn't public, nobody could come in. No, it was open, but it was highly restricted. Only 27 to 32 members of the public could come and watch something that had been broadcast on national media news for over a year. People had been talking about this case on YouTube. So there was tons of public interest in this case. And what they're saying is that due to the judge's restrictions and the order that we just read, he was supposed to follow certain rules. So Waller versus Georgia cites another case that had occurred before it called Press Enterprise. And what it said and what this court said in Waller is that these are the parameters that have to happen in the case. The parties seeking to close the hearing, whatever hearing it is, in this case dealt with a motion to suppress. That was the issue in Waller. There was a case where there were wiretaps that were being used. I think, was this the wiretap? Yeah. Wiretaps were being used in this case. And the court, there was a motion to suppress that was held, right? What just happened? Oh, I froze. Hold on. Oh, no. What just happened? Okay, I'm back. It just froze. I don't know. I guess I've been on too long. It's 3 hours. Okay. So let me remove. Okay. So in the Waller case, there was a case where they were using wiretaps. And when they were having this trial, there were certain people that the state said that are on these wiretaps that haven't been indicted yet or are not going to trial at this time. So judge, because of that, this motion to suppress hearing that's happening right before trial needs to be closed for the public because so they won't hear these wiretaps. There's a law that says if any of the wiretap is published in court and is proven to be irrelevant to this case, then it could be deemed inadmissible in the future. So they're like, we don't want to mess any of this up. So we need to close this motion hearing to the public. The judge agreed, closed the motion hearing. The motion hearing lasted 7 days. However, the testimony about the wiretaps only lasted for 2.5 hours. So the defendant, after being convicted at trial, not of RICO, they got not guilty on that, but on some underlying charges, they filed this motion arguing that the motion hearing should have been open due to the Sixth Amendment right to a public trial. And therefore, we need to go back and get a new trial for that reason. So that is the basis. And that's some of my highlights that I went through, how I can recite that back to you. I read the case. Okay. So that's what happened in this case. And the court said that before you can close the hearing, you have to have this you have to go through these facts on the record. You have to say the party seeking to close the hearing must advance an overriding interest that is likely to be prejudiced. The closure must be no broader than necessary to protect that interest. The trial court must consider reasonable alternatives to closing the proceeding, and it must make findings adequate to support the closure. That was the Supreme Court's ruling in Waller. I'm going to remove that because I have put all of it into, I can't share that way. Go back, hold on. Into a PowerPoint so we can see it easily. All right. So 5 minute work, okay, baby? I'm getting ready over here, okay? So what this says is Waller versus Georgia. This is the site. You can go Google it. Claude is better than ChatGPT because ChatGPT makes up things. So use Claude. If you're going to pull it that way, you can just Google Waller versus Georgia, put in this U.S. site, and it'll bring the case up. It says the party seeking to close the hearing must advance an overriding interest that is likely to be prejudiced. Let me do this and make it even bigger. All right. Oh, wait a minute. Not lose myself. Okay, let me leave it right here. Doing too much. All right. So first, in this case, the defense argues that who raised the issue? Like, nobody. The defense didn't raise this. And the state didn't raise this. They are parties to the case. The judge is not a party to the case. It's state of Georgia, state of Texas versus Karmelo. Those are the parties in the case. Neither party raised this issue asking for anything to be sealed or for the media to be kept out of this. Okay, that was all the judge sua sponte issuing this order, meaning of his own will. So number one wasn't met. They're also saying that, okay, the judge did this on his own. He is supposed to talk about what overriding interests would be prejudiced by having this hearing open. He spoke to, gave like a thing about, and we'll go back to the order about, matter of fact, let me pull it up as I'm talking to you all so I can reference that here. Oh, I got a lot of stuff open. So they're saying that wasn't done in the judge's underlining order. And so that is something that's missing. Next, okay, I'm doing too much. Let me focus. Next, it says the closure must be no broader than necessary to protect that interest. So what was the interest here that was trying to be protected, right? If it was underage witnesses, could we have just done an audio feed that hides their face? What interest were we protecting, and was it broad or narrow to protect just that interest? There's nothing in the order that kind of speaks to that, right? Because there was no discussion of alternatives. It just says what we're not going to have. We're not going to have video, live feed, all of that. It didn't say that I considered those alternatives and using video feed would cause blah, blah, blah. Like none of that is in the order. And they're saying Waller requires that finding of facts on the record. And so that's the issue. Shout out Mindy Ann 44. Sending y'all a link to the case so you don't even have to go look for it. Just go to the chat, hit that link. Shout out to an amazing moderator, Mindy Ann 44, and shout out to Kia Elder 305 and a couple. It's another moderator that's in the chat. Thank you all so much for your help during this live. So part 3, the trial court must consider reasonable alternatives to closing the proceeding. So you can't just say, I close it because these issues exist, even if your issues are right? You say what the court said in the order is correct. These are the issues. This is why we're closing it. Is correct. The trial court says you still must consider reasonable alternatives to closing the proceeding. So you have to consider, can we do an overflow room? Guess what? They could. There was an overflow room for the second day of trial for jury selection. What changed? Why didn't we have an overflow room for the testimony? Okay, so what changed? The media's attention is still there. Jurors were able to be seen by the public. I think it was like 100 people there for the jury selection. So what's changed? Oh, witnesses are testifying now. The trial starting. You don't want the witnesses to change their testimony because the public's looking. What can we do? Audio feed. We can do that, or we can blur out the witnesses' faces. We don't ever have to see them. We don't ever have to see them testify. There were several witnesses in the YSL case that didn't want to be seen. There were undercover officers. There were just witnesses that were, for all intents and purposes, snitching, whatever, that didn't want to be seen, right? So they didn't want their face to be shown, or they were victims that had to testify about the crimes that they had been committed against themselves, and they were being used to create this RICO case, right? And they didn't want their pictures to be shown. They'd already been victims of a crime, so we didn't show them. We didn't know what their names were. They were called to testify. The cameras were cut. The feed came back up when they're on the stand, and it's like the bottom of their shoes or their knees. Like, we're not seeing them. So there were alternatives, and the order didn't speak to any consideration about those alternatives. Number 4, the trial court must make findings adequate to support the closure. So while there may be some type of findings listed in the judge's order, right? Because he says that, and let's go back to that. Hopefully I can do this fast. The judge. Can I do this fast, y'all? Bear with me. Where is it at? It's not going fast, is it? Okay, yeah, that's not what I'm trying to pull up, but I'm going to work on trying to figure out where I had it. But back in the order that we just reviewed, right, we saw that that wasn't done in that order. There was a reasoning listed, but what the defense is arguing is that that reasoning wasn't sufficient. And so those finding of facts weren't in the order. And guess what? A lot of the issue with why the finding of facts and why the evidence wasn't there was because there was no hearing on this. The state didn't ask for this. The defense didn't ask for this. The judge just decided this on his own. And while he may have thought that he was covering the law and putting everything in, they're saying under Waller v. Georgia, he did not. The second case that they're making this argument on, and let me go pull up that case, is Presley. Now, I told you that Waller versus Georgia, it was a motion to suppress case. And basically, the court there was saying that even motion to suppress requires being to the public. Now, why is that an argument in this case? If you'll remember, the motion hearings in this case were not public. They were held in chambers without a court reporter. Remember, the judge was making the parties not e-file things into the documents. They were actually just hand delivering stuff to each other and arguing it in court. Where the court says in Waller that motion to suppress hearings fall under this public trial requirement of the Constitution. So if the court that's hearing this motion for new trial says, those cases were supposed to be held in public and they weren't, that could be a basis for this motion to be granted and a new trial granted, because the law said in Waller that when this happens, the court has to give a new trial. Go back and show that in the actual case so you can see that part, so we can make sure that, the law is being highlighted properly. If I can get back to my Adobe screen that has everything. Okay, here we go. All right, so this was our Waller case, and then let me see if I can get to it and show you all. So in Waller, they were asking for the judge to overturn the entire conviction, but the Supreme Court in Waller said that because the violation only applied to this suppression hearing, that the remedy is right here, should be appropriate to the violation. So if after a new suppression hearing, essentially the same evidence is suppressed, a new trial presumably will be a windfall. So that's not fair, right? So if you got a new motion to suppress that is open to the public, but nothing changed, then your fairness was just to have a new motion to suppress, not a whole new trial. But it says that if I don't get to it, and it unless the state substantially alters the evidence it presents to support the searches and wiretaps, significant portions of a new suppression hearing must be open to the public. We remand to the state courts to decide what portions, if any, may be closed. This decision should be made in light of conditions at the time of the new hearing, and only interests that still justify closure should be considered. A new trial need be held only if a new public suppression hearing results in the suppression of material evidence not suppressed at the first trial or in some other material change. So in Karmelo's case, if they're only relying on the motion to suppress and that wasn't public, because it wasn't. So if the court finds that it should have been, all he gets is to rehave the motion to suppress unless the state uses new evidence in the new motion or the result of it changes one of the parties' positions in the case. Like say more evidence is kept out this time than not last time, then that's a material change. So then you do go to having a new trial, okay? So that was the issue in Waller. The next case we're going to look at is that the defense argues is Presley v. Georgia, also another Georgia case, and this case is out of DeKalb County. This case was an actual trial. The defendant was convicted of trafficking, and the issue here was that the defendant's uncle was kept out of the voir dire. So that is the jury selection process. That day that they were doing jury selection, the uncle came into court. He was the only person that wasn't a jury member. The judge was like, who is that? And there was this whole conversation on the record, because that is how you can appeal, because you need a record. And there was this conversation about, hey, this is the uncle, he's here to observe. And they're like, well, the uncle can certainly come back once the trial starts. So the judge kicked the uncle out of jury selection and said he can only come back when the trial starts. And the court's like, wait a minute. So that's the issue that's presented. And it goes all the way up to the Supreme Court, because the Court of Appeals issues something. They ask for cert to the Georgia Supreme Court. The Georgia Supreme Court rules in the state's favor, and then the defendant files cert on a pauper's affidavit to the Supreme Court. They take the case up because they're like, wait a minute, we thought we kind of answered this, but maybe we have been silent. So let's be clear and issue this ruling so you all know that the right to a public trial also goes to jury selection. And also the requirement that the judge has to make, and let's get down to the holding in this case, which I put in green for you. Okay. And this is what we do every day in law school, okay? And we'll go home one night and we have to read 100 pages of these cases, like Miranda versus Arizona, the case that comes down and says that when you're arrested by a cop and before you're interrogated, you have to read Miranda and has to say you have the right to remain silent. Anything you say that comes from a Supreme Court case that came out of Arizona, but it applies to all of the U.S., right? Because the Supreme Court issued it down. And so that tells us how we have to behave in those circumstances, right? So this case says, this was the holding of Presley. They weren't even going to rule on the second claim in this case, because even assuming arguendo that the trial court had an overriding interest in closing voir dire, it was still incumbent upon it to consider all reasonable alternatives to closure. It did not, and this is all this court needs to decide. So you see, it's a very narrow issue. What they're looking at in Presley is, did the court, in making their decision to close the courtroom on the record, consider reasonable alternatives? And in that case, and I'm sharing my PowerPoint so we can see the breakdown. Move to the second one. Okay. This is Presley, and moderators, you can go find this is the U.S. site, and you can share this case here. This is the other defense's case. They're saying the Sixth Amendment's public trial right extends to voir dire. Yes, that's jury selection. The trial court must consider reasonable alternatives to closure sua sponte, meaning on its own. So if either side, when they ask for the court to be closed, if they don't give reasonable alternatives, the court still itself has to consider. That's pertinent here because this judge decided this closing all on his own. No side asked for it. So even though no side asked for it and there wasn't a hearing, the law still required him to put on the record and consider alternatives. And the order was silent to that. It didn't speak to anything. Like, it didn't say, I considered overflow room. And we're saying, no, you can't do an overflow room because the courthouse only has this much space. Or I considered audio being broadcast out to the world, but I changed my mind because it wouldn't protect this particular interest. Or I considered video and that wouldn't protect this interest. Like, that reasonable alternative consideration has to occur. The judge has to do it, and it has to be on the record. It has to be in the order. And what the defense says is that this order is silent to it. And so because it's silent to it, then the remedy, because this applied to the entire trial, the gentleman's agreement, the motion to suppress hearings, voir dire was open, right? They opened that little small portion, but when it came to the testimony, it was back closed again. It was closed let me rephrase. It was restricted. Okay. Yes, it was open a little bit, but they're saying it was restricted and these things weren't done. So if the district court, whatever judge ends up hearing this, had they not filed a motion to recuse, Judge Roach himself would have had to hear this motion, but it's up in the air. I don't know who's going to hear it yet. But if they have a hearing on this, this is what they're going to be looking for and considering is, did the judge's order address these constraints? Okay. Now that I've given you those two laws and we've broken them down like a law student 101, right? We are going to go back to the state's brief and look at what they did as they made this argument, because they also, believe it or not, there have been two cases from 2026 that have been decided by the Court of Appeals, who would get this court next this year, right before this trial. One I think was like January, one was May, that the defense they referenced in their motion that overturned the convictions for some of these similar things. One was an actual capital murder conviction that was overturned, convictions gone, and the court had to go back and redo it again because they put these restrictions in place. There was another case, it was a theft case of like $150,000 to $300,000 that the person was being charged with. And that was their argument that, wait a minute, they kept something closed. And so the court issues in that another ruling saying Waller and Presley have to be held. And if they're not, then, that's an issue. So let me go. Oh, okay. This is the window. And then let me get to the case, back to the motion. Okay, there we go. All right. So let me take us back up to the actual body of the motion when they start their argument. Now, I've given you, their basis of the cases, so we're not going to go through that again, but I'm just going to read some important parts I want you to hear from their argument. So, they first start out showing that this motion is timely filed. The court ruled. All right, let me put myself down. Okay, June 9th, so they had 30 days to file this order. June 4th, the trial court signed the certification of defendant's right of appeal. That is with the Texas Appeal Court. Remember, this is a motion for new trial that's filed back in the district court. This motion is timely filed, and they talk about the Texas. Remember, we went over the rules of appellate procedure, and we went over section 21.4, and it talked about how, the timelines and everything for filing this motion. Just pop back down. Legally speaking over here now, look, I'm showing you everything. So remember, we went over this, and it told you how the motion for new trial had to be filed in the timeline. The court back on this motion for new trial is saying we followed that procedure. Okay, it's done in time. We've already submitted it to the court within the 10 days. They talk about the 75th day. Okay. So this says that the 75th day falls on Sunday, August 23rd, because it's based on the day from the time sentence was pronounced. So my apologies on that. Earlier I said September 21st because I was basing the 75 from the day the motion was filed. I stand corrected. It's August 23rd. And whenever a deadline falls on a weekend, it goes to that Monday after. But the defense is like, look, we don't even want to get into what the day is. So kind of give us the hearing by Friday, August 21st. So that makes sure we're clear of the deadline. That's what they're requesting. And they're also requesting that the interim judge or whatever other judge hears it, because of course, remember, they filed a motion to recuse Judge Roach. This motion is supported by affidavit because it raises matters outside the trial record. Remember, we talked about the court reporter not transcribing anything, a lot of things happening in chambers outside of the presence of the court reporter. So they're using those affidavits so that they can put into the record what occurred. And then they get into their first ground. And that is that the trial court violated the defendant's Sixth Amendment right to a public trial by materially restricting public access without findings and alternatives required by Waller, Presley, and Stricker. Now, I've already gone through the Waller arguments. Y'all know the law better than anybody, right? So now when you go back to Facebook, you can argue with knowledge. Okay. So, and you know what this motion is all about. And so they talk about here the public's right to the trial and, you know, how the courts have spoken on this in the past, like why it's so important for people to be a part of a trial. One, the public can rest to know that everything was done correctly when they have access to the trial, right? We know that there wasn't any shady business, all that kind of stuff. So we can make sure the defendant's rights were protected. And witnesses will tell the truth when they know that they're coming in and being seen in front of people to testify, right? They're going to be less likely to lie because the public is going to have access to their testimony and know whether or not it was truthful based on what was said, like in police reports and provided earlier in other evidence. So they just go in and talk about the rights and, you know, how they come into play. Because I want to get to the cases that they reference that have come down from the Texas Court of Appeals. So this is a case, Stricker v. State. The most directly, and this is from the defense's argument. So I'm skipping over. I've already showed y'all what Waller requires, the 4 things there, and I've shown you what Presley requires. So they say now that the most directly applicable appellate authority on this precise question is a published decision of this Court of Appeals. So basically the Court of Appeals that would handle this case decided Stricker just months prior to this Karmelo trial starting. So they're like, we got a good example of what's required here. In Stricker v. State, the Fifth Court of Appeals held that a trial court violated the defendant's Sixth Amendment right to a public trial and ordered a new trial where the court, citing courtroom space and a generalized security concern, refused to seat a single member of the public during jury selection without first considering the reasonable alternatives the law requires. This is a Stricker v. State case. Here's the citation. It's from January 29th out of Dallas. Like, it's when sites have like the number and Lexis is another online source that we use as attorneys. It's Westlaw. That's what I like and use. But in law school, we use Lexis. So it's whichever one you purchase. They all hold every case in every jurisdiction that's decided by an appellate court. And so when it's a new order, sometimes it has this citation when it's been on the system longer to get the numbers that you saw for the other 2 cases. But anywho, it's a case that the Court of Appeals decided January 29th of 26, very recent. The defense is arguing this, okay? I'm sure the state would argue opposite, but we're talking about the defense's motion. Because Stricker was designated for publication under Texas Rule of Appellate Procedure, it is a published memorandum opinion of this Court of Appeals and thus the most directly applicable appellate authority on the public trial question. And having been issued months before this trial, it was available for the trial court's review when the court entered the amended order and closed these proceedings. The closure here was therefore not the resolution of an unsettled opinion. It ran headlong into a recent published decision of this very court that reviews this one. Every justification the Fifth Court rejected in Stricker is a justification the court invoked here. And that rejection was on far more extreme facts. There, In Strichter, the court refused to seat one observer because the veneer filled the gallery, meaning the jury took up the gallery, so they didn't put anybody in, which is kind of similar to the Presley case. Remember the one uncle being kept out of jury selection. The court rationed the general public to roughly 24 rotating seats across every stage of a nationally watched murder trial. Sounds familiar, right? Because the court here rationed 27 to 32 seats ended up being for the public. Here in this Strichter case, there were 24 rotating seats for the public at every stage. There, in Strichter, the trial court declined to split voir dire to make room, explaining, I'm not going to spend 2 days picking a jury. The Fifth Court held that space and overcrowding, though legitimate concerns, must now outweigh a defendant's Sixth Amendment rights because there are readily available alternatives, and that neither convenience nor judicial economy can constitute an overriding interest. Here, meaning in Karmelo's case, the record in the court's own public statements at least raise a fact issue that reasonable alternatives existed. Remember, the judge said in his interview, that's the court's public statements, that hindsight, maybe I should have considered audio feed. He himself in an interview after the trial gives an alternative that existed, yet in his order, he didn't speak to this alternative or if he considered it and why he didn't put it in place. So the record in the court's own public statements at least raise a fact issue that reasonable alternatives existed, including larger or additional courtroom space. We get that because remember, he said the other judges were working with him and not having their court appearances during this time, which means their courtrooms were left open. A live audio or video feed, he talks about that in his interview, and the overflow accommodation the court used during jury selection and then withdrew. Like you literally did an alternative for 2 days and then took it back. And there's no order speaking as to why your alternative was considered okay for jury selection and not. My guess is the judge may have looked at one of these cases, the Presley case, seen the issues on the jury selection and say, hey, I got that covered. We'll do an overflow room for jury selection. But when it comes to the trial, my interest changed because now I got kids testifying. So that's going to be my difference. Guess what? That may have been legal, but you didn't put it on the record. You didn't put it in your order. You didn't have a hearing to talk about the reasonable alternatives and what interest would still be prejudiced if you didn't take those steps. So that's what the defense is saying, bro, you got to do more than what you did. That's what the argument here is. Is it viable? I don't know, but that's what the defense's argument. So here, the record and the court's own public statements at least raise a fact issue that reasonable alternatives existed, including larger or additional courtroom space, a live audio or video feed, and the overflow accommodation the court used during jury selection and then withdrew. And where the Strichter court faulted the trial judge for failing to identify a specific concrete fact of danger, the order here rests on the same generic recital that unrestricted access may compromise security, entered without a hearing. So what they're saying is, in Strichter, that judge said, unrestricted access may compromise security. So did the judge in this case. It's the same thing he said. So it's like, if that wasn't enough in Strichter, how can it be enough in Karmelo's case? The defense is arguing it's not. So judge, it fails on that argument. So therefore, the conviction should be overturned. That's what the defense is arguing. So they say if excluding a single member of the public from jury selection required a new trial in Strichter, then the recurring exclusion of numerous members of the public from testimony and punishment after the court withdrew an available overflow alternative and made no Waller findings cannot be dismissed as trivial. So if this error was made in Karmelo's case, it can't be trivial. It has to lead in a new trial because that's what the court has already said in Waller, Presley, and now in Strichter, which is a case out of the Texas Court of Appeals. The second case they mentioned in their legal argument is Hernandez v. State. Now, the Hernandez case, I think this is a theft case. A second court of appeals reached the same, so not the same court of appeals that Karmelo's case would go to, but a second court of appeals. They reached the same result weeks later after this stricter case on facts materially indistinguishable from the space rationale invoked in Karmelo's case. In Hernandez v. State, the 14th Court of Appeals reversed a capital murder conviction and ordered a new trial because the trial court closed voir dire to the defendant's family and the public, citing an 80-person veneer and a lack of physical space, without conducting a Waller analysis, making findings, or considering reasonable alternatives. Presley. So Hernandez v. State, May 19, 2026. Mind you, this trial starts June 9th. So this is something that just comes down recently, right before Karmelo's case. The court held that concerns about space must not outweigh a defendant's Sixth Amendment rights, and admonished that trial courts are expected to know and apply this basic rule. Strichter and Hernandez are thus recent, published Texas decisions holding that a space-based closure of jury selection entered without Waller findings or the consideration of reasonable alternatives is structural error requiring a new trial. And both were available for this court's review before this trial. Strichter and Hernandez addressed the merits of a space-based closure. Dixon and the preservation authorities addressed when the complaint must be raised. Defendant satisfies both rules here because the closure was administered off the record, and as applied exclusion became apparently only after trial. So what the defense says is we're raising this, in a timely fashion, which is required by law. Now, this is going to be a point of contention that I know the state will raise. Is this timely? There is no way the court was able to know, the defense attorney was able to know that the public was being kept out, that Thelma Anderson, I think her name was, or whoever those people they got the affidavits. There's no way I can know that if I'm on trial and I'm defending my client. But what I do know is the grandmother and aunt aren't letting in, right? Because isn't my client telling me daily, hey, my folks wouldn't let in. So if the court finds that the defense did not raise this issue during the trial court, we don't know because we don't have a record, right? There's no court reporter transcript of things, so we don't know what, when, or if this ever was objected to. Remember, because the pretrial hearings that were held were in chambers off the record. But let's say they say the defense didn't raise this in time, then this argument goes away. But if they do say first, if they do decide to hear this motion, because they can ignore it for 75 days and it's automatically denied, and then they would take it up on the Court of Appeals. But if they do have a hearing on this, that's the first thing they got to decide. One, does the court agree that restrictions were put in place? Does the trial court say, like, I can look at this order and say restrictions are put in place? I think that's pretty obvious. Then they got to look at, did the defense object to this in a timely manner? The defense is arguing, hey, look, we didn't know about this until after the trial, and we got these affidavits and we got these declarations, so it's the first time we could raise this issue. But is that true? Was there some knowledge, right? Because the amended order was issued before trial. Did the defense object then? I mean, at the time that this is issued that it's being restrictive and it doesn't contain Waller arguments because the order was done prior to trial, right? So what I'm saying, what the defense is saying the judge didn't do, it exists prior to trial starting. So was that objection made at that time? What the defense also argues to kind of cover that in their motion is that, well, the order says one thing, but the practice of the order, what the public information officer put in place actually was even more restrictive. So I didn't have any knowledge of that until after the trial, and I got these affidavits, and then I could raise this issue. And we didn't know until trial started that the judge had this overflow room for jury selection and was going to take it away for the trial. So we didn't know to raise that issue. So that'll be something that the state, I'm sure, argues back in their motion when they come back is at whether this is a timely issue that's being raised. And then if it is, they're going to apply. And were these Waller factors done? Did Waller requires that the first one, how do you get the party seeking to close the hearing must advance an overriding interest that is likely to be prejudiced? What was this overriding interest that was likely to be prejudiced? And the parties didn't ask for this. The judge did this. But even though the judge did it on his own, the closure can't be broader than necessary. What was the overriding interest that was going to be prejudiced? We didn't see that in that order, right? Let me go back to the order. I'm not going to read the whole thing because he just lists the overriding interest in the first paragraph. So let's go back. Now that you see what the law says on this overriding interest, do you think that the judge covered that in his order? So he says, due to the significant public and media interest in this case, the court finds that specific procedures are necessary to ensure the defendant's right to a fair trial. The orderly administration of justice, the safety and security of all participants, and reasonable public access consistent with constitutional requirements. Seems kind of general. The court finds that this case has generated substantial public and media attention, and that unrestricted access or activity may compromise courtroom security. So there was no definite threat that was going to happen. It says jury privacy and the defendant's right to a fair trial. And he feels that the court further finds that reasonable time, place, and manner restrictions are necessary and appropriate, and that while the media and public retain the right to attend proceedings, such access is subject to limitations. That's all that is put into this order. Now, the rest of the order talks about how, what limitations are, but that's all that's listed in this order when we're talking about the restrictions. And as we saw in Waller, what's required is that the court must consider reasonable alternatives. That's not spoken to in this order. It can't be any broader. So what was this overriding interest that was going to be prejudiced, and what was the narrow way that you could protect that? If it was the kids, don't show their faces, don't have their names released. Like, none of that is in the order, y'all. None of it. Put a 1 in the chat. Put a 1 in the chat if you think the defense has made a good argument with this public trial, and if you think this is something that the court could rule on in Karmelo's favor. If you heard this and you think, man, yeah, I'm hearing it, but I don't think they raised it timely, and the judge did put facts on the finding, you find like it's a weak argument, put a 2 in the chat. But if you really think this is a good argument, I think it's a great argument. I think the defense really went through. They showed us cases that things have happened in. Do you think this is a good argument? Put a 1 in the chat if you do. If this argument, if the court hears it and they agree, this single argument is enough to get Karmelo Anthony a new trial. Would there be a new trial? That's a question, because gosh, it took them, the judge in his interview. We're going to cut back to that interview because it's about time for another quick little recess. We're going to go back and finish playing that. But he's talking about how he wishes now, he could have gone back and maybe put an audio up, and talks about Karmelo, now he learned he might have been a good child, but now he sees the consequence of his actions. Like in his order, did he put enough? Did he do the Waller findings? Did he do what he's supposed to do? I don't think if he did, I don't think it was a willful decision. I think he actually thought he was doing what he needed to do, but maybe the court will disagree. So that's the defense's first argument. Let me go back to the motion, and I see a lot of 1s in the chat. Let me go back to Ayana says 1, but I don't think, probably what you're saying, you don't think it's gonna be granted, maybe not. Queen Brielle says, thanks for walking through this for us. You're so welcome, because as lay people, you're just hearing this motion for new trial, and a lot of people are thinking it's based on what happened under the 10, and it's about the facts. And no, it's about the first argument being about this public trial. Ayana says, I don't think Howard objected. Yeah, that's going to be an argument. Did he object in time? Is this truly the first time that they could have raised this or not? And Latria Watley says he was biased, saying that during the interview. Yeah, I definitely think the motion for recusal will be granted, but will they even hear the motion for new trial? Shout out to Jersey Girl Trey moderating the house. Shout out, sis. I think you were in the chat on Facebook, right, when they were coming for me this week with the 4,500 comments. You didn't go to law school. What law school did you go to? No way you got your degree. It was just a whole bunch of different comments. But anyway, I thank you all for tuning in. We are 269 in the chat. Be sure you like, share, and subscribe to the channel. Because when the state issues their motion, if they respond, we'll be back and we'll go over it. All right, I'm going to go back to the defense's argument. Let me just make sure I covered most things in the first argument, because like this was 63. We weren't going to read word for word through the argument. I broke it down, showed you all what's required in Waller, what's required in Presley, and that is what the court will be deciding. Let me see. And they go into further, and because they have these affidavits of people saying how they were in line early and were kept out, and they're just saying how everything was even further restrictive, putting in a time to really say give the public 10 minutes to get into the courtroom for court to start. That's highly restrictive, right? And if you showed up at 8:50, as the order said, people were actually in line at 4:30, so that wasn't going to get you in the door. So all of that they go through and talk about. They also point out in number 47 how the defendant bears the initial burden to show that the trial was closed to the public, but that burden is carried on the totality of evidence. And that is why the defense went so much detail getting these affidavits and declarations, is because you don't look just at the judge's order. You look at the totality of the circumstances to determine whether or not this was public or not. Oh, it's thundering over here. So hopefully this doesn't mess up our live, y'all, but it's thundering. All right. So, which means lightning's coming and all that stuff. But okay. So hopefully we don't get messed up with any Wi-Fi or anything here. But so basically they're saying that the burden is carried on totality of the evidence, meaning everything. So it's the order. And remember how the defense argued that how the order was actually handled by the public information officer actually made it even more restrictive. So the court has to consider all of that. They bring up Lily, and let me remember what Lily was. Oh, that's the totality of the evidence argument. So it's not, and the defendant, as I remember I told you, he doesn't have to show that someone was even actually excluded, right? So that's not important, although he does. His grandmother, his aunts were excluded. People from the public that traveled from Arizona, from other states, were excluded from this trial due to this 10-minute cap and 27 seats. I will say the Diddy trial that I went to the sentencing for, we had the same kind of restrictions. I think there were 17 public seats in this courtroom, but there was an overflow room that had feed, audio, video. So you were able to still know what was going on, even if you weren't in the actual main courtroom. They talk about more people that they have that gave these affidavits. And that's basically what the rest of this, when I tell you this, public trial argument was 48 pages of the 63 pages of the motion. I have summarized that for you. The defense also gave a breakdown chart of other cases and like what they require, like in Waller versus Georgia. No overflow room was done. The entire suppression hearing was closed, and a new hearing was ordered. They talk about Stedman v. States, a case where there was no overflow room or live feed. The family was barred from voir dire for lack of room. Alternatives were not considered. A new trial was ordered. Lilly v. State, no overflow, no live feed. Trial conducted in a restricted access setting. Structural error. New trial was granted. Presley v. Georgia, no reserved roles, no overflow considered. The trial court must consider reasonable alternatives. That conviction was overturned. Williams v. State. Yes, there was a live video feed to a neighboring courtroom. The court said there it was a trivial closure, no violation. Zorns v. Bolin. Yes, remote viewing from an observation room. Trivial closure, no violation. This case, provided during jury selection in an overflow room, then withdrawn for the testimony. No feed thereafter. Falls on Waller, Stedman, Lilly side of the line. New trial should be granted. So the defense did a really good job breaking down this argument and showing other cases that ruled on it. Let me scroll through. They go on and break down the deficiencies that they feel are in the order. I've really done a really good job of summarizing this 48-page argument for you all. So I hope you walk away with the gist of getting an understanding of their argument there. And then they go into talking about how it fails the Waller steps, and y'all can recite this to your friends because you learn now, right? We law school 101 today. So we broke down all of that. They said that the order applied the wrong constitutional standard. If you remember the second page of the order, the second paragraph, you see that reasonable time, place, manner restrictions. They're saying that is the standard the judge gave the case, but he chose the wrong standard. It was actually the Waller standard, and he's supposed to apply that they're saying this isn't the standard. Reasonable measures that merely administer the courtroom may be permissible, but the provision that excludes the public is required to go under Waller and Press and do that 4-step analysis that Waller required, and then reasonable alternatives have to be spoken about on the record. So they just further show how that wasn't done in this order. They even mention other cases that have been public and how they have handled their restrictions. They talk about the remember the Derek Chauvin case. That was a case out of Minneapolis, and how they broadcast and live stream that case. They even talked about the Amber Geiger case. Remember that case was out of Texas where the officer went to the wrong apartment and ended up shooting the ex-military guy that stayed there at Bojang. I can't remember his last name, but that case, they brought up how that was handled. Remember, we had a live feed for that case. So y'all, ever since COVID, we've really gotten on YouTube a lot with these feeds from trials. So we've seen how judges in other cases have permitted the media, how they've protected witnesses from being shown at trial by cutting from their face, cutting their name. So we know that there are alternatives that could have been done. And the fact that that alternative discussion was never done in this case per the defense, that seems to be an issue that they can raise for Karmelo Anthony to get a new trial. As you see, I'm still scrolling through this public trial. They're just talking about how the order was more restricted by the public information officer. And again, how other people came forth with affidavits and everything, showing them how that was done. So I'm going to scroll. So this was a very long argument. So you see, it took me a lot of time this week to read this, go through it, go through the law, pull out the argument so you as lay people can understand, what they were arguing here. So that is this argument. We're almost getting to the end of it so we can get into number 2, which gets us to the juicy, right? So we're finished with that part. Let me literally go back through any questions. We got the ones. No. We're coming up on that now. True Advocate says, did we go over Mike Howard's affidavit already? No, that's coming up. Another jaw dropper, okay? So I want to go over the state's main argument for you all so you can see what the big issue is, because that is an argument that gets him a new trial. Whether you agree with the facts or not, it has nothing to do with the facts of the case. That is purely procedural, and did they do it? No, the state has not. Yes, the state can respond. They can do a motion to respond to this. Usually motions are filed and answered within 30 days. So they can respond. If they do, we'll come back and do them live on their channel. Latria Watley says it's almost like Judge Roach has a big ego, like he can't be touched. Yeah, I don't know him outside of this case, but he definitely felt bravado after this case and felt that he handled it perfectly, and that this case will be a linchpin or, an example for other big cases that can model this case, how Collins County handled this case, so that's kind of how he feels of the job that he did. So yes, prosecutors already said they were going to respond. Thanks for that, True Advocate. And I don't see how they can. When we go through Mike Howard's affidavit, the things that he alleged in his affidavit can't be left one-sided. The state has to respond to this. This was too big of a case. All eyes are here, so they have to respond. So we'll get that response in about 30 days, and we'll go through it. Thelma Anderson is also an attorney. Okay. She's been appearing on several podcasts, and she drafted her affidavit and has been in communication with the defense team. Yes, she has. Her affidavit is attached to this motion for new trial. That's why she's referenced in it. I didn't know she was an attorney, so good to hear that. So we know that we can add a little more credibility, right, to her affidavit to know that she's an attorney, because attorneys are held to a level of candor. So we can kind of put a little more, trust into what she's saying occurred. Yes, Mindy Ann 44, one of the mods here, the channel says it will be modeled on what not to do in a case. Yeah, that's that could happen as well. And a lot of this is hindsight 2020, right? I'm sure they didn't know things would go this way, and I'm sure if Mike Howard knew how this gentleman's agreement that they reached was going to go, he would have not agreed to that. So let's move forward to this second ground for new trial, which is the state's repudiation of the party's unrecorded agreement. But before I get into it, let me pull up Judge Roach's interview, and let me cut back into where we were on that. I just need a few seconds here on this side. We're on for almost 4 hours. So let it, take a little pause for the calls for 1 second. We're gonna go back to this interview. When I come back, we're gonna get into this their second argument with this gentleman's agreement, why they're asking for a hearing, and we're going through Mike Howard's affidavit, okay? We are going to hear what the defense attorney in this case had to say. It's a sworn affidavit. So what he's saying is each line in this document is actual, factual, and he's swearing under oath that is true. And when you read it and hear it, it's going to blow your mind, because it answers every question we had. Why didn't the defense cross this? Why did Mike Howard ask this? Why didn't Karmelo testify? It is all in the affidavit, and it stems from this gentleman's order that Judge Roach said he had no way to enforce, even though it happened in front of him in chambers and was placed on the record in front of him, all right? So first I'm gonna share, we're gonna go back to where we left off with Judge Roach's interview. I'm gonna make that full, oh, wait a minute. Oh, it is full screen. Bring myself down, and we're gonna go back to that. Right back.
I hate to have to ask about stuff that emerges on social media, but I have to ask it. And I know you don't know any of it because you're not on social media.
I'm on it. I mean, I'm an elected official, so I have a Facebook page and stuff. Do I look at it? Do I monitor it? Do I let it impact me? None, not at all.
So I have to ask, do you have a personal relationship with the Metcalfs?
I wouldn't know Mr. Metcalf prior to this trial if he walked up to me and said hello. I don't know the Metcalfs. I sympathize with the Metcalfs and what they've been through and all, but I don't know them personally. Never have. So
these AI images emerging of you and them at a party or drinking together, all
never
of that.
Happened. And that's the problem with social media, isn't it? You can't tell what's true and what's not true. I will tell you, I got some reports of some things that were coming out of this courtroom, and I wondered to myself, were they even in the same courtroom that I was? It's that bad. And I think that's tragic, because I think really if you just listen to the case based upon the facts, you'd understand it so much better.
Do you think it reinforced your decision to not have cameras or streaming inside this?
Sort of. I will tell you this. Sometimes I think maybe I should have at least the audio streamed or something so people could hear it. But at the end of the day, I don't think, no matter what, people are going to distort whatever happens or whatever they hear into their own agenda. And so what's the point? And again, that noise affects people. It affects the fairness of the trial, the safety of the witnesses, the safety of the jury. And those are my primary concerns, not what social media says. It's not my duty. I don't think it's my job to feed social media or the media stuff. I certainly understand the role that media plays in a case like this, but I'm not here to feed it. And I took that very, very seriously.
But Judge, when people don't have access to the trial or the courtroom, doesn't it invite speculation?
Well, sort of, but I got 70 seats in my courtroom, and I had 200 requests by the media to sit in the courtroom. So let's say if I just entertain the press, then I have nobody from the public watching what's going on in their county. And so I had to do a balance between the media's right to know and to be able to report what's going on, because I think that's extraordinarily important. I think it's important that the general public had access to the courtroom and to see what was going on. And so I tried to balance all those things with the primary, again, purpose of having a fair trial. And I think I struck that balance pretty well.
But the media's right to know is the public's right to know, is the public's access. We are the extension of that public.
I think somebody from the public who wanted to come watch a trial and know that they were excluded from a trial because all the media was there, I beg to differ.
Do you think there was a possibility for a learning experience? I mean, people do not know about how trial works. Do you think that this may have been an opportunity for people to know how it truly works, and that kind of erases some of the negative notions of court and trial?
I'm doing this interview with you to make sure that people understand how the system works, and if they really wanted to, and I mean this seriously, if they wanted to, they could have stood in line with everybody else, and had the 27 to 32 public seats that we had in this courtroom that we rotated every day. And so, was that important to them? They could have made it in here.
How did you plan for some of the outside noise?
Well, we started playing with the sheriff's office and the McKinney Police Department and the Allen Police Department and the Frisco Police Department. So those were talks that we're having 8 months before the trial to ensure the safety of the people out in the parking lots. They certainly had a right to demonstrate, and all. And I think we struck a very, very good balance, allowed them to do that at the same time, maintaining safety of everybody involved.
Did it affect your day-to-day decisions?
It didn't. Actually, I didn't. I came in from a different entrance from the courthouse. I didn't come in through the front. I couldn't hear any noise at all from my office. The jurors were not facing the parking lot, so they didn't see anything or hear anything. And I think we did a marvelous job in isolating them and having them concentrate just on what was going on in this courtroom, which was my instruction from the very, very beginning.
All right. So that was a little more of Judge Roach's interview that he gave 2 days after the trial. So, there's a pending motion to recuse on this case. So this is the basis for the motion to recuse, his interview. Did you all hear some statements in there that make you want to recuse the judge? Does he sound unbiased when he makes statements about Karmelo's guilt in this case and how he seems like a good kid, but he now understands the consequences of his actions, right? That kind of sounds like you are making a decision that you believe his actions are unjust, which means you are agreeing with the state's position that this wasn't self-defense. Well, how is that unbiased? You're taking a position on the case and there's a motion for new trial pending and you're going to be the person to hear it. Have you remained unbiased? Can you make this decision? I don't think so. So I really think that he may be recused from this case for that reason. There's no arguments being raised that he was unbiased during the trial. This is simply for his actions after the trial. So now we are going to get into the second argument that the defense raises, which talks about this gentleman's agreement that existed. And then we're going to jump right into Mike Howard's affidavit, because that really tells us all the facts about this this gentleman's agreement that existed. I believe this is where we are. All right. So yeah, shout out to the chat. I love y'all. We've been on for 3 hours and 59 minutes, and this chat, it's been about 269 to 300 people in the chat. I mean, pretty much since we kind of got through the factual background of this motion. So I thank you all for tuning in. Thank you for hitting the like button. If you haven't, close that chat, hit that like button and come back to the chat. Share this live. Once we're done with this live, hype this video so that it can get into the algorithm. It was very important to me to provide education. This is Legally Speaking with Fit. We are talking about the law here, how the facts are being applied to the law. That's it. No conspiracy theories, no excuses, no request for Karmelo to be released tomorrow. Just that the legal proceedings be handled fairly, justly, and by following the law. And we're just breaking down what the defense's motion is, making arguments that it's not. We are going to do the same for the state's motion when they file their response, which is coming, because after Mike Howard's affidavit, you best believe Bill Werski is going to have an affidavit of his own. All right, so let's get into the second argument. The second ground, and I mind you now, the first part of this argument was 48 pages, okay? It's only 63 pages in the motion. So we only got 58. So we only have literally 3 arguments over 10 more pages, okay? So that tells you the bulk of their argument is all in the public trial. All the affidavits that are listed except Mike Howard's, they all speak to this public trial. So that is what it's about. Shout out to Operation Sexy Body in the building. This is the leader of my accountability group that I've been in for the last 2 years. So shout out to Operation Sexy Body. You can follow her under the same name on Instagram. She's also on YouTube. So shout out Operation Sexy Body for being in the building. So yes, so these other grounds are really quick. They are the least, you start out with your strongest argument first, right? So you can just tell how we're going through this, what they believe their strongest arguments are. Second ground for new trial, the state's repudiation of the parties' unrecorded agreement limiting character evidence. After the defense relied on it, coerced the waiver of the defendant's right to testify, denied him a complete defense, and warrants an evidentiary hearing. So this argument is not a ground that gets Karmelo automatically a new trial, but they're saying that it's enough of a ground that it needs to have an evidentiary hearing. And if the state then decides from that hearing that his rights were violated, like his right to testify, then that will mean that maybe he should get a new trial for that reason. So that's what they're asking for with this ground. So they say that, and we're going to get into the agreement. through Mike Howard's affidavit. But let me just first, lay down the law. So Santabello does not involve an identical procedural setting. This is a case they're referencing, and they're saying that it right off is not identical, but they say it supplies the governing law. It supplies the governing due process principle. When the state induces detrimental reliance on a definite promise and then repudiates it after the reliance can no longer be undone, fundamental fairness is implicated. In Santabello versus New York, the state made a promise the defendant relied upon and then broke it. Through a change of prosecutors and perhaps inadvertently, the court held that the breach could not stand and vacated the judgment. Even though the breach may have been unintentional, and even though the sentencing judge said the broken promise had not influenced him, the defense relied on the parties' understanding through 3 successive phases of trial: voir dire, the opening statement, and the cross-examination of the state's witnesses, and the state repudiated it only when the defense reached its own case, at the point when that reliance could no longer be undone. If the inadvertent breach in Santabello required relief, then the deliberate mid-trial repudiation here warrants at least the hearing this ground request. So they're comparing this to Santabello. They're saying in that case, the defense, the state, they didn't mean to do it. Prosecutors changed, and so that's why the agreement didn't follow. But here they're saying the state was the same from beginning to end. They knew the agreement. They substantially relied upon it because, as you're going to hear from Mike Howard's affidavit, the defense did their entire trial defense based on this agreement. And then when Karmelo got ready to testify, the state said, oh, wait a minute, that's not covered in the agreement. It says before and during trial, you know what? I want to skip to the affidavit because the affidavit goes into detail and I want to get right to the point. So we're going to scroll down to Exhibit 10. That is the affidavit of Mike Howard. Mike Howard was the defense attorney that represented Karmelo in this case, along with Toby Shook, and there was another attorney, Tasha Gupta. All right. So this is his affidavit. He wrote this up. He's working with the appeals team. That's why we haven't heard from him. He's been quiet, but he's speaking loudly through this affidavit. Okay. So this affidavit starts like any affidavit. It says it's before me, which is the notary, the undersigned notary public. On this day, personally appeared Mike Howard, who being by me duly sworn, deposed and stated as follows. I, Mike Howard, am at least 18 years of age, of sound mind, and I am competent and qualified to make this affidavit. Let me make sure I haven't missed any super chats. I think I have. Let me just recognize these 2 super chats before we get into this. Prayer Changes 7154 sends a $10 super chat, says, thank you for always breaking down paperwork where it is understandable, even by a 5th grader. Also, your other source of donation. Thank you. Check my other source. Thank you so much, Prayer Changes 7154. I'm checking that now. Also, thank you so much for that $10 super chat. Yeah, that is why I've spent, the last few days kind of arguing with people back on Facebook. And it's just for simply educating the public about this. Oh my goodness, Jewel Johnson. I'm sorry. I keep on, I know Lee, because you open the super chat and you see a name at the top. So my apologies. Prayer Changes 7154 sent a $50 Cash App as well as this $10 super chat for thank you for always breaking down paperwork. That is so appreciated. Thank you so much. Thank you so much, Prayer Changes 7154. I'm trying to make sure I keep track with the right name that you want shouted out. Thank you so much. I greatly appreciate that. And I appreciate the fact that you understand that that's what I'm doing. I'm here just to simply break down the paperwork, layman's terms, and we can debate it in the chat. That's what I'm here to do. So shout out for the $10 super chat and shout out for the $50 Cash App. That would make Prayer Changes 7154 our stream sponsor so far. Thank you so much. You've donated the most to this channel for this live. I greatly appreciate all of your support. Thank you so much. Anthony Peterson 5618 sends a $10 super chat. It says, Judge spoke to usurp any conflicts of wife and Metcalf fam. Does he typically make post-trial speeches? At Fordred, trial over, but KA was invited. Attorney didn't object to with opinions, 135 pounds, KA hum. So I guess you're talking about the fact that the attorney didn't object, and I'm glad I read this comment because we're about to get into Mike Howard's affidavit, and we're going to learn why some of those objections were not raised. So shout out Anthony Peterson, 5618 for the $10 super chat, and Prayer Changes 7154 for sending $50 on the Cash App and a $10 super chat. I greatly appreciate you both. And thank you for everyone being in the chat and providing commentary here on this case. All right, so Mike Howard's affidavit. He states that I have personal knowledge of the facts stated herein, and they are true and correct. I declare that. I was the trial counsel supported by second chair co-counsel Toby Shook, third chair co-counsel Tasha Gupta, and briefing appellate co-counsel Michael Mola, who represented Karmelo Anthony in cause number 296-83565, 2025. Leading up to the June 1st, 2026 trial of this case, the defense and prosecution reached an agreement where the prosecution and defense jointly agreed to not raise any alleged character, reputation, or extraneous offense bad acts evidence relating to Mr. Anthony, as well as Austin Metcalf and Hunter Metcalf during the trial, herein referred to as the agreement. This is the gentleman's agreement, okay? The lead prosecutor in the case, Bill Werski, brought up the possibility of the agreement a number of times well before the agreement was discussed in detail and eventually reached. When mentioning a proposed agreement, Mr. Werski proposed that we try the case clean, which he defined as based only on what happened under the tent that day, which would have been under the Memorial High School tent at Kuykendall Stadium on April 2nd, 2025, and not go into character, reputation, or extraneous offense and or bad act evidence applicable to either Austin and Hunter Metcalf or Karmelo Anthony. On May 5th, 2026, Mr. Shook and Mr. Werski discussed this proposed agreement by phone. I would suspect it probably started between those two because they used to work together in a law firm and then they worked together in the DA's office. So they have a personal relationship. So they're the two that started this discussion of this proposed agreement by phone. During that phone call, Mr. Shook and Mr. Werski discussed the evidence of character, reputation, and extraneous offense bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. Mr. Werski reiterated that he would be happy to try this without getting into character at all, just on what happened the day of the track meet. On May 8th, 2026, the defense and prosecution teams met in the Collin County Grand Jury room. The prosecution team gave us a document entitled State's Notice of Intent to Use Extraneous Offenses, hereinafter State's Notice. And we gave to them a document entitled Anthony's Motion in Limine regarding the admissibility of pertinent character trait evidence, evidence under the ambiguous aggressor rule, and evidence under Texas Code of Criminal Procedure, Article 3836, which is classified as the defense notice. After tendering to each other our respective extraneous filings, briefings, we then discussed the proposed agreement. When Mr. Werski, which Mr. Werski referred to as a gentleman's agreement. Mr. Werski outlined the proposed agreement as follows. Both sides try the case without character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony, and just try the case based on what happened under the tent. And during another description during that meeting, what happened on the day of the incident. Seeking clarification, I asked, and Mr. Werski confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extraneous offense acts related to violence and bullying, inclusive of discipline and write-ups in the Metcalf twins' schools records within this framework, as well as racism. In exchange, the prosecution would not go into character, reputation, and extraneous offense acts evidence relating to Karmelo Anthony, inclusive of the contents of Karmelo Anthony's cell phone, told y'all about those pictures, and school disciplinary records. At this meeting, I sought clarification on how this agreement would work practically, specifically how to handle the possibility of opening the door to this evidence from either side. During this meeting, Mr. Worski repeatedly expressed his concern that the defense would kick open its own door by asking questions of witnesses that would delve into issues restricted by the agreement. I asked about specific statements made by witnesses interviewed by police and captured by video on the day of the incident, where those witnesses discussed the Metcalf twins being passionate, triggered, and not tolerating being disrespected, etc. Mr. Worski eventually agreed that questions narrowly tailored to ask about specific statements the witnesses made to police about the incident under the 10 on April 2nd, 2025, including statements just described about the mindset and actions of the parties involved in the incident, would not constitute kicking open your own door, and thus would not violate our proposed agreement. So the agreement, basically, they're both sides are saying, look, we got a stack of stuff against Karmelo from his phone and his records at school that we can use that would hurt him. The defense is saying, hey, we got a stack of things from the Metcalf twins, school records. We got the email cheerleaders. We got proof of racism, bullying. We got statements that the witnesses made to the police that day that go to their, aggression and bad character. We're going to leave all that out. Both parties agreed on a gentleman's agreement. You're going to see that was sealed by a handshake that they would both leave that out and try the case clean only about what happened under the tent. Put a 1 in the chat if you think this was a good idea. Put a 2 in the chat if you're like, hell no. He's telling it all. I mean, what could be in Karmelo's phone that the defense wanted to keep out? We don't know yet. I'm pretty sure that as detailed as this affidavit is, and it lists what was in the Metcalf's docs, that when we get the state's motion, it's going to list what was on Karmelo's phone. It's going to tell us what they were trying to keep out. I've seen an image online of him holding a weapon. I don't know if that was what it was, but Sean C17 says that this only benefits the twins, this gentleman agreement. You think so? They had 75 pages of extraneous information that they were going to bring out on Karmelo. 75 pages. Ayana I5W says, call their bluff. Do you want to? You don't have to. You're not calling their bluff now because you got a copy of it. So you're going to see what it's not a surprise to the defense. It's a surprise to us because we're not a part of the case and the case file is still sealed in the judge's office. But it wasn't a surprise to them. They got the 75 pages. They had a chance to flip through. They were able to see. And they felt like making this agreement was a good deal. They felt that whatever they had against Karmelo, it was severe enough they wanted to keep it out, that they agreed that bringing up that the very person who pushes Karmelo, we don't get to know that he's a bully, that he's aggressive, that he's been he's done racist graffiti in the past. We're going to get into that. I got enough bad. You're giving me enough bad stuff on my client that I'm going to agree to keep this out on the victim that I'm saying aggressed me, and that is the reason I defended myself. It had to be some pretty strong evidence that they did not want to come in for Karmelo. I see a comment. Let me go catch it. Elvira Ward 3402 says the parents said in their interview he never been suspended from school for a knife. May not have been. He may have been suspended for fighting. He may have been suspended for slapping a teacher. Like, I mean, it could have been any reason, right? Okay, he wasn't suspended for a knife. So what? What if it was other stuff? Like, I do these cases all the time. I fuss at my clients all the time. You know what I end up getting in discovery? I get your Instagram posts. I get your stories that you think only last for 24 hours, but they stay on your phone forever. I get when you were in that apartment packing up weed with your homeboys and smoking a blunt on camera, and y'all recording yourselves to some rap music because you thought it was fun, and you place it on your story, and it only lasts for 24 seconds and it's gone. But guess what? I get that in discovery. I get those Instagram messages that y'all DM your friends. Had a case where my client was charged with shooting up a house. He allegedly DMs a female and asks for the address to the house that he goes, and he pays her $100. Guess what? The DMs, they got the Instagram DMs of you doing this is there. So what else is on your phone? You got WhatsApp. That's not encrypted. You can get that information. Snapchat stuff, I don't think they can get that. But there are so many things you all do on your phone. Text messages. He could have texted a picture to some friends. That could be there. It was 75 pages of bad character evidence that they wanted to keep out. Ayana I5W says, but if Karmelo is a 3.7 GPA, a captain of both his track team and football team, how bad could it be and not be overcome? You would be surprised. I just had a case where a 17-year-old female, we're sitting there talking, and I'm like, what's on your cell phone? If they charge you with party to a crime to a felony murder, which is what you just did by driving these Negroes to somebody's place to commit a robbery, what would they find on your phone? Oh, for my birthday, I took a picture with a gun, and my homeboys, they had it for my, what? Like, kids that graduate early have bad stuff on their phone. Like, I don't want that shown. I don't want you standing up there with bandana tied on your head and you holding an AK-47 or M316, or you holding whatever guns you got, whatever. If it's a pistol, a 9, a Glock, I don't want that in the case when I'm arguing. You're scared of somebody that is threatening you, but you're a big bully and a thug on your social media. Like, I might want to keep that out. It's 75 pages. What was it? So you can do all of that. In that case I just spoke about, the mom, when we first got the case, she hired me. This is the case with the ag assault and the client with the DMs. And she's like, oh, my son, he drinks he goes to Starbucks with me. He gets these, these fruity, these drinks or whatever. We go get our pedicures together. He has a job. He listens to country music. But guess what? She didn't know. I'm like, Mom, I got this social media. I got a whole thumb drive from the state. Look at him on this Instagram. I don't know what he's like in your presence, but outside of it, he's in an apartment with his friends. They're bagging up weed. They're pointing guns at the camera. They're riding around the car. Everybody had a gun. I mean, people live different lives. These kids these days put everything on social media. So I don't know what it was, but whatever it was, Mike Howard, Toby Shoup, Ms. Gupta felt like when the state came out with this agreement that it was something that it was enough for them to jump on so they could keep it out. We're going to hear about it, because if I'm going to keep reading this affidavit and you're going to see how the defense is dropping little things about the Metcalf twins, oh, the state's going to drop some stuff about Karmelo and their thing. So we'll eventually hear about it. But this is why his attorney entered this agreement. I saw we got a $2 super chat from Anthony Peterson, 5618. Shout out, says, was there order for phone? I don't know, because this case is sealed under record. Was there there should be a search warrant for the phone to go through the phone and do a phone dump. Did that exist? I don't know. I can only presume it does, only because there are no arguments that this was searched improperly in this document. But we don't know, because the judge still has the entire case file under seal in his office. So things aren't on the public docket. So I don't know, but you definitely need a search warrant before you can do a phone dump for somebody's phone. At For Dread sends a $2 super chat. Shout out. At For Dread, FaceTime video if you're going to talk about doing dirt. Yes, we learned that from the YSL case. FaceTime videos cannot be found. They can't pull that video and see what you were talking about. So if you're going to be talking about some illegal activity, FaceTime may be the method you use, because they can't get that. But when you're sending those DMs, the text messages, the stories and Instagram messages, that stuff can be found. So we will know soon, maybe when the state responds, if they have anything. But I see Meek 595, they lied. It's not a lie. They actually handed him a document that's verifiable. So his attorneys received this evidence before they made this agreement. And so just like they provided evidence about Austin, because when you have these criminal cases, you file a motion for discovery and you're given Brady material. And that means that the state has to turn over everything that they want to use against your client at trial, whether it hurts or helps the case. Okay. So even if they're not going to use it at trial, but it's some exculpatory evidence that will help your case, they got to turn it over. Okay. So they don't get to hide those type of things. And if they didn't turn something over, that's an allegation that will be made in the file, and it's not. The only allegation is we entered into this agreement and the state bagged out. All right. So we're going to go back to Mike Howard's affidavit. All right. So he says, let me see. So they talked about how the defense could kick open their own door. And Mr. Worski eventually agreed that questions narrowly tailored to ask about specific statements the witnesses made to police about the incident under the tent, including statements just described about the mindset of the parties, would not constitute kicking open your own door and thus would not violate the proposed agreement. During this meeting, we discussed, and there was question before who all was in this meeting. This is Mike Howard. This is Toby Shoup. This is Ms. Gupta. This is the state, Bill Worski, his second chair. They're all together discussing this. They discussed the terms of the agreement, being that testimony from eyewitnesses from under the memorial tent on April 2nd and who were discussing the facts of what happened under the memorial tent on April 2nd would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the twins or Karmelo. During this meeting, I also asked about the agreement regarding the possibility of the defense calling experts. The prosecutors only discussed how the agreement would apply to defense experts during the sentencing phase. So I asked how the possibility of the defense calling experts to testify during the guilt innocence phase would impact the proposed agreement. The prosecutor team replied that they had not considered us calling experts to testify during the guilt innocence phase. They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about a fight or flight response, they considered expert testimony like that to violate the agreement and thus open the door to character, reputation, and extraneous offense act evidence. Like, this was something that's not done, right, most times in cases. So they weren't working from, the law says that in order to have an agreement like this, it can do this, this, and this. This was just them coming together, forming this agreement. The defense would ask a question and state like, no, that's going to open the door. Not based on necessarily rules of evidence or a judge saying it opens the door. This is just the attorneys working out this gentleman's agreement. Section 6, on May 11th, 2026, Mr. Worski, Dewey Mitchell, Mr. Shook, and I discussed the proposed agreement again by phone. I informed the prosecution that we had an informal agreement on the proposed agreement, but that we needed to have a final conversation with Mr. Anthony and his parents to confirm the final agreement. During this phone conversation, Mr. Worski confirmed that the agreement would extend to the sentencing phase of trial as well. Mr. Worski said that that would mean that in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any of the allegations listed in the state's notice. Mr. Worski said, however, that he would not allow a false impression to be presented to the jury by a defense witness, and that if such a thing occurred, he would respond by going into the character, reputation, and extraneous evidence from the state's notice. After the defense asked about an Anthony family member testifying at sentencing, Mr. Worski agreed that the agreement would cover Mr. Anthony's mother testifying to the standard, I love my son, please show him mercy type testimony, but no further. This is why Anthony's mother only made 3-sentence statement at sentencing. I wondered about that too. Like, why didn't they bring in people to talk about his job, talk about this? This is why the gentleman's agreement agreed that they keep all of that out and even limited what his mother could plead to the jury after they had found her son guilty of murder. Yes. I'm sorry. Alvira Ward 3402. This just seems wrong on every level. Anytime you block a defendant from taking the stand, no expert witnesses, etc., is crazy. We didn't end a trial if this is the case. It makes you feel that way, right? Because there's so much that didn't come in that the jury wasn't able to hear. And what was it beneficial? And especially not when the state reneged at the end. And we're about to get to that. All right, so number 7. On May 21st, 2026, the defense and prosecution teams met with Judge Roach in his chambers. During that meeting, both sides explained the agreement to the judge, describing it again as both sides agreeing not to go into character, reputation, or extraneous evidence as it applies to both sides during both guilt, innocence, and sentencing phases, as long as no doors are opened or false impressions given. We agreed that the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses, so it would cover both the twins and Mr. Anthony, but if made public, would not trigger reporting in the media about bad act evidence specific to certain witnesses, thus endangering a fair trial. On May 21st, I drafted the motion in limine as described above and sent it to Mr. Worski by email. It was hand-delivered to the judge on the opening day of trial. Remember now, they said in this motion that they drafted this motion, and that is how they were putting this gentleman's agreement in writing. The motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses. So it would cover both the twins and Mr. Anthony, but if made public, would not trigger. So they kept it general so that they didn't put any of the 75-page notice or any of the details. They just listed it and saying that this evidence will be kept out applying to witnesses. So, thus, because if it's got out, it will endanger a fair trial. This motion was drafted, emailed, not filed as normal, because remember, they're trying to keep everything secret here. And they hand-delivered it to the judge on the opening day of trial. So we don't have a copy of it. We don't know what that motion looks like. The case file is under seal by oral order of the judge and still sitting in his office. So we don't know what that motion looks like. The defense's understanding of the agreement. And this is when it starts getting shaky. The defense understood the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or the defense about the incident that occurred between Mr. Anthony and the twins and their teammates under the memorial tent on April 2nd, 2025. As every description by Mr. Worski described, the agreement to allow for testimony about what happened under the tent. And Mr. Anthony was obviously a witness to what happened under the tent. By the plain meaning of the language Mr. Worski repeatedly used, the defense always understood the agreement to cover Mr. Anthony's potential testimony just as it would any other eyewitness to the incident under the tent. Following the plain meaning of Mr. Worski's words in describing the agreement, the defense understood the agreement to cover testimony by eyewitnesses, such as the memorial students under the tent at the time, Hunter Metcalf, students outside the memorial tent who looked over and witnessed the incident, and Karmelo Anthony. This understanding of the agreement was further confirmed by events that occurred after the motion in limine memorializing the agreement was drafted and tendered to the prosecution. On May 29th, after a meeting with Judge Roach, the prosecution and the defense to discuss how trial security would be handled, the parties discussed the timing of the state's case in chief and when the defense's case in chief would start. Mr. Worski informed the court and defense that he estimated it would take 3 days for the state to present its case in chief, which would have ended sometime on Saturday. In response, I voiced concern to the judge in front of the prosecution team that some of the witnesses the defense anticipated calling to testify were unavailable on Saturday. I explained that, like in any case, I would not know until the final moment whether we would call our client for sure, but if the prosecution rested sometime Saturday and the judge forced us to call witnesses immediately on Saturday, I may not have enough witnesses available to fill up a full day of testimony Saturday. I may not have enough. Oh, I'm sorry. I explained that if this happens, it would force me to call my client out of order. The defense plan was to call all of our fact witnesses first to establish certain facts and then conclude by calling our client. So what he's saying is that our understanding was that our defendant was always covered by this agreement. And after we did that motion in limine, remember that they emailed to Bill Werski. They had a meeting with the judge on May 29th. And in that meeting, they're discussing the defendant testifying and how the time limits on each side. On Friday, June 5th, 2026, the second day of testimony, I checked in with Mr. Werski about how he was proceeding and whether he would end up taking more or less time to present his case than he initially estimated. Mr. Werski informed me that he was moving more quickly than he initially estimated, so the prosecution was on track to rest his case in chief midday Saturday. In this conversation, I again brought up the fact that several defense witnesses were unavailable on Saturday, and if the judge proceeded with his plan to force the defense to call witnesses immediately upon the prosecution resting, in order to have this full day of testimony on Saturday, we might be forced to call our client out of order. This time, I did not preface this statement with the perfunctory, like in any case, I won't know if I am going to call my client at the last minute, because I was not on the record and was speaking frankly with opposing counsel. So there was no secret that they ever thought, they were considering Karmelo testifying. Mike Howard says, I was very plain about the defense's intention to call Mr. Anthony to testify and how the judge's proposed schedule requirements were going to force us to call Mr. Anthony out of order. I don't independently recall what time on Friday this conversation occurred, but it must have occurred just before noon, because I then sent an email to Michael Maula, who is the briefing appellate attorney on the defense team, describing the problem we were facing and asking him to draft a brief for us to argue to the judge that he couldn't force us to call our client out of order. Throughout the morning and early afternoon of Saturday, June 6th, Mr. Shuk and I repeatedly checked in with Mr. Werski to get updated estimates on when he might rest his case in chief, each time referring to how the judge's plan was going to force us to call our client out of order. Besides the defense team repeatedly mentioning in front of Mr. Werski and the rest of the prosecution team that we intended to call our client to testify, even if it meant it would be out of order, Mr. Werski's own actions and arguments made it clear that he knew full well that we intended to call Mr. Anthony to testify. Even before both sides tendered their notices of and arguments in favor of the admissibility of character, reputation, and extraneous evidence pertaining to the other side's witnesses, Mr. Werski made references to understanding that the defense sought to introduce character and reputation evidence about Hunter and Austin that was uncommunicated, unknown to Mr. Anthony via the ambiguous aggressor rule from Torres v. State. The ambiguous aggressor rule and the admissibility of uncommunicated character and reputation evidence of the decedent in a murder case are all part of a self-defense argument. Torres discusses in depth how the ambiguous aggressor rule allows the defense to put on uncommunicated character and reputation evidence before or after the defendant testifies. That means that this is character evidence that Anthony didn't know. He didn't know this prior to the incident, but knowing it now, I'm showing how this person's an ambiguous aggressor. Like, that's the rule. So this is not, stuff that they're saying Karmelo knew that Austin did these things. They're just saying that the law in Torres allows them to put that evidence up before or after the defendant testifies. Mr. Werski repeatedly brought up Torres in discussions with the defense team in the months leading up to the trial, stating that while he thought the judge would rule correctly and not allow the evidence, he conceded that character evidence could be allowed. This repeated discussion of Torres and how it may apply to the trial showed that Mr. Werski was well aware of at least the possibility of Mr. Anthony testifying in order to argue self-defense. This was the entire purpose of the agreement, in that it provided value to the prosecution, limiting the defense from presenting damaging character evidence against Austin and Hunter, and the defense. From the defense's perspective, the entire agreement centered around the defendant testifying without impeachment by character, reputation, and extraneous evidence in exchange for the defense not seeking to introduce character, reputation, and extraneous evidence against the twins. This was supposed to be something that was beneficial to both sides. Furthermore, any competent criminal trial lawyer knows that for a self-defense argument to have any chance of succeeding, the defendant must testify. For all these reasons, the defense always understood the agreement to include Anthony's testimony free of impeachment by character, reputation, and bad act evidence. Just like every other witness, either side could call to testify about what happened under the tent that day. Throughout the trial, the defense revised its trial strategy in reliance upon the agreement. Absent the agreement, the defense intended to cross-examine each memorial student witness the prosecution called about Austin and Hunter's character and reputation for violence, for being bullies, and for racism. The defense also intended to cross-examine these witnesses about various statements they had made to the police on April 2nd regarding Austin and Hunter being easily triggered, having a loud mouth, being passionate, not allowing themselves to be disrespected. Some specific examples include Austin's a really big guy, and he's kind of like the aggressive guy on the team. Austin got the same way that he got during the altercation is the same way he got with some of us. And the mellow kid, something or whatever, and then Austin kind of got triggered. Austin and Hunter, they're not going to let you disrespect them. And Austin, he's like a big guy, so nobody really wants to fight him. And Austin's really a passionate guy, and Jose told police about Austin's history of fighting and almost getting kicked off the football team for fighting. We already know that he got suspended from the track team, and his first day back was the day this incident happened, so he almost got kicked off the football team as well. I've known Austin for a while, and if Austin is about to get into a fight, you can tell. Austin can be a bit aggressive at times, and he has a bolder mouth. If the prosecution did not call any of these witnesses, the defense was ready to call them during the defense's case in chief and question them as hostile witnesses. Furthermore, the defense intended to call witnesses familiar with Austin and Hunter's reputation for violence and bullying. The defense intended to call witnesses who themselves were victims of the Metcalf twins' violence and bullying. The defense intended to question Memorial High School teachers about the Metcalf twins' disciplinary history contained in their school records, which corroborated their character for violence and bullying. And finally, the defense intended to elicit testimony about the Metcalf twins' arrests for racist graffiti. They actually got arrested for this. So back to the 75 pages on Karmelo. What was so bad on Karmelo's side that made the defense agree to keep out an arrest of racist graffiti? Do you think, put a 1 in the chat if you think the jury hearing that the twins had been arrested for racist graffiti, that they had been bullied, that Austin almost got suspended for fighting from the football team. Drop a 1 in the chat if you feel like those things strengthen Karmelo's argument on self-defense. I mean, and so when you think about a motion for new trial and getting a do-over, does those things coming in, do they change the outcome? Does the jury feel differently? Does the jury no longer look at Austin being this poor guy that was just trying to get this Anthony from under the tent and he pushed him and got stabbed? Do you still have that opinion of him if you knew that he got arrested for racist graffiti? What was it? Was it the N-word? Was it, I don't know. There's so many ways to be racist, but was it the N-word? Because Anthony's Black. Was it something that referenced Black people? They had a character for violence and bullying. If the jury gets to hear this, do they feel the same way about Karmelo? But You don't get to hear that, though, unless you hear the bad stuff that's on Karmelo's side. So we haven't heard that yet because the defense isn't putting it in their motion. But I'm sure the state will provide it to us. But these are the things that the jury didn't get to hear because of this gentleman's agreement. Okay. Number 16. In good faith reliance upon the agreement, the defense did none of this. The defense even limited its questioning of witnesses about statements they had made about the Metcalf twins being triggered, having a loud mouth, being passionate, etc., that had been deemed to be allowed under the agreement in an abundance of caution to avoid opening the door. Furthermore, because the prosecution had made it very clear that the defense calling any psychology-related expert will open the door to character, reputation, and extraneous evidence pertaining to Karmelo, the defense chose not to designate any experts and ultimately chose not to call as a witness a neuropsychologist to discuss how Mr. Anthony's epilepsy impacted his perception of threat and response, as that is relevant to self-defense, and a forensic psychologist to discuss both brain development of a 17-year-old as well as the fight or flight response as it applied to Mr. Anthony's actions. As a result of this revision in defense strategy, the defense did not go into these subjects during voir dire or opening statement. Without such an agreement, or if the defense had suspected that the state would violate the agreement, the defense would have explored these subjects during voir dire and would have introduced these topics during its opening statement. In sentencing, in reliance upon the agreement, the defense did not designate an expert who was ready to testify regarding mitigation, i.e., a risk assessment and psychological profile of Mr. Anthony. Furthermore, in reliance upon the agreement, the defense severely limited its available character witnesses to just 3 questions of Mr. Anthony's mother, which had been previously agreed upon by the prosecution. Other than general character testimony and pleas for mercy, in reliance upon the agreement, the defense also did not go into substantial family violence Mr. Anthony had witnessed and been a victim of in his home. What family violence occurred? This is so interesting. So all of this, they opted to keep all of this out. This trial could have went so different. On Saturday, June 6th, after the prosecution rested its case in chief, the defense called witnesses Adam Linwood, Jeremiah Smith, and Jose Andres Ramos Mora before ending the day in the late afternoon, early evening. On Monday, June 8th, the defense resumed its case in chief, calling Brendan Stevens and Brennan Lacey. The defense's next planned witness, blank, had been avoiding the defense's subpoena. It kept changing the time he told us he would arrive at the courthouse. Accordingly, after Mr. Lacey's testimony, we took a break at 10:50 a.m. to see if blank had arrived. During the 10:50 a.m. break, in the back hallway outside the judge's chambers, the judge asked us for an update about timing, how many more witnesses, etc. I explained that the next witness the defense had planned to call was a Centennial High School coach. Mr. Worski asked what the coach would testify to that did not pertain to Mr. Anthony's character. I explained that this coach had witnessed Mr. Anthony's seizures, so he would testify about Mr. Anthony's epilepsy based on his personal knowledge. Mr. Worski then argued that testimony about epilepsy was irrelevant at guilt innocence, and to the extent it was relevant, would open the door to character, reputation, and extraneous evidence against Mr. Anthony. In plain terms, it would breach the agreement. I stated that I disagreed, explaining how it was relevant to Mr. Anthony's state of mind pertaining to self-defense, and that it did not relate to character, reputation, or extraneous evidence in any way. But Judge Roach agreed with Mr. Worski, and he thought testimony about epilepsy was not relevant during guilt innocent and would open the door to character, reputation, and extraneous evidence Based on this, I informed the court that I would not call the coach and that I anticipated having 1 or 2 more witnesses before I would call Mr. Anthony. In response to the judge's question about likelihood of Mr. Anthony's testifying, I told the judge that we would need to confer with Mr. Anthony about his Fifth Amendment decision regarding testifying, but that I was 99% sure that he would, in fact, testify. We were supposed to hear from Karmelo Anthony. After the break, back in court before the jury to give somebody's name that starts with the M more time to arrive at court, we then called Frisco Police Department Detective Riley to testify. After the Detective Riley finished testifying, I then decided not to call blank as a witness. And we broke for lunch early around 11:17 a.m. and the prosecution and defense team stayed behind to talk to the judge outside the jury's presence. This is what leads up to the 2.5-hour break that occurred on Monday prior to the defense resting on their case. On the way back to chambers, Mr. Worski mentioned to Mr. Shook that from his perspective, I had already opened the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony by saying that Mr. Anthony was a member of the chess club during my opening statement. I did not say anything about a chess club at any time. During my opening, I said that Mr. Anthony played chess during my background description of him and his hobbies. Mr. Worski also stated that from his perspective, this agreement did not cover a testifying defendant. Mr. Shook alerted me, and Mr. Worski, Mr. Mitchell, Mr. Shook, and I stood in the well of the courtroom, and Mr. Worski repeated these statements, adding that the prosecution never thought that the defense would call Mr. Anthony to testify. Back in judge's chambers, Mr. Worski repeated his assertion that the agreement between the prosecution and defense never contemplated a testifying defendant. He elaborated, stating that he had never thought we were calling Mr. Anthony as a witness. He also repeated his claim that I had already violated the agreement during my opening statement by saying that Mr. Anthony was a member of the chess club. It is important to note that this was the first time Mr. Worski mentioned that he believed I had violated the agreement days earlier by mentioning that Mr. Anthony played chess during my opening. Although the prosecution and defense teams had conferred many times throughout the prosecution's case in chief about various issues, this was the first time Mr. Worski brought up this assertion. Judge Roach told the prosecution and defense teams that my mentioning chess during the opening statement, it definitely did not open the door to character, reputation, and extraneous evidence applicable to Mr. Anthony. So even the judge agrees with the defense and says the mentioning of chess, not chess club, but playing chess, it didn't open the door. So why is this an issue for the state? The judge says it didn't open the door. The parties then argued about whether the agreement between the parties covered Mr. Anthony's testifying. The prosecution repeated their position that it did not, and that if we called Mr. Anthony to testify, character, reputation, and extraneous evidence pertaining to Mr. Anthony were in play. Furthermore, Mr. Worski stated that at that time that the prosecution already having rested character, reputation, and extraneous evidence pertaining to Austin and Hunter Metcalf was not relevant. When Mr. Shook and I mentioned the ambiguous aggressor rule from Torres, Mr. Worski argued that Torres did not apply because it was not ambiguous who the first aggressor was, that the first aggressor was clearly Austin Metcalf. At this point, the discussion devolved into a shouting match. Can you imagine? So they're in judge's chambers. They're arguing. This is about 5 attorneys in the judge's chambers, and it's getting heated. All while Karmelo Anthony, 19 at this time, is not a part of this in-chamber meeting. So he is just in the courtroom waiting on them to come back and say what's going on because he's on bond at this point, so he's not in custody. So he is not aware of all of this argument about the state saying this agreement no longer matters. He knew that prior to the agreement coming out in May, They hired these attorneys in 2025. So from 2025 until now, they have been prepping their case. So Mike Howard, Toby Shook, they've been having meetings with the family. They say, look what we dug up on Metcalf. Look what we dug up on them. We got to arrest about their racist graffiti. We're going to argue self-defense, and we're going to do this. And like, we got a expert on the epilepsy. We got an expert about the young mind, right? Because they say the brain doesn't fully develop to 25. We got someone to speak to that. We got a mitigation expert. So the family, we paying for all of this. We think we got this great defense we're building. And then May comes and the state says, hey, here's a notice of 75 pages of shit we're going to use against Karmelo. But we'll offer you a deal. You keep out the bad stuff on Austin, we'll keep out the bad stuff on Karmelo. So now this great defense that y'all have been building for months, the experts you got, all of this is dwindles away because of this agreement. Karmelo's in the courtroom. They're fussing and they're fighting and they're arguing, not physical fighting, but they're arguing, shouting match in the judge's chambers discussing this. And you're going to hear that when it comes back to Karmelo, you're going to hear what he's told and the decision that he has to make. Okay. So let me go back. Number 24. After the breakdown of the agreement, the defense and prosecution teams agreed to take 10 minutes to cool off before attempting to renegotiate parameters for how the agreement could extend to Anthony's testimony. So walk it off. They walked it off. Now, should the defense now choose to call him? After the 10-minute cooling off period, Mr. Worski and Mike Howard meet in open court outside the presence of the jury and without the public in the room to discuss possible parameters for the agreement covering Mr. Anthony's testimony. Okay, so now they're back in the courtroom, not in the judge's chambers, but everybody's kept out. Given Mr. Worski's expansive view of what he considered would open the door to character, reputation, and bad acts regarding Karmelo, especially his repeated claim, even after the judge stated otherwise, that even my mention of playing chess opened the door, I resolved that my only choice was to go over my planned outline of Mr. Anthony's direct examination line by line. Line by line. The defense sat down with the state prior to Mr. Anthony testifying and went over his testimony outline line by line. They do this so that Mr. Worski can determine what would and would not, in his view, open the door. Mike Howard says, I have never taken such a drastic step of previewing my strategy and even my questions with the prosecutor, but as a defense team, we agreed that if we had no other option, if we wanted to try to reach an agreed understanding with Mr. Worski on how the renegotiated agreement would cover Mr. Anthony's testimony. As I went through my outline with Mr. Worski standing, reading the outline over my shoulder, Mr. Worski declared various subjects that, in his view, would open the door to character, reputation, and bad acts pertaining to Karmelo. During this discussion, Mr. Worski repeated his claim that my earlier mention of chess opened the door. While I disagreed with all of Mr. Worski's assertions of subjects that would open the door, I agreed to cut them from my questioning in the hopes of salvaging the agreement to keep Mr. Anthony's bad acts out if he testified. At the end of this discussion, with the understanding that Mr. Worski would extend me leeway to lead Mr. Anthony more than normal through certain aspects of the testimony in an abundance of caution to avoid opening the door, Mr. Worski and I informed Judge Roach that we had come to an agreement as to how the renegotiated agreement would cover Mr. Anthony's testimony. We then summarized the process we had just gone through in our renegotiated agreement on the record, meaning we got a court reporter this time. Prior to breaking to allow the defense to retire to the defense room to discuss the issue with Mr. Anthony and his parents, Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between the parties. A whole trial has occurred. There's been a voir dire. There's been jury selected. That's voir dire. They have had openings. They've had the state presentation of their case. And not one time did Judge Roach say, I know y'all got that agreement, but I ain't got no way to enforce it. Not until Karmelo gets ready to testify and they get into this argument. Now he has no mechanism to enforce it. Even though this agreement, he knew about it before trial started. They talked about it in his chambers. He says he has no mechanism. Furthermore, Judge Roach informed us that he saw no way for Mr. Anthony to testify without the door being opened. For example, if he said that he brought the knife by accident or said that he was scared, etc., this would almost certainly open the door to character, reputation, and bad act evidence of some sort. To clarify the issue, I propose the hypothetical scenario that if Mr. Worski claims that the agreement had been breached in some way, if I and even the judge felt that Mr. Worski was operating in bad faith, that the judge was stating that he could not enforce the agreement. The judge says that he would have to make a ruling based on the Texas rules of evidence alone, and that in all likelihood, the door would have been opened. Judge Roach confirmed that this is the case, because Mike Howard asked for clarification. Like, Judge, are you saying that even though you told the state that I didn't open the door and you know about this agreement, are you saying that if we put the client up to testify, you're not going to honor this agreement? Judge says, no, I got to follow the rules of evidence alone. Everything that a defendant may likely testify may open the door. So if you try to object, I'm going to follow the rules of evidence. And at that point, the bad act stuff is going to come in. But the judge knows that they've been acting under this agreement the entire trial. But he allows the state to basically renege on it, because now he says, once they are, I don't have a mechanism to stop this. Mike Howard says, we then broke to discuss the issue with our client. Mind you, this whole 2.5 hours, bulk of this has been the attorneys talking amongst themselves, arguing in chambers, getting told to walk it off. All that time, Karmelo and his family have been in the defense holding room waiting. So they haven't been privy to any of this. Judge Roach gave us approximately 10 minutes to explain the breakdown of the agreement and the proposed resolution with our client before the judge brought Mr. Anthony in for an on-the-record admonishment. During the initial pre-admonishment meeting with Mr. Anthony and his parents, I did my best to explain everything that had just happened with the help of Mr. Shuk and Ms. Gupta. We then returned, mine only had 10 minutes. So imagine hearing after you paid for this amazing defense attorney with the public's money that was raised on GoFundMe. And you all have been prepping for trial for months. You then get this agreement to keep everything out, and you're like, great, you're going to get to testify. They're not going to be able to bring up all of this stuff. You've been prepping your testimony. You're getting ready to testify, and your attorney walks in and say, hey, man, listen up. We got 10 minutes to talk. I got to tell you what just happened. The state is no longer honoring this agreement, and if you get on the stand to testify, they're bringing up that 75 pages of bad acts from your cell phone and your school records, okay? So I need you to understand that you got 10 minutes to decide whether or not you're going to testify. Now you could test. So he got 10 minutes to explain to a 19-year-old child that the plan that we have been working on for months is no more. And that you got 10 minutes to decide whether you're going to take a chance of this 75-page stuff that I've been telling you is going to be kept out. You got 10 minutes to decide whether or not you're going to testify or not. Does that sound fair? Put a 1 in the chat if that sounds fair. Put a 2 in the chat if you're like, that doesn't sound right. I don't know if it's right or not. I don't know if it's fair or not. We're just reporting what happens, right? And our feelings, as we know from this, they don't matter. It's about what the law says. But if they have an evidentiary hearing on this, and this comes out to be the truth, will the court deem that this is fair and due process? That the state was able to rely on an agreement for the entire trial, and then right before the defense gets to testify, they get to say, oh, we didn't anticipate him testifying. But how is that possible? Because How else was all this extraneous evidence from his cell phone going to come in? You can't get what's on Karmelo's cell phone in by anybody else testifying. You have to have the defendant testify unless they had this search warrant and the officer was going to come in and talk about how he got the phone during the search, and then they downloaded all this stuff on his phone, right? That you could get it in that way, right? But the state would have done it on their state case in chief, and then the defense would have crossed, right? It didn't happen. The state's over with. So this is the defense case. So now that it's the defense case, how do you get that evidence in but if the defendant testifies? So how is the state arguing they don't believe the defendant was covered by this agreement? It makes no sense. This is what happened. Going back to the affidavit, it says that during the initial pre-admonishment meeting with Mr. Anthony and his parents, I did my best to explain everything that had just happened. With the help of Mr. Shu, I'm explaining to you all what happened. And hasn't this taken longer than 10 minutes? We've been on for 5 hours and 2 minutes. Like I'm going through this affidavit, like just what happened. If you were to tell somebody this is what happened over the last 2 hours, that takes longer than 10 minutes, right? I got to wrap it up. I got to tell you, this is what happened. These are your rights. This is what can happen if you testify. You got 10 minutes to decide. You know, Karmelo's mom is in there crying. Dad is like, what the hell's going on? Karmelo's probably looking like, what do I do? What do I do? 10 minutes. We then returned to the courtroom for Judge Roach to admonish Mr. Anthony about his Fifth Amendment rights and also to explain that if he testifies, Judge Roach believed he had no mechanism to enforce the agreement between the parties and would rule on the rules of evidence alone as to whether the door had been opened. Judge Roach then gave us 10 minutes to discuss his Fifth Amendment rights with Mr. Anthony and help him ultimately decide whether he would testify. I asked for additional time to have such a complicated discussion with a 19-year-old in the most stressful situation in his life, but Judge Roach declined to extend our time beyond 10 minutes. Again, we did our best to explain everything, the pros and cons of testifying versus not testifying, the likelihood of winning on self-defense if he testified versus if he did not, the likelihood of whether we could get instructions in the jury charge on the lesser included charges of manslaughter and criminally negligent homicide if he did and if he did not testify, and the likelihood of whether we could get instructions in the sentencing jury charge if we got there on sudden passion if he did and if he did not testify. This is all that Karmelo has been told in quick 10 minutes. You got to consider this, consider that. If you don't testify, what's going to happen to our self-defense claim? Down the drain. How can we argue sudden passion if you don't testify? Like, these are all the things he's having to consider in 10 minutes. During this discussion, beyond all of the above, the most complicating factor of all was whether Mr. Worski would claim that we had opened the door and then bring in Anthony's extraneous offense, bad character evidence based on his actions and claims, specifically his repeated assertions, even after the judge had firmly disagreed that I had opened the door by mentioning chess, as well as his general claim that the agreement had never contemplated Mr. Anthony testifying. Despite the plain meaning of the words Mr. Worski himself repeatedly used to describe the agreement, the defense team felt strongly that the risk of Mr. Worski claiming the door had been opened was too high. This was amplified by the fact that Judge Roach made it clear, should Mr. Worski claim a breach of the agreement, he felt he was unable to enforce it and that in all likelihood the door would have been opened. At the end of the 10 minutes, despite our request for additional time, Judge Roach called us back to the courtroom to announce Mr. Anthony's decision and proceed with trial. Ultimately, Mr. Anthony chose not to testify. This 180-degree change in the defense strategy was the direct consequence of the breach of the agreement. The breach of the agreement affected all aspects of the defense case. By the time that the agreement was breached, it was too late to change or our approach in voir dire opening, too late to ask different questions of the prosecution's witnesses, and too risky to recall those witnesses to ask questions that would risk the prosecution deciding we had opened the door. It greatly hampered our strategy during sentencing, causing us to decide not to call witnesses we otherwise would have called and severely limiting the questions asked of the one witness we did in fact call. The prosecution's breach of the agreement directly and significantly undermined the defense's ability to present a complete defense. This is the defense attorney, Mike Howard's sworn affidavit, sworn to on July 5th and notarized. Wow. Like, unbelievable, right? We get answers to every question that we have, right? We now know why Karmelo didn't testify. We know why they didn't mention any bad acts about the twins. And it's because of this gentleman's agreement. Now, we were in ground 2 of Karmelo's motion for new trial. And if you recall, they're arguing that this agreement and the breakdown of this agreement was unfair. And that because the defense relied on this agreement so much, right? It developed their entire case. And the state, they relied on it as well. They didn't mention all this stuff to the other defense witnesses that testified. They didn't bring up any of this evidence. And even though they say that the defense breached this agreement by mentioning chess, the judge says they did not. The state, although they didn't want to stay within the agreement for Karmelo's testimony, they went right back to the agreement during the punishment phase. They didn't put up any evidence during the punishment phase, and they held Karmelo Anthony's mom to 3 sentences per the agreement. So if we breach the agreement, why not go into the sentencing phase, bringing in all of this evidence, bringing in all of the bad character evidence, bringing up things that you could argue? Why not? Why did you follow the order after you say that we broke it? Like this. So what the defense is arguing is that this is unfair. It's not due process. Have a hearing, because this is not an argument that means he gets an automatic new trial. They're saying have an evidentiary hearing. And if you find from this hearing that what we are saying is what occurred, the state cannot benefit from a reliance on agreement that they then want to take away from the defense when it's their turn. And so then that would be something that's unfair and would be justification for a new trial. So we're going to go to some super chats. Shout out to Prayer Changes 7154. Oh, we already read that one. I'm sorry. Let me go to, I know some more that came in. Okay. Anthony Peterson 5618 sends a $2 super chat. Witnesses' opinions. What say you? Be more specific. When you say witnesses' opinions, are you meaning like when the state would ask every witness at the end whether or not they felt like Karmelo was the aggressor and that this wasn't self-defense? I thought those questions were improper because they are a conclusion of law. And usually a witness cannot testify to a conclusion of law, right? They can only talk about what they saw, right? Especially a layperson. And so I thought that was strange, but it wasn't objected to. That's not raised in this motion. So maybe it wasn't in violation of Texas law. Egyptian Deity 1862 sends a $2 super chat. Thank you. Why didn't read HM3 accounts of the incident into record? Why didn't read Hunter Metcalf? Okay, so why didn't they read Hunter Metcalf's 3 accounts of the incident into the record? You can't do that. So police reports are not evidence, and someone has to testify to get that in. So Hunter didn't testify. Actually, he didn't even appear to the hearing, to the trial at all. I was thinking as the trial was first occurring that they were keeping Hunter out because they potentially want to bring him as a rebuttal witness. If Anthony testified, then they could come back and the state could bring rebuttal witnesses and he could come in and talk about what he saw that contradicted what Karmelo testified to. That's what I thought. I don't know if that's true or not. They didn't address it. So I don't know. But you can't just read into the record his other 3 what could have happened if they didn't have this gentleman's agreement. If Hunter testified but made different statements, they definitely could have cross-examine him on that and impeached him on that, but he would have had to testify for that to happen, and he wasn't even at the hearing. So I definitely don't believe the reasons they told us he wasn't there, but he wasn't, and so his testimony couldn't be questioned. Oh, the Spanish name, I know. Marina, Madvida, mi amor. I can't say it like Lee, but hopefully I got a little bit of that right. Sends a $10 super chat. Glad to catch you live. You and the lead attorney need to have a discussion live on this topic. I would love to hear two attorneys with your experience give us perspective. Hashtag Team TLA. Shout out. Y'all put lead attorney's channel in the chat, one of the mods if you can. TLA is an amazing YouTuber on this channel. He gave me the TLA effect during the YSL trial, hence how I got a channel and was able to get monetized overnight in my first live that I had on my channel. So, which I think is a record. Okay, I'm holding it as a record. Because we had like 17,000 views on that video. And as soon as I ended that live with China, who was the wife of the first defendant to take a plea in the YSL case, over 1,000 people in that chat. It was amazing. It had over 4,400 watch hours. So like I said, I was monetized live #1 thanks to the support of the lead attorney. So yes, shout out Marina, Madvida, mi amor. I can't say it like Lee, but hopefully I got some of that right. Thank you so much for your super chat. Ed for Dread sends another $10 super chat. Shout out. Thank you so much. He says, Bill Worski hit Howard and shoot with the okie doke. He says, well, our case in chief is done. So Metcalf twins' bad acts are irrelevant. Roach and Worski played them until that sentence should have been life in, been LIO. Let me see. What is, yeah, I'm sorry, I'm not catching that acronym, but yes, this it seems that way, right? It does feel like they got played, right? They came into this agreement, but did they play themselves? They didn't put the agreement in writing. They didn't require that the agreement went in writing. And I never heard from this affidavit that Mike Howard ever specifically, explicitly stated, hey, Karmelo's testifying, does this agreement cover him? They presume that it did, right? But that's the question, right? Because it wasn't in writing. However, if all is true that Mike Howard says in his affidavit, and they had these conversations, and they said things about Anthony testifying, and this Torres case came up, and the ambiguous aggressor stuff came up, then they definitely knew Karmelo was testifying. Plus, I don't even know how you get in all of that bad facts evidence without him testifying, right? So that feels like a BS argument that they didn't think he was going to testify. And the judge himself says they didn't open the door. So it really feels dirty that the state would not, that they would renege on this agreement. And that is what the defense is arguing in their argument #2, is that because of this reneging, after they substantially relied the state to their benefit, they got the benefit of this agreement. And then when it was time to benefit the defendant, they snatched it away. And so that's not fair. And so that's what the defense is arguing in their second prong of the motion. And they want a hearing on it. And they want that hearing to decide whether or not, if this is true, and then if this is, to rule that due process wasn't given, it's unfair, and he needs a new trial. So thank you so much for that super chat. Shout out to Misty Black, sends a $5 super chat. Do you think that was the strategy for the prosecutors came up with the agreement to scare the defense because their case probably was not as strong? I definitely think they were motivated to enter the agreement because they knew that, not that the case wasn't strong, because what happened under the tent happened, right? There's no argument about that. Karmelo stabbed Austin. He said, I did it, but his argument was self-defense. But I think the state proposed this so that they could keep out the bad stuff about Austin and Hunter. You don't want that. If you're trying to win this case and it's already racially motivated, right? You do not want it to come out that Austin has been arrested for racist graffiti. So they propose this agreement so that they can benefit from it. Mike Howard just failed to get it in writing. And the way this judge is ruling, I don't even know if it was in writing, if it would have changed things, but it doesn't feel right that, judge, hey, you didn't speak to the fact that you couldn't enforce this agreement. We abided by it. And now that they're trying not to, all of a sudden you can't enforce it, judge. Like, it just doesn't feel good. It doesn't feel like it's due process to Karmelo. So great question. Thank you for the super chat. And while I think they necessarily weren't scared about the facts. They definitely may have been afraid that the bad things coming out of Austin would have strengthened Karmelo's self-defense claim. So I definitely think that's what led them to make that agreement. And Ed for Dread sends another $2 super chat, says lesser included offense. Okay, thank you for helping me understand with the LIO. Yes, I agree. I let me say this. Based on the evidence that was presented at trial, I do see how the jury reached murder, although I did want them to come back to a lesser included. However, now that we see what all was kept out, if the trial is anew and all of this stuff comes in, I think we're definitely down to a lesser included offense. And we could even get down to criminally negligent homicide, which is a 1 to 10. And so if there is a new trial and the jury finds Karmelo guilty, not of murder, but of manslaughter, time can't be worse because the max on that is 1 to 20. And the max on criminally negligent is 1 to 10. So those will be the type of things that he'd be fighting for and happen occurs if he gets a new trial. So thank you again, Ed for Dread, for that super chat. Y'all trying to get down. Okay, we got one more. Meek 595 sends a $5 super chat. What do you think about Mike Howard having to show his outline to the prosecutor? Crazy. But I get it, right? We can't go back, right? So the point that he gets here, he's like, okay, the state is saying if you testify, Karmelo testifies that it can open the door. Well, let me see what I can salvage, right? Because of course they all want Karmelo to testify because the self-defense claim is out the window when he doesn't, because there has not been a witness that has testified to a need for self-defense, right? We haven't heard, no witnesses testified about a jumping. They testified about a push, right? The witnesses didn't testify that Karmelo, they all testified that he was the aggressor, right? And that they felt like he wasn't acting in self-defense. So they needed Karmelo to testify to speak to his state of mind. What made him fearful? What made him feel like this deadly force was the only option in this case, right? Because if I'm just going off a push met with a stab, I'm like, yeah, that ain't enough, right? So we needed to hear from the defendant on this case. So Mike Howard at that point, he's doing what he can. He's trying to save it. He's in desperation. Okay, let's go through this agreement line by line. What are you cool with? But I don't like that. It gives Bill Werski like this power, like he's the prosecutor, he's the judge, he's making all these decisions about what opens the door. He's not the trial court. How do you get to make that decision, right? And the judge tells him the chess playing didn't open the door, but he still stands there and says, put Karmelo up. And I'm bringing in that evidence because forget what the judge says, it opened the door. Like, that's very unfair. Shout out to Ayana from Oakland, sends a $10 super chat. She says, are we sure that Melo would have been convicted based on the actual Texas law? I saw somewhere that the law wasn't applied properly. Proportionality isn't relevant according to the law, I hear. Great question. If you go to my last live on this, it was the jury got it right. In that trial, we broke down what the murder statute requires and what your question is on why people feel like the verdict still wasn't fair was this provocation argument. And that is the defense's third ground in their motion for new trial that we're about to get to, is that they feel like the judge gave an improper instruction to the jury that said, if you believe Karmelo was the initial aggressor, that he can't use self-defense. But you heard through Mike Howard's thing that even the state was clear that that Austin was the initial aggressor, right? But the state is resting on the fact that jurors are lay people. They're not attorneys. So let me play to the law based on the evidence I have and what my story is. And I'm going to convince them that Karmelo's standing firm and saying, y'all are a bunch of pussies, make me move and touch me and see what happens, that's going to make him the aggressor. So therefore, he can't claim self-defense. And so that is the jury charge that is the basis of these defense's third argument in the motion for new trial. So thank you, Ayana from Oakland, for that $10 super chat. Great question. It leads us into the defense's third argument. Now, based on Texas law for murder, premeditation is not required. You got to prove identity. Karmelo said, I did it. That wasn't a question. Causation, the ME testified that the knife caused the death and talked about the wound. Then you're left with intent. And the law in Texas says that intent can be proven in 3 ways. It also says that the juror doesn't have to agree on that way that intent is found, that each juror could find intent in a different way. But if they find it, they can find him guilty of murder. And intent in this case was shown by the fact that Karmelo intended to stab Austin with a knife. And I mean, you can't really argue that stabbing somebody with a knife is not going to cause serious bodily injury. So the intent was that you intended to cause serious bodily injury. That's with the knife stab. And then that the action that you did, stabbing, is something that can cause the death of a human. I mean, you can't disagree with that, right? Stabbing somebody with a knife definitely can cause the death. And it was the cause of death in this case. And stabbing somebody with a knife is going to cause seriously bodily injury, right? Is no other way that it cannot. So they inferred intent there. It doesn't have to be premeditated. And they're not saying he came to the track field with the knife intending to kill, but the intent was inferred from his actions of stabbing. And that whole provocation, cutting out the self-defense, was a major concern and issue. So maybe that is what you've heard. But if you check out that last live, we do break down the law, put it side by side with the facts, and show how the jury could have come to that conclusion. Ed for Dread sends a $5 super chat. You've got to be stream sponsored by that. I don't know. I got a $50 one here. I got to go back and add, right? There's been so much going on. We've been on for 5 hours and 23 minutes, but I will go back and add up and shout out all the stream sponsors in the description of this live. He says, I feel the worst part of the agreement is not being able to impeach witness testimony versus statements from date of offense. Yeah, because some kids made statements the day that this occurred, adding in the aggressive part of Hunter and Metcalf, and that's what the defense agreed to keep out. So taking into account what they agreed to keep out that benefited the state, it just makes me feel like, what the hell did they have against Karmelo that his attorneys didn't want to come in, that actually ultimately led him to not testify at trial? We're going to find out. You best believe the state is going to put that kind of stuff in their motion when they respond, right? Because Mike Howard's giving this affidavit, talking all this stuff about the state and how they acted. I can only imagine that the state will kind of do the same things in their motion, and we'll be able to hear like what their arguments are. So we're at 5 hours and 24 minutes. Lead told me that this is going to take me 5 hours to cover, and I said, you got to be crazy, Lead. And here we are, but we are coming close to an end, because I mean, I told you this motion was 63 pages, including signature, but 58 of a typed document with arguments. 48 was the first argument. We already gone over it. And the last 10 pages had 3 arguments. So we're already through the second. They're talking about, the state not really relying on this agreement to the defense's detriment after they couldn't change anything about it. So that's that argument. The third argument, the fourth, is that the cumulative effect of all of these errors. So we don't have to spend so much time on that. The third one deals with the jury charge, and that is going to be a quick one to review. It's on page 55. I told you this ended on page 58. So we are almost at the end. So thank you so much for everyone with the super chats and all of the questions. Let me actually go back and just see if there are any questions that I did not grab, y'all, because the super chats were popping up and they stick out first. Okay, so True Advocate says, first of all, the video didn't show that Karmelo stabbed Austin, so I'm trying to see how he was convicted. And that opinion is held greatly by a lot of people. You feel like there needs to be video evidence of a crime, and that's not required. The law says that the testimony of one witness can be used to prove a fact. We got way more than that. The state presented 21 witnesses. So you don't need a video of the stabbing. You don't even need a video of the incident. If you have witnesses that were there, that their testimony can prove that they were actually there. You have the testimony of the ME about the injury that was caused. You have Karmelo on body cam stating that he did it, meaning he stabbed. Now, he has an argument that he did it in self-defense, but this case was kind of cut and dry, which is why they agreed to try it clean, because it wasn't something you had to bring in all of this evidence. You didn't have a gun shooting. You didn't have multiple weapons. And I got to know what bullet hit the person and killed them. Like, it wasn't all of that here, right? It was kind of cut and dry. There was a stabbing. Karmelo never disputed that, right? it's his case, right? He has attorneys. You haven't seen that raised in any argument that I wasn't the person that did that. Identity wasn't an issue. Causation wasn't an issue. This case came down to could the state prove intent, and could they prove beyond a reasonable doubt that I didn't act in self-defense? And that was greatly the ability to present that defense was greatly hampered by this gentleman's agreement, that ended up being the reason Karmelo didn't testify. So you don't need a video of a crime to be able to convict someone. Y'all talking about some other stuff that happened in Collin County. Let me see if I see any questions I need to address. So Perfect Blackness Senior says, and Missy Black, this is exactly what I think. This was a horrible deal that Mike Howard agreed to. Whatever's Melo's negatives are, Mike Howard should have been an attorney and overcame it on cross. And that may be a lot of people's opinion, right? And so there has not been an ineffective assistance counsel argument raised in this motion. So they're just basically saying this is what happened. They're not second guessing his actions, but calling out where the agreement broke down. Like, it definitely should have been in writing. It definitely should have been clear that it covered the defendant's testimony if they were going to enter it. All right, so we're going to go on and get into the last argument the defendant had. And I shout out to everybody that's still in the chat. The best chat on YouTube. It has been 5 hours and 28 minutes, and you all are still in the building. I so greatly appreciate you being here, and I hope that you're providing or receiving value from this live and kind of understanding from a layperson what this motion for new trial is breaking down. So thanks for tuning in. And if you have me watching on Facebook, because we are streaming there as well, I can't see your comments. I'm not that savvy enough. I got to focus on one stream at a time. So jump on over here to YouTube if you have a comment to leave and you want to join the chat conversation. But thank you for watching there as well. All right, so this third ground for new trial, the court's unsupported provocation instruction and properly limited the defendant's right of self-defense. So this is dealing with the jury charges. So trial is over. The defense has rested. They've had this fight about the agreement, and the judge is getting ready to start closing arguments. Prior to doing closing, he is going to charge the jury with the law that they need to apply on this case. So they go over this. It's given, after closings, but you discuss it kind of at the top of the day that closings, and the jury will get it. You kind of go over it as the defense and state argue to the judge why certain charges should be brought in. This is when they were able to get the judge to agree to give a manslaughter charge. This is how the jury got charged with the lesser included. So that is what, this is dealing with. So during that jury charge conference, the state argued, and the judge decided that they were going to give a provoking the difficulty instruction. A provoking the difficulty instruction is one of the few charges that can take a defense away from the jury altogether. Properly given, it tells the jury that a defendant who provokes the encounter forfeits the right of self-defense he would otherwise enjoy. For that reason, the Court of Criminal Appeals has held that the instruction may be submitted only when the evidence supports each of its 3 elements, and that giving it without that support is error. The case cited is Smith v. State. Here, the instruction was given without that support, and it did to the defendant's self-defense case exactly what an unsupported provocation charge always does. It invited the jury to set the defense aside before weighing it. On a record in which self-defense was the heart of the case, that error was not harmless, and it requires a new trial. So the defense is saying if the court feels like given this provocation, and we talked about this on the live when I said the jury got it right, because I went to the self-defense law. And in the first section of that law, there were 2 different statutes that cover self-defense. It gave what kind of had to be in place and what couldn't exist if somebody was going to claim self-defense. And it said that if you found provocation, that the defendant provoked the encounter in order to use violence to claim self-defense, he could never raise self-defense. So what they're saying is that by the judge giving this charge and saying that the state had met their burden in proving the 3 elements that are required for this charge, it meant that the jury agreed with this provocation charge. They didn't have to even consider self-defense. So it didn't matter if Anthony testified or not. If this charge was given, the jury could rest there, dismiss self-defense, and now we're only looking at, is it murder, is it manslaughter, or is it not guilty? And it would have been not guilty, not based on self-defense, because you would have found provocation, but it would have just been not guilty on the state not meeting their burden on the charges. And so they're saying that this mistake, it is detrimental, and that is not a trivial error, and that is, you don't get the harmless error either. You don't get to say like, oh, this didn't really hurt the case, because how can it not, right? If you take out my whole defense, that's not harmless error. And they're saying that Karmelo would deserve a new trial, but this is their third argument, which means they feel like this is one of their weaker arguments, but it's an argument that they're making nevertheless. And if it's granted and the court agrees, he gets a new trial. The defendant's defense at trial was self-defense, and the jury was charged on the justified use of deadly force. The court's charge, however, also instructed the jury on provocation, that the defendant forfeited his right of self-defense if he provoked the difficulty. A provocation or provoking the difficulty instruction is a limitation on, and in some cases, a negation of the right of self-defense. And for that reason, it should rarely be given. It may be submitted only when the evidence supports each of 3 elements. Number 1, that the defendant did some act or used some words that provoked the attack on him. That the act or words were reasonably calculated to provoke the attack. And that 3, that the act was done or the words were used for the purpose and with the intent that the defendant would have a pretext for inflicting harm upon the other. Let me break it down. So what this provocation difficulty says is that the defendant used something, some words or some actions to provoke the attack. So they're saying Karmelo's sitting there when being asked to leave 15 times, refusing to leave, calling them some pussies, saying that you're going to have to make me leave, that touch me and find out what happens. They're saying that those things that Karmelo did those in order to get Austin to attack him, to provoke the attack. That the words were reasonably calculated to provoke the attack, that he's using these exact words to provoke being attacked. And that the act was done, his provocation, the words used, for the purpose of when Austin does touch me after I provoke him, boom, I can stab him. That's what the state is required to show in order to argue this. And what they feel, I mean, the judge gave the charge to the jury. So the judge says, I feel like the state showed this, and that's utterly ridiculous. I can't even follow that thinking, that you think that Karmelo purposely enticed Austin to push him so that he could take this knife that he brought to the track meet that day. Prior to this occurring, he doesn't have a crystal ball, like that he set out to do all of this just so he could have the chance to stab Austin. I don't believe the evidence presented at trial showed that. And so the defense says they don't agree either. In what Smith v. State says, if you can't prove all 3 elements, then you don't get to give this charge to the jury. But the judge gave it anyway. And so they're saying, hey, court, as you're reviewing this, we feel like this is an error. And if you agree with us, this means Karmelo gets a new trial because the jury was charged improperly. The defense says the charge here gave such an instruction. It directed the jury that if the defendant immediately before the difficulty did some act, use some language, or both with the intent to produce the occasion to bring on the difficulty and kill Austin Metcalf, and that such conduct was reasonably calculated to and did provoke the difficulty, to which Metcalf responded, sorry, by attacking or appearing about to attack him, and that the defendant then killed him in pursuance of his original design, the jury would find against the defendant's self-defense claim. I don't believe the evidence was there to show that, right? We don't have any text messages. We don't have anything to show Karmelo's thinking or his plan prior to this happening, or the reason that he brought the knife there. We don't have any of that in this case. Wasn't internet evidence. So, I mean, it feels like this jury instruction may have been improper, right? So, you know, I don't know. I mean, I see someone saying people can no longer claim fuck around and find out, or that's provocation, folks. I mean, it's like, that's basically what we had here, right? There was a conversation, leave the tent, and you got to leave. It's not your tent. And Karmelo's like, hey, touch me and find out. Like, y'all gonna have to make me leave. Maybe he did say all those things, but was it a plan that he's purposely saying those things to get Austin to push him so he can then stab and kill him? I don't think the state proved that, and that's what the defense argues. And if they didn't, then there wasn't enough evidence there for the judge to give that instruction. So that is the third argument. They say that even viewing the evidence in the light most favorable to submission of the instruction, the record did not permit a rational finding on the third Smith element. The state may point to evidence that the defendant remained in the area, exchanged words with Austin, possessed a knife, or took part in a confrontation. Even credited, such evidence does not show that the defendant acted or spoke with the purpose and intent to provoke Metcalf's attack as a pretext to inflict harm. That is a requirement. They're saying it wasn't met, and therefore provocation, it being given to the jury, was improper. They say provocation requires more than words, presence, poor judgment, or participation in a confrontation. It requires evidence of a performed design to create the occasion for deadly force. And that wasn't shown, so it couldn't be in. And this talks about the law on it. The error was harmful and it was preserved. They said the defendant objected to the submission of the provocation instruction. So the issue was reserved properly at the trial court. And they're saying that the law says that this error is not harmless error, that if the court finds this, they have to give a new trial. And so this is the third ground that the defense moves on. Their fourth ground just speaks about basically the cumulative issue, basically all of you see it's just a paragraph. The fourth ground is that a new trial should be granted in the interest of justice. They're saying that the cumulative effect of all of these errors means that Karmelo did not get a fair trial and that a new trial should be granted. Woo! 5.5 hours, y'all. 5 hours and 40 minutes. And we have covered this motion for new trial in as greatest detail as I know how. We have reviewed the motion. We have gone through the arguments. We've gone over the Waller points, the Presley requirements, right? Y'all could go take a law school exam on those issues, right? We've gone through it so thoroughly and discussed what the defense is arguing. And so now it's going to be up to the trial court. The district court is where this case was heard. The district court will decide this motion for new trial. The state I saw people putting comments in that the state has already said that they are going to respond to this motion. And after we just finished reviewing Mike Howard's affidavit not too long ago, you see that they have to, right? Because there were so many allegations raised against the state in their bad behavior and reneging on their gentleman's agreement that they have to respond. So we'll be back. We're going to get the state's motion when they respond, and we're going to come back and we're going to give it the same energy. Okay. I love the law. This is Legally Speaking with Fit, and we go over the law over here. So we're not one-sided. We're not biased. Of course, this is a biased presentation, right? Because it's the defense's witness. The defense's motion. I don't have the state's motion yet. When we review the state's motion, it'll be the argument from their side. And the court, per the Texas Court of Appeals, I pulled that up. We went over it. They actually have 75 days from the day of sentence to rule on this motion for new trial. And I believe that deadline like is around August 23rd, which is a weekend. So the defense has asked for a hearing by August 21st on this motion. Remember, the defense has also filed a motion to recuse Judge Roach based on his interview. And we played some of that interview here in between this live. And in that interview, he talks about the verdict, believing the jury got it right. Karmelo is a good kid, but he learns the consequences of his actions more than anything now. Those are statements he made. He also says that he thinks he may have should have used audio streaming in this case so that the public could hear what was happening. He actually came back, I believe, like 9 days after the trial and released the entire evidence file of the evidence submitted in court because he felt like transparency needed to be out there because there were so many, false stories in the news and media, but he contributed to that, right? He issued a gag order July 28th, 2025, sua sponte. No party asked for that gag order. He issued it on his own, saying that everybody with actual knowledge in this case had to be quiet the entire time until trial was over. And 2 days after trial, he's given an interview. And then he does an oral order after the case is over with, keeping the entire case file in his chambers. We talked about how the appeals court couldn't even get a copy of the trial record. One, because the transcript hasn't been started. The court reporters haven't even started on it. And the judge is holding the entire case file in his chambers. So there was a lot that the defense put in their motion for new trial. If you're just joining us, go back to the beginning. We break it all down. We started this live with Miss Quincy Hill, coming up as a court reporter in federal court in Florida. She started out in Fulton County, and that's how I know her. I was a public defender here in Fulton County. And Fulton County is the court that the Waller versus Georgia case comes from that gives Judge Roach his requirements for restricting access to the courtroom. The Presley v. Georgia case comes from DeKalb County, and that also requires that he consider reasonable alternatives on the record. The defense argues that doesn't exist here. And so for that reason, Karmelo gets a new trial. They also argue the gentleman's agreement. The state highly relied on it to their benefit up until Karmelo was supposed to testify, and then they renege on it. And so they say that is undue process. It's not fair that they should get an evidentiary hearing on that. And if the court finds that it was unfair, that he should get a new trial. They then lastly argue that the provocation charge that was given to the jury at trial was improper, that they didn't prove all the elements of the Smith case that was required for them to give that charge to the jury. And that if they did that and the court finds that they didn't have all the elements, it means a new trial. So number 4 was that all these cumulative effect arguments are detrimental to Karmelo's right to a fair trial, so he deserves to have a new trial. So we'll see, right? The court has until August 23rd to rule on this motion. If they fail to rule on this motion, meaning they stand moot on it, like they don't say anything, no written order, no oral order, the motion is denied by law, okay? And then they would just have to take this up on the Court of Appeals. So I hope you all enjoyed the live. Let me see. We've been here for 5 hours and 45 minutes. We still got 217 in the chat. Be sure you like, share, and subscribe to the channel on your way out. Mindy Ann 44, the amazing moderator here on the channel, says telling someone to leave is not bullying. And yeah, right. Telling somebody to leave isn't. But are you then, if you get physical in telling somebody to leave, does that now make you a bully? Like you didn't go get a teacher, you didn't go get someone else, but now you're telling me 15 times to leave. I'm not doing anything to anybody. It's kind of drizzling out here. There are some other people that aren't, memorial students under this tent. Like, is it a big problem? Is it really a concern? Can we not go get an adult? Do you get to then put your hands on me and push me so forcefully that I fall back into somebody else? Do you get to do that? Does that rise to bullying? I don't know. Great questions. Yeah. All right. So I'm just going through trying to see if y'all have any last minute questions. It's real common sense says you see the school has no lawsuits. I wonder why. I don't know if they do or not. I haven't looked into that. If anybody is suing if there's filing a wrongful death claim saying that there was security issues or something at the school, I don't know. So that, really doesn't matter the facts of the case as far as the criminal case is concerned. Meek 595 is talking to Latria Watley, saying the people who saw it at Frisco says it's not what they saw, and what they're referring to is the video. Frisco ISD allowed people to come view the exact video from the incident that occurred at the stadium, that because Frisco ISD owns the stadium, so they own the footage that was taken from the stadium. I contacted them a few weeks ago to say, like, hey, can I come see the video? And they directed me to the form to fill out on their website, as well as an opinion from the Attorney General. I think his last name is Paxton of Texas. And back in September of last year, after about 50 or so people had seen the video, the school now says, wait a minute, do we have to keep letting people see this video? Like, is there some way we can deny these open records requests? And the Attorney General issues an opinion last September saying, yes, you can deny these requests because, one, it showed like by looking at the camera, you're able to show where the security camera is set up. And so that breaches the security concern. Like, sounds so minuscule, but anyway, the law is there. So they were able to deny. So no one has been able to go to Frisco ISD to see this video since September, I believe it was 28th, 2025, when the order came down from the Attorney General. So that is what her question refers to. People who have allegedly seen the video, because I don't know factually, I haven't seen any sworn affidavits of that, but they say that the video was clearer and that you could see more things. However, the defense attorney in this case, they had the video. They could have played a different video if it showed other things at the trial. And I will say that although Dominique Alexander hasn't led the family down the right path this entire case, he did say on one of his interviews that he saw that video and it did not show a jumping. So I don't know. We can't really speak to it right until it comes out. Yana from Oakland says, love your content. Keep going. Thank you so much, Yana. I'm so thankful that you all tuned in today to see us break down this thing. Let me see. It's real. Common Sense says, I remember you starting with lead. Yes, the lead attorney. He would bring me up through the YSL trial to kind of give some commentary. And then he gave me the TLA effect. And here we are. So thank you all so much. Yes, Paxton. I did not see his post, but his bias doesn't matter. He's the Attorney General. He doesn't have anything to do with the criminal part of this case. He just ruled on the fact that, you couldn't keep coming to Frisco ISD, which I was very surprised that people could do this, right? I've had a case that occurred on a school bus here. And for me, the attorney represented the defendant, who was an adult who got on the bus and kind of cussed the bus driver out. In order for me to see that video, I had to sign paperwork and I had to come to the school board's office and sit in a room. I couldn't get a copy of it because other kids were on the bus. So they didn't want to release this because it showed minors. I had to watch it there, and nobody was blurred out. It was HD TV. And after I left, but guess what? It wasn't broadcast to the public that everybody could go and watch this video. Like, that's very strange that just random people from the public were able to go watch a video that is used in a case. You usually do not see that. So I'm surprised that it lasted as long as it did and so many people were able to see it. But hey, look, if we get a new trial, maybe we can get the full video from ISD to be shown during that trial and we can really see what everyone else is talking about. It says, it's real. Common Sense says you should do an interview with the Not Guilty boys. Who are you referring to? Because I love interviewing people. So check out some past interviews we've done on the channel. They've been gotten really good reviews on it. And we interviewed Keith Adams, who is Young Thug's attorney, and Young Thug actually called in. I was seeing that pop up during the YSL trial. So that's another good one. Denise Walker, 9298 says, do you believe Karmelo should get a new trial in your professional opinion? My professional opinion is this. If the defense raised an objection to the judge's restriction to the public entering the court in time, and the court finds that the judge's amended order as we reviewed it, I do not believe that all of the Waller standards or the Presley standards are in that order. So if the court agrees with the defense and says that the 4 requirements of Waller and the requirement of Presley were not met in the judge's order, and the defense raised the objection in time, yes, I believe that Karmelo should be granted a new trial. Yep. So we shall see. Let's see. But like, we're going to come back now, and I have a right to change my opinion, right? So if the state comes back in their motion and they bring some case law that we didn't consider in our arguments today that says otherwise, then my opinion could change. But as it stands today, reading a biased motion, because it's just a defense, but looking at the law, because I pulled the law out, I showed you all PowerPoints, what was required, and I looked at the order, and I said to ourselves, do you see what the law is asking to be put in this order? And I don't. And so therefore, I think this is a strong argument for a motion for new trial. But guess what? The court has to rule on it. They got 75 days. If they don't want to rule on it, they don't have to. And it go up to the appeals court, and we'll be waiting on them to make a decision. So this is very exciting. I love the law. And so legally speaking with Fit, we'll be back when the state files their motion so that we can see what happened. Thank you all so much. And I think I've covered all of their super chats. Thank you all so much for tuning in. We had like 300 some people in the chat at one time. We have been on for almost 6 hours. I cannot believe it. I need to go clock out because I've done a shift. Okay. Thank you all so much for tuning in. I am a 20-year criminal defense and personal injury attorney here in Atlanta, Georgia. I have my own practice. It's called the Adams Firm. If you're in the area and need us, look us up, give us a call. The firm's information is in the description of this live. I want to give a shout out to everyone who gave us a super chat during the show. Anthony Peterson, 5618. For Dredd gave us several super chats throughout the show. All News 110 gave super chats throughout the show. Ayana I5W gave a $20 super chat. She gave a $10 super chat. I even got All News 10 gave several super chats. We got Johnny Paul 685 with a $10 super chat. Thank you all so much for supporting the channel. All News again. We had Ed for Dread giving us more super chats, $10 there. Ayana gives another $10. I got $50 cash app from I can't remember the name. Oh, Prayer Changes 7154 gave a $10 super chat and a $50 cash app. Also got a $5 cash app from Aries One, who also sent a donation on the live, a question on the live. More super chats from Anthony C. Peterson 5618. Thank you so much for supporting this channel and this live. Marina, my vida, mi amor. I don't know. Lee's going to tell me if I got more of that right or not. Thank you so much for supporting the channel. Like you said, some of you all found me on Lee's channel and you followed me over here. So I greatly appreciate the support. Jay Witt was in the chat earlier. Kat Not Williams, other YouTubers who have amazing channels. Thank you all so much. Ayana from Oakland gave us a $10 super chat. I just appreciate you all so much for tuning in. Thank you so much for the support of the channel. This was I had an amazing time. This might be one of my longest lives. So thank you so much for staying tuned. This has not been legal advice. This has simply been me breaking down this motion for new trial by Karmelo Anthony, giving lay people insider to how lawyers think and how we write these motions and what the law says on the issues. So thank you so much for tuning in. Shout out to all the mods in the chat that kept everything straight. I didn't see any fights or anything. You know, I wore my fatigue today because I had to fight all week on Facebook, but I didn't see any of that in the chat today, mod. So thank you so much for helping us out. Thank you again for tuning in. We will be back when the state files their motion. All right. So we'll be back with another segment of Legally Speaking with Fit. But until then, I'll see you in court.